Puneet, start.
Dear respected seniors, friends, colleagues, delegates, and eminent tax professionals from across the country, a very good morning to you all. I, Puneet Kumar Singh, Secretary AIFTP Northern Zone, will be the MOC for the conference. On behalf of my entire team of Northern Zone, I welcome you all to Gyan Pravah, the virtual National Tax Conference 2020. Despite the dark clouds of COVID-19 hanging over us, we are able to bring to you a silver lining in the form of this virtual National Tax Conference. I expect that this virtual conference brings hope and positive energy to all. We are pleased to inform you that more than 3,750 participants from across the country have registered for the virtual conference and are watching the proceedings live on Zoom and YouTube. In a very short time, we have made all efforts in organizing this virtual tax conference and conducting it without any glitches. However, in the very beginning, on behalf of my entire team, I seek apologies for any technical glitches that may occur during the conference. The virtual dais for the inaugural session is ready. Present on the dais is National President AIFTP, Madam Nikita R. Badheka. I welcome you, ma'am. I also present on the dais is Deputy President AIFTP, Mr. M. Srinivas Rao. I welcome you, sir. Also present on the dais are Vice President AIFTP Northern Zone, Mr. Anil Kumar Srivastava, and Chairman AIFTP Northern Zone, Mr. Asim Zafar. I welcome you, sirs. Also present on the dais are the Conference Chairman, Mr. Sanjay Kumar, and Conference Secretary, Mr. Arvind Mishra. I welcome you, sirs. Friends, Secretary General AIFTP, Mr. Samir S. Jani, could not attend the conference as he is suffering from COVID. We wish him speedy recovery. Friends, it is a matter of immense joy and pride to start the session by welcoming the chief guest of this inaugural session, Honorable Mr. Justice Rajesh Bindal, Judge, Jammu and Kashmir High Court. Welcome, sir. I also welcome the guest of honor, Honorable Mr. Justice Ujjal Bhuiya, Judge, Bombay High Court. I also welcome the guest of honor, Honorable Dr. Justice Anita Suman, Judge, Madras High Court. I also welcome the guest of honor, Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court. I also welcome the guest of honor, Honorable Mr. Justice Piyush Agrawal, Judge, Allahabad High Court. I also welcome the guest of honor, Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court. I welcome everybody on the dais. Dear friends, all good endeavors start with a prayer to Almighty. Today, we invoke His blessings through Swasti Vachan to spread good energy, positivity, and hope. हमारे मध्य महर्षि भारद्वाज वेद विद्यालय प्रयागराज से प्राचार्य पंकज कुमार शर्मा जी उपस्थित हैं। मैं उनसे विनम्र निवेदन करता हूं कि अपने वरिष्ठ छात्रों के साथ वे इस कार्यक्रम का शुभारंभ स्वस्ति वाचन से करें। आचार्य जी।
ओम श्री गणेशाय नमः, श्री सरस्वत्यै नमः, श्री वेदपुरुषाय नमः। हरि ओम जज्जाग्रतो दूरमुदैति दैवन्तादु सुप्तस्यातथैवैः दूरङ्गमञ्ज्योतिखाञ्ज्योतिरेकं तन्मे मनः शिवसङ्कल्पमस्तु येन कर्माण्यपासो मीहिणो जजिये कृण्वन् दिव्येदाते कुधीराः यदा पूर्वं जक्षामन्ताः पुराजानान् तन्मे मानाः शिवासङ्कल्पमस्तु जप्रजियानामुता चेदोधेतिश्च जजियोतिरन्तारावृतं प्राजासु जस्मान्न हरेते किञ्चन कर्म क्रियते तन्मे मानः शिवसङ्कल्पमस्तु जेनेदं भूतं भुवनं भाविष्यत्पारिगेहि तामामृतेन सर्वं येन जजियस्तायते सप्ताहोदा तन्मे मानः शिवसङ्कल्पमस्तु यस्मिन् रेचाः सामजायुग्मुखी यस्मिन् प्रतिष्ठिता रथना भाविवाराः यस्मिंश्चित्तग्नो सर्वमोदं राजानां तन्मे मानः शिवसङ्कल्पमस्तु सुधाराभिरक्षामि वाजन्मानुखियान्नेनीयातेभिः शोभिर्वाजेन एव ऋक्प्रतिष्ठं जादाजिरं जाविष्ठं तन्मे मानः शिवसङ्कल्पमस्तु हरिः ॐ।
धन्यवाद प्राचार्य जी. I now request the conference chairman, Mr. Sanjay Kumar, to give his inaugural address. Mr. Sanjay ji, please.
आज का दिन पवित्र एवं प्रेरक है. राष्ट्रपिता महात्मा गांधी जी एवं पूर्व प्रधानमंत्री श्री लाल बहादुर शास्त्री जी को नमन. आप सबको भी मेरा नमस्कार देवियों तथा सज्जनों. Good morning, ladies and gentlemen. It gives me an immeasurable pleasure of great privilege and also infuses a sense of pride in me to welcome each one of you to this National Tax Conference 2020 on the virtual mode. The Northern Zone of AIFTP is organizing this conference, Gyan Pravah, in association with 5 state bar associations, Uttar Pradesh Tax Bar Association, Uttarakhand, Jammu and Himachal Tax Bar Association, and Punjab Tax Bar Association. When the executive committee of the North Zone assigned me this responsibility of leading the team to organize this conference, I was a little shaky, a little scared. Dar tha, bhay tha thoda sa. We had organized so many of events for the zone, but it was a different ball game totally. How to start the planning and execution to have a flawless and a successful event was in the mind. Being a legal professional, it was a challenge to organize this virtual conference when more than 3,000 persons were expected to be connected with the use of technology. The theme of the conference, as you are aware of, and you can see on the brochure, is challenges for tax professionals post-COVID-19. I admit it was a challenge for all of us because we have not taken any help of any event organizer. It is the support and guidance of members of the Federation which has made this possible. We have 6 honorable judges of various high courts as guests who are presently holding honorable positions in Jammu and Kashmir, Madras, Allahabad, and Guwahati and Bombay high courts. We shall always remember this event when knowledge flows from all corners of the country to this Sangam, a confluence of professionals. My sincere gratitude and welcome to Honorable Mr. Justice Rajesh Bindal ji, Senior Judge, Jammu and Kashmir High Court, who accepted our invitation and is the chief guest of today's program. He has been a very active member of the Federation and has been organized several programs in Chandigarh, including a NTC in 2005, where I was attendee. Welcome you, sir. I welcome Mr. Justice Ujjal Bhuiyan, Judge, Bombay High Court. He's a very simple human being, and in the Mumbai Convention last year, he administered oath to the present National President of the Federation. Welcome you, sir. My greetings to Honorable Dr. Justice Anita Suman, Judge, Madras High Court. As a member and South Zone Chairperson of the Federation, her contributions are always remembered. Welcome you, ma'am. Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court, is amongst us. My sincere gratitude and warm welcome to you, sir. I welcome Honorable Mr. Justice Piyush Agarwal, Judge, Allahabad High Court. Has always been very supportive, and together we have organized several conferences in Prayagraj. He was elevated on 22nd of November 2018. Until 18th of November, he was supporting me to organize a conference on 24th and 25th November 2018, which was attended by more than 700 delegates, and Honorable Justice Ashok Bhushanji, Honorable Justice Vineet Saranji, and Honorable Justice Krish Murariji from the Apex Court, and Honorable Justice Govind Mathurji, the Chief Justice of Allahabad High Court, was gracing the inaugural dais. I welcome Honorable Justice Piyush Agarwalji. Honorable Mr. Justice Soumitra Sekia, Judge, Guwahati High Court, is amongst us. Grateful to you, sir, for accepting our invitation and your presence. Welcome you, sir. The National President, Mrs. Nikita Badeka, the Secretary General, Mr. Sabir S. Jani, is down with COVID. We wish him a speedy recovery, and I welcome Mrs. Nikita Badeka. The Deputy President, Mr. M.S. Rao, the VP from North Zone, Mr. A.K. Srivastava on the dais. I welcome you all. I can see immediate past President Dr. Ashok Saraf logged in. I welcome you, sir. I welcome all the past presidents, all the office bearers of the Federation, NEC members, delegates, and all the students who are also logged in here. We have excellent speakers on the subjects chosen for deliberation. I am grateful to them. My sincere thanks to all the chairmen, chairperson, and speakers and panelists of various sessions who are logged in from all across the country. In this conference, we have tried to few things a little differently. Inviting our own family members as chief guests and guest of honors, I would share with the audience, I invited the honorable judges with the intention that the members should know what is the contribution to the judiciary by the Federation. Their presence shall motivate the members of the Federation. Further, having guests from our own family makes you a little relaxed. And if there are any glitches and mistakes, we would escape and be excused by tendering an apology. Apart from our educative technical sessions, we have tried to connect with our super seniors and legends of the Federation who have been far away and due to old age or medical reasons have been disconnected with us for a few years. The last session tomorrow, we shall have many super seniors on the screen to give us our blessings. Instead of fellowships and lunches, we have sponsored meals for 6,000 persons today and tomorrow for homeless, laborers, destitutes, and needy with the help of an NGO in Varanasi, which carries this work in the name of Roti Bank. Today, we have a release of book by Dr. K. Shivram in the memory of late Honorable Justice B.P. Saraf. A souvenir has also been compiled by the untiring efforts of the Vice President, Mr. A.K. Srivastava and Mr. O.P. Shukla, which is being released today. Before I leave, I would extend my gratitude to the Zone Chairman, Mr. Asim Zafar, the young and dynamic Zone Secretary, Mr. Puneet Kumar Singh, who is also the MOC for this event. I am grateful to all the executive members and all the associated associations who reposed faith in me and trusted me with this responsibility. I am grateful to the convener, Mr. Arvind Shukla, Mr. D.K. Gandhi and Mr. O.P. Shukla, my co-chairman, and the conference secretary, Mr. Arvind Mishra, who worked day and night to make this event a grand one. I am grateful to Mr. Pankaj Sharma, Pracharya from Ved Vidyalaya, Prayagraj, for his initial prayers. Initially, as I said, I collected support from all corners of the country, breaking the barriers of the zone. This techno-legal event was only possible due to keen participation, inputs, and technological support of various members, namely Mr. Vijay Keval Ramani and his team from Thane, Mr. Vivek Agarwal from Kolkata, Mr. Pankaj Ghia from Jaipur. and our CEO of the Federation, Mr. Ravi Patade, who has been a great help to us. The team has worked very hard, but still there may be some glitches and mistakes for which, with folded hands, I tender apology for being excused. Once again, I welcome all the dignitaries and delegates to this inaugural session and wish that you have a wonderful learning experience. Thank you. Over to Puneet. Thank you so much.
Thank you, sir. I now request our dynamic zone chairman, AIFTP Northern Zone, Mr. Asim Zafar, to give his welcome address. Mr. Jafarji, please.
थैंक यू मिस्टर पुनीत। गांधी जयंती की शुभकामनाओं के साथ ऑनरेबल चीफ गेस्ट मिस्टर जस्टिस राजेश बिंदल, जज जम्मू एंड कश्मीर हाई कोर्ट, आवर गेस्ट ऑफ ऑनर ऑनरेबल मिस्टर जस्टिस उज्जवल भुइया, डॉक्टर जस्टिस अनीता सुमंत, मिस्टर जस्टिस कल्याण राय सुराना, मिस्टर जस्टिस पीयूष अग्रवाल, मिस्टर जस्टिस सौमित्र साकिया, आवर नेशनल प्रेसिडेंट रेस्पेक्टेड मैडम निकिता वडेका, Deputy President Mr. M.S. Rao, Vice President North Zone Mr. A.K. Srivastava, Conference Chairman Mr. Sanjay Kumar, our seniors in profession, ladies and gentlemen. Good morning to all of you. As the Chairman of All India Federation of Tax Practitioners Northern Zone, it is my proud privilege to be the host of this virtual National Tax Conference 2020. And I welcome you all from the core of my heart to gain knowledge from the best speakers of the country who are going to deliberate on various topics in this conference. In the time of adversity, with the threat of coronavirus, physical meetings are not feasible, but the pursuit of knowledge should continue. And so we have named this conference as Gyan Pravah, signifying that come what may, our constant endeavor for enriching our professional knowledge should continue. I am happy to inform that till now we have registration of over 3,750 delegates, not only from the length and breadth of the country, but also from abroad, who are witnessing this program through Zoom and YouTube. I welcome all the delegates. I would be failing in my duty if I do not mention our gratitude for the eminent dignitaries enlightening the glory of virtual dais in this conference. Before I conclude, I am very grateful to Mr. Sanjay Kumar, Conference Chairman, and the Conference Committee for organizing the conference in a very short span of time. I would like to thank our young and dynamic Zonal Secretary, Mr. Puneet Kumar Singh, and the Conference Secretary, Mr. Arvind Kumar Mishra, to make this conference a grand success. My sincere thanks to all participants, chairmen of all the zones, members of technical support team, Anil Kumar Singh Advocate Memorial Charitable Trust, and Tax Sutra for their support in the conference. Thank you very much. Jai Hind. Over to Puneet.
Thank you, sir. I now request our Vice President, AIFTP Northern Zone, Mr. A.K. Srivastava, to give his address. Mr. Srivastava ji, please.
Good morning, Honorable Mr. Justice Rajesh Bindal ji, Mr. Justice Ujjwal Bhuiyan, Mrs. Justice Anita Sumant, Justice Kalyan Surana, Justice Piyush Agarwal, Justice Soumitra Saikia. Good morning, along with Honorable President AIFTP Mrs. Nikita Badeka, past presidents, esteemed speakers, delegates, young professionals, ladies and gentlemen. It gives me great pride and privilege to welcome you all to this two-day virtual NTC being organized by the North Zone AIFTP. In AIFTP, it has been a ritual to hold a NTC in every quarter. In the year 2020, on account of COVID-19 pandemic, holding NTC had a setback. It is said that every adverse situation creates a new challenge. COVID-19 has given us a new opportunity to hold the NTC on virtual platform. The new experience, I am sure, shall be thrilling and educative. All of us are eagerly awaiting to hear our chief guest and the guest of honor in this inaugural session. I would not like to take much of your time and welcome you all to this virtual NTC. Enjoy the deliberations at the virtual NTC and welcome again. And thanks to all who have spared their time in organizing this program and making it a success. Thank you.
Thank you, Srivastava sir. I now request the Deputy President AIFTP, Mr. M. Srinivas Rao, to give his address. Rao sir, please.
Thank you very much, Mr. Punit, Secretary of Northern Zone. First of all, I would like to give pranams to seniors of our past presidents. Then I move to Nikita Badeka, the national president, and all the team members of the South Zone, judges who are joined over here for the guest of honor and chief guests for this today's function. I'm very thankful to the organizers to giving me this opportunity. First of all, the North Zone, whenever in the leadership of the members conducting the programs in virtual or physical, it will be very useful to the each and every delegate and participants. I welcome all my colleagues of the FTP all over the country. I give the Jan Prabha, who has taken for this virtual national tax conference, is very proper and appropriate. The challenges for the tax professionals post COVID-19, the theme of the conference is also very excellent and good. And the North Zone joining associations, I once again thank the giant organizations who are there in all the states of the Northern Zone. I will wish the program will success in a grand success. More than 3,750 participants along with abroad and with YouTube and Zoom. I thank you one and all. Welcome and I wish. Thank you.
Thank you, Rao sir. I now request the National President, All India Federation of Tax Practitioners, Madam Nikita R. Badeka, to give her presidential address. Nikita, Madam, please.
Good morning. A very warm welcome to all of you. My Lord, Shri Justice Rajesh Bindalji, my Lord, Shri Justice Ujjwal Bhuyanji, Ladyship Srimati Anita Sumanji, my Lord Justice Kalyan Rai Saumitraji, my Lord Shri Justice Piyush Agarwalji, and my Lord Shri Justice Kalyan Rai, I'm sorry, Saumitraji. I made a mistake, sorry, in the hierarchy. I'm very sorry. Chairman of the North Zone, Asim Jafarji, Sanjay Kumarji, the master behind the session, all his team, my past presidents, all are present today. I'm very much glad to hear them also. A very warm welcome to all the delegates to this House of Thought. As rightly said, every adversity carries with it the seeds of opportunity. AIFTP has taken the task of turning this adversity into opportunity, of acknowledging and giving knowledge to all the members throughout India. By now, we have held around 102 webinars, and we have been able to reach out to each and every corner of India. This is the second virtual National Tax Conference. The first one was on 12th and 13th of September, and the third one is following. And every National Tax Conference is going a step forward than the earlier one. I'm really glad. The challenges is taken by all the zones. All the zones have functioned so well. For my lords who are new to the Federation, this Federation is having around 8,000 plus members, and they are chartered accountants, advocates, and tax practitioners. And our endeavor is always to spread the knowledge through our journal, through our lectures, conferences, seminars, and now, of course, webinar. As it now turns, I think the next year, for at least 6 months now onwards, we will be seeing everybody virtually only. And that's really good because we would be able to meet a lot of people. Now, today is a very special day. Apart from being a Gandhi Jayanti, my homage to Mahatma Gandhiji and Lal Bahadur Shastriji has rightly said, it's a golden moment for us. A dream coming true. Why? because we have our James of Association. There are 6 judges. I'm really glad they have been part of us. They have been our family. And now they are adorning the benches throughout India. And look at the way they have come up. I mean, without any exception, like all the judges are good. But we are really proud because it is our members. It is like somebody from my family being a judge. And this is the proud moment for us, as it gives me an opportunity. Thanks to the webinar, I could have them all at one platform. Thank you very much, all the judges, for being here with us at this golden moment. One of the other good part of this webinar would be release of 151 landmark judgment book. Now, this is the book which is prepared for celebrating the 150 years completion of Mahatma Gandhi ji. People have known Mahatma Gandhi ji as a social worker, but Advocate M.K. Gandhi, the barrister M.K. Gandhi, is not known to many people. And this is why we decided that if as an advocate, and if you would see his books available on the website, it is said that it is his knowledge as an advocate which helped him in his future services to the nation at large. And it is for this reason we decided as a federation to celebrate his 150 years Janmatithi, his birth anniversary, as by preparing a book. And thanks to Dr. Shivram, our past president and senior advocate, he does all the job, of course, with his very vibrant team. Thank you very much to all of you. I'm looking forward to this Gyan Pravaha because, as the theme suggests, the technical session would be enlightening the delegates with vital and critical issues of GST and also the direct and other indirect taxes. Friends, the persons, because I'm told there are 3,000 plus members registered for this. The members who are not registered for this program, my request is they may be registered for this program, but not my member. My request is please become member of our federation. You see the way federation is now grown up. It was a small baby, now it is not. It is a grown up, it is an adult, full adult person of 44 years. So we have grown up and we are still growing up. And therefore, it would be good decision if those who are not member to join us as our member. Thank you very much, all of you. Congratulations to the North Zone, Asim Jafarji, Conference Chairman, Mishra ji, and all other persons behind the screen. Thank you very much.
Thank you, madam. Thank you, madam, for a motivational speech. I request the North Zone Managing Committee member, Madam Pooja Talwar, to introduce guest of honor, Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court. Pooja, madam, please.
Thank you, Mr. Puneet. It's my pleasure to introduce Honorable Mr. Justice Soumitra Saikia ji. He was born on 18th April 1965. Honorable Mr. Justice Soumitra Saikia ji, son of Shri Purnachandra Saikia, retired district and session judge. Honorable Mr. Justice Soumitra Saikia ji completed his school at Guwahati and thereafter completed his education at Nagaon. Honorable Mr. Justice Soumitra Saikia ji joined Assam Judicial Service in the year 1992. Worked as a district and session judge since September 2011. In between, he had also held the position of Member Secretary, Assam State Legal Service Authority. Honorable Mr. Justice Soumitra Saikia ji elevated as additional judge of Guwahati High Court on 26 November 2019. High Court on 26 November 2019. I humbly request Mr. Justice Soumitra Saikia ji to please bless the ego audience.
I request Honorable Justice Soumitra Saikia ji to give his address. Sir, please.
Namaskar. Good morning, everyone. Perhaps because of this online conference, and perhaps because in similarity of names, I'd just like to point out that Madam Talwar has probably read out the biodata of my colleague, Mr. T.J. Soikia. He's also a justice, he's also a Saikia. Madam, please don't look alarmed, it's perfectly all right. It happens, not a problem at all. I am Justice Soumitra Saikia. I was born and brought up in Guwahati, educated in a school in Guwahati. My father, late Nagendranath Saikia, was a senior advocate, and he was also Advocate General for Nagaland and Arunachal, about twice for each state. And I joined practice in the year 1995 in Guwahati High Court, and continue to do so. And I was guided, and I've had the privilege of working with esteemed seniors and erudite lawyers like Dr. Saraf. Justice Bhuya was also there, as he then was at the bar, Justice Surana, and many others. And I was elevated to the bench on 26th of November 2019. So in terms of judiciary, as compared to all the other erudite judges and seniors, I'm still a baby. I have a long way to go. I have a lot to learn. And if I make any mistake, please feel free to correct me. And Madam, once again, Madam Talwar, I think that's perfectly all right, because the website lists both the psychiatrists together, because he and I were elevated on the same day. So it's quite possible. Anyway, so Madam Nikita Badekar, President, All India Federation of Tax Practitioners. Dr. Ashok Saraf, Senior Advocate, Immediate Past President. Mr. Sanjay Kumar, Advocate, the Conference Chairman. Honorable Mr. Justice Rajesh Bindal, Judge, Jammu and Kashmir High Court, the Chief Guest of the conference today. Honorable Mr. Justice Ujjal Bhuya, Judge, Bombay High Court. Honorable Madam Justice Dr. Anita Suman, Judge, Madras High Court. Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court. Honorable Mr. Justice Piyush Agarwal, Judge, Allahabad High Court. Mr. M. Srinivasa Rao, Deputy President of the Federation. Mr. Samir S. Jani, Secretary General, AIFTP, who I'm told is not in the conference today because of medical issues. I wish him early recovery, Godspeed. Mr. Anil Srivastav, Vice President, North Zone of the Federation. Mr. Asim Zafar, Zone Chairman, North Zone, AIFTP. Dignitaries present in the virtual platform, respected members, respected senior advocates, learned chartered accountants, tax professionals, ladies and gentlemen, a very good morning to all of you from Guwahati. I am indeed honored and very humbled to be a part of this inaugural function of this virtual tax conference with the theme, Challenges for Tax Professionals Post-COVID-19, which is organized by the All India Federation of Tax Practitioners, North Zone, in association with the Tax Bar Associations of the states of Uttar Pradesh, Jammu, Punjab, Uttarakhand, and Himachal Pradesh. The All India Federation of Tax Practitioners, more popularly known as AIFTP, was formed in 1976, November, with Sri N.C. Mehta as the founder president. It is the apex body of tax professionals of India, comprising of advocates, chartered accountants, and other practicing tax professionals. Since its inception, the Federation had continued to immensely contribute towards imparting and disseminating knowledge and information in the realm of taxation, both direct and indirect. I'm informed that presently the Federation has more than 8,000 members, individual life members, including eminent counsels, senior advocates, jurists, chartered accountants across the country, and it has affiliations of more than 125 associations. Its members over the years enjoy a strong bond of fellowship exchanged through various conferences and study circles. The AIFTP over the years, as Madam President had said, has grown from a baby to an adult organization. And one of the most important contribution is the journal of AIFTP. This is a journal which covers the latest judgments of the various high courts, Supreme Courts, tax tribunals, includes articles, opinions, latest developments in the field of taxation, both direct and indirect. The the notification also contains circulars, the other topical information. Apart from that, the national seminars like this, which are being conducted by AFTP every year, in fact, more than once in a year, conventions, which are frequently organized by the Federation, are some of the most significant events organized by the Federation, which are helping the members and other practicing tax personnel to keep abreast with all the latest developments, not only to taxation, but with all the relevant fields of law, accountancy, and the financial norms. Some other notable contributions are I understand, are the Nani Palkiwala National Moot Court competition, which was initiated sometime in the year 2004. The other are the Dr. Justice B.P. Saraf Memorial National Moot Court competition, which is considered to be one of the most prestigious moot court competitions amongst the law schools and colleges in India. Besides that, there are several study tours which are organized by the Federation, both domestic and international, which also facilitate the exchange of various ideas amongst the members, as well as the legal and tax fraternity in general. In this conference, which is organized from today, I find the topics are very relevant in today's context. The first session, the first technical session, the subject matter is charitable trusts, educational institutions, hospitals, and discretionary trusts under the IT Act. While the second technical session relates to all about show cause notices, adjudications, assessment, appeals, and GST, under GST. For the second day, in the third technical session, the topic is restrictions on cash transactions and new penalties regime. While the fourth technical session is the subject matter, which will be the subject matter of discussion on the second day, would be GST implication on healthcare, education sector, charitable institutions, and CSR related activities. As most of the members and dignitaries are aware, that law is a constantly changing topic in various subjects, but more particularly in finance and taxation related, this perhaps is one of the fastest evolving subjects in the context of law, both academia as well as law practice. So the subjects which have been taken for this two-day national virtual tax conference are of utmost importance, keeping in context the present scenario. I have been given to understand that at present, perhaps more than 3,500 participants have already registered. And this only goes to show the massive popularity and the importance in respect of the subject matters which are raised, which are taken up in this conference. I would also like to congratulate the Federation in its commendable efforts in bringing out a publication which is a commemorative edition on the occasion of these virtual national tax conferences. The compendium of 151 landmark judgments of the Supreme Court, rendered in direct tax, indirect tax, and other allied laws, is but a befitting tribute on the occasion of 151 years of the father of the nation, Mahatma Gandhi, and also on the birth anniversary of Lal Bahadur Shastri, a former Prime Minister of India. I sincerely believe that this compilation of judgments brought out by the editorial team of the Federation will be of immense help to the members of the association, the students pursuing law, as well as members of the academia. I also understand that a book on Justice Dr. B.P. Saraf is to be released today in the inaugural session. I would just like to reflect upon the life and life of late Dr. B.P. Saraf from a personal point of view, as I had known him for several years, several decades rather, even before I started my practice as an advocate. I am deeply privileged to be a part of this program for releasing the book on the life of late Dr. Justice B.P. Saraf. I fondly recollect and remember his words of wisdom, his deep appreciation and blessings showered upon me and my family. Justice Dr. B.P. Saraf was a person of golden heart and was well admired by all for his soft-spoken, kind-hearted, and altruist nature towards one and all. Justice Dr. B.P. Saraf was a scholar and had a brilliant academic career all through. He stood first in BCom as well as the MCom examinations of the Guwahati University, secured first position in the LLB examination. For his academic achievements, he was awarded accolades by the universities and other educational and social organizations. His consistent yearning for knowledge led him to embark on an extensive research in the realm of taxation. He earned his PhD for his dissertation, Capital Taxation in India. Justice Dr. B.P. Saraf was an extremely committed person to social causes and was involved in a large number of philanthropic and social organizations. He was deeply involved with the Red Cross Society and the Red Cross movement till his elevation to the bench. He was a judge of the Guwahati High Court and subsequently a judge of the Bombay High Court. He served as the Chief Justice acting of the Bombay High Court and was finally appointed as the Chief Justice of Jammu and Kashmir High Court. Dr. B.P. Saraf, Justice Dr. B.P. Saraf led an enviable life which had a meaning and a purpose. He was truly a man of substance, but was yet very humble. He lived his life in a manner, as I believe Gandhiji had quoted, live as if you are to die tomorrow. Learn as if you are to live forever. This, according to me, in my personal view, is one of the most important quotes which I'm always inspired when I think about Gandhiji. Ladies and gentlemen, I conclude thanking the organizers of this virtual National Tax Conference for giving me this opportunity to be a part of the conference. I wish the organizers a grand success for this conference. And last but not least, my gratitude and gratefulness to Dr. Ashok Saraf, Senior Advocate, who first introduced me to this august federation and for the opportunities to bond with the federation as a life member of the federation till I was elevated. Thank you. Thank you all.
Thank you, sir. Your humility is inspiring for us, sir. Even though you have forgiven us, on behalf of the conference committee, I apologize for the mistake in introduction.
Not at all.
Thank you, sir, again for inspiring us.
Introductions are always available in the website. You can go and have a look. There's hardly anything to be introduced other than the fact that I was a life member of this august federation. And I believe I will be continued to be inspired by the developments and the discussions which take place on conferences like these. Thank you all. Thank you so much.
Thank you, sir, once again for inspiring us. I now request the conference secretary, Mr. Arvind Mishra, to introduce guest of honor, Honorable Mr. Justice Piyush Agrawal, Judge, Allahabad High Court. Mr. Mishra, please.
Thank you, Puranji, for giving me this opportunity. I would like to wish very good morning to all of you. Welcome, ladies and gentlemen. It's my pleasure to introduce Honorable Mr. Justice Piyush Agrawal ji. Mr. Piyush Agrawal, Justice Piyush Agrawal ji, born on 6 November 1971, and he was graduated in law from APS University, Rewa, 1993, and got enrolled as an advocate on 28th August 1993 in Bar Council of Uttar Pradesh. He has practiced mainly in civil side, handled matter related to consumption, taxation, company, and allied branches of law at both of the branches of Allahabad High Court. He worked as standing counsel for several companies and corporations, and also worked as additional chief standing counsel for state of Uttar Pradesh in 2014. He was also senior standing counsel, Income Tax Department, Government of India from 2016 till his elevation, and was also senior standing counsel, CGST, Excise and Custom Department, Government of India from 2017 till elevation. Honorable Mr. Justice Piyush Agrawal elevated as additional judge on November 2020, 2018. I request Mr. Justice Piyush Agrawal ji, please bless the eager audience.
Thank you, Mishra ji,
Sir.
for introducing me. In the family which I belong to, good morning, all of you. The dignitaries on the virtual dais. I'm very happy to be in the beginning of this October gathering on the virtual platform, for it gives me an opportunity to update my knowledge on my favorite subject, tax. In short while, we are going to deliberate on the theme Challenges for the Tax Profession Post-COVID, touching on the topics including GST and income tax. With economic wring from the coronavirus pandemic, we all find ourselves in an unprecedented position to help create a new norm for both ourselves and those around us. Everyone together needs to share how we are seeing the experienced member around us respond to this challenging time. What guidance are we providing to each other, and the impact this crisis will have on the tax profession now and in the future. India has put in place strict restrictions to combat coronavirus. Since March, it has taken extraordinary measures to contain the spread of COVID-19. It has had a several impact on the economic activity, small business and medium business supply chain, even the tax practitioners. To minimize some of the adverse effect to lockdown and other restriction measures by the government, including need compliances and regulatory changes which help the companies to survive the economic shock. But even after that, it is a challenge to the field to feel and figure out the game plan going forward. A way to combat this by recognizing the unknown and letting go of the expectation that we need to have all the answers immediately. I would be bold to assume the far future to determine when this pandemic would end together, but it is predictable that the reality, that the time people will come accustomed to the situation and more things will come in order, keeping the current scenario in mind. In the matters of tax practitioner, the one way to handle the near future and survive this is to remain as updated as possible with the upcoming changes and the deadlines. Once in a few months, there will be possible changes and all of us will have to incorporate them in our daily lives. The major change that can be expected post-COVID is a major revolution in a technology know-how. people would have to come accustomed to the everything being done electronically. And every one of us will have to cope with that. There will be obvious advantages and disadvantages with that too. But we will all have to face it. Apart from the major lives lost in this pandemic, it is the economy of the country which has taken a huge toll, which is a great concern right now and which will remain focused post-COVID as well. Everybody present here today is also somewhere affected by it too. If we look at the manufacturing sector and the industrial sector, the growth essentially comes from the uptick of the spending, which is not happening. The public need to have confidence that they can spend the money and they will be able to earn it back. Similarly, the industry need to put in money. If they put in the money in the new projects and the working capital, they are not going to settle with the inventories and more loans. Banks have already had a principal component analysis problem. They are naturally trained a caution about the choosing the person to whom they are willing to give money. Still, a lot of banks are under PCA, and even though they have money, they are not in a position to lend it. All these things need to be addressed. Litigation strategy shall be revised due to restricted functioning by the court cross-country. At the best time, our judicial system was plagued with the delays. The backlog of cases in the courts are nearly in lakhs. In and around third week of March, the Supreme Court as well as high courts in several states notified that they will be taking only urgent matters. The litigants have to explain and justify the urgency. There is no end date of the said notifications. However, on 23rd March, the Supreme Court of India has issued an order stating that the period of limitation for all court proceedings shall be extended. Whenever the High Courts opened its door, about 5,000 to 8,000 new filing may reasonably be expected. Thereby, it is expected that the pendency of litigation in India is going to further increase in coming months. Therefore, it is advisable for the tax practitioners to revise their litigation strategy and analyze the impact of the delay in disputing resolution. There is hope for the courts to improve its judicial delivery system by making optimum use of available technology by permitting e-filing and video conferencing in all and not only urgent cases. In Allahabad, we are doing fiscal hearing with our 30 to 40% of the strength. The new guidelines of the Ministry of Home Affairs keep on showing the intention of the government to slowly lift the lockdown. However, at the same time, the health and the safety remains the first priority. The business continues to keep up themselves prepared to adapt with any legal or regulatory change introduced by the government. In the line of other countries, the Indian government has announced a large fiscal stimulated package to address the concern of the economy. It would be prudent for the tax professional to quickly analyze the obligation and determine their position so as to advise their client accordingly to avoid non-performance of force majeure clauses. COVID-19 threat also exposes business to various tax law related challenges which can vary as per the nature of business and operation of the company. It is advised to revise contract and policy to ascertain whether they are properly worded to address challenges posed for this unusual situation. In addition, constant changing government regulation must be taken into account. Local notifications are regularly issued on short notices, which must be observed by the professional. It is therefore inevitable that every practitioner keep up to date and think about necessary measures in advance so that the company can respond quickly on the new solutions. We have series of speakers and sessions after me who will be deliberating on the various facets of the tax laws and principle. I like that I am also eagerly waiting to hear them speak. And before my own address become taxing for the audience, I must thank the organizer for giving me an opportunity to share my thoughts on this virtual platform. Thank you very much. Jai Hind.
Thank you, sir. Sir, your addresses will never be taxing for us. I would like to thank you for your constant support. Your guidance is very valuable to us, and your presence keeps us motivated. Thank you again, sir.
Thank you, Puneet.
I now request the Treasurer AIFTP Northern Zone, Madam Shilpi Satyapriya Satyam, to introduce guest of honor, Honorable Mr. Justice Kalyan Rai Surana, Judge Guwahati High Court. Shilpi, Madam, please.
Good morning, ladies and gentlemen. I am pleased to introduce Justice Kalyan Rai Surana ji. Honorable Mr. Justice Kalyan Rai Surana is a judge in the Guwahati High Court. He was born on 13 December 1965 and did his majors in management, accountancy, and taxation in 1988. He obtained his LLB degree in 1991 and was enrolled as an advocate on 14th of August 1992. He has practiced in various fields of law in the Guwahati High Court and subordinate courts, and has also appeared before various courts, tribunals in Kolkata and New Delhi. Honorable Mr. Justice Kalyan Rai Surana was appointed as an additional judge of Guwahati High Court on 15 November 2016, and he became a permanent judge with effect from 12th of November 2018. I would now humbly request Honorable Mr. Justice Kalyan Rai Surana to kindly address the August gathering.
A very good morning to all of you. At the outset, I begin with thanking the organizing committee to have invited me in this August gathering. Special mention is made to Mr. Sanjay Kumar, the conference chairman. In an August gathering where, except for me, all the other speakers, namely Honorable Mr. Justice Rajesh Bindal ji, Honorable Mr. Justice Brother Ujjwal Bhuiyan, Honorable Dr. Justice Mrs. Anita Sumant, Honorable Mr. Justice Piyush Agarwal, and Honorable Mr. Justice Brother Soumitra Saikia are erudite and thus enlightened. And if I am permitted to say so, they are authorities on their own right. Moreover, in this conference, those who are attending are themselves expert and highly successful in their own respective fields. Placed with such a learned house full of luminaries, I recall a very old advice that I had received, which is, in a conference of learned men and women, I can maintain a facade to appear learned till such time I open my mouth. In other words, the more I speak, the more I risk an eminent exposure. The theme on which this conference is being held is about challenges to the tax professionals post-COVID-19. I have noticed that due to the pandemic, various statutory timelines to fill and file up returns, to have audit completed, to upload requisite information, payment of tax, etc., have been extended from time to time. And in a few months' time, all these extended timelines would come to an end. It is also seen that various taxing statutes provide for imposition of cost, fines, interest on delayed payment of taxes. All these would have a telling and taxing effect on the tax professionals to complete their assigned task within the timelines fixed. Gone are the good old days when one tax practitioner could have worked in a relaxed manner. Now he has to be tech savvy by not only knowing how to operate computers and other electronic gadgets and devices, but he must also know how to operate on various official portals and programs. Filling up of various forms in e-portals appear to be a very tedious task, which needs a lot of patience. Error-free filling up of the e-forms is a challenge. I also find that an SSE, who we can call as an average common man, is also dependent on the tax professionals to pay tax for him through the e-mode and then get reimbursed. As such, the tax professional would also need to know how to operate on these payment portals. It is seen that to meet certain specific requirements, the tax professionals have started large partnership firms and LLPs. Managing these large-scale operations is itself a challenge for a tax professional in this COVID-19 situation. The COVID-19 pandemic is likely to hamper physical audits, specifically for banks, factories, warehouses, etc., which are located in interior places or difficult to reach sites. I hope that this conference would definitely solve all these issues in course of your deliberations, which would be immensely beneficial to all your members. And in this respect, I wish this grand success. Considering myself to be a student of law, I take my seat to gain knowledge from the wisdom that would flow from my honorable brothers and sister and other learned speakers. I thank all of you to have invited me to this conference, and therefore I am obliged with the love and affection which you have showered on me. Thank you so much.
Thank you, sir, for your erudite words. I again request Madam Pooja Talwar to introduce the next guest of honor, Honorable Dr. Justice Anita Sumant, Judge, Madras High Court. Pooja, Madam, please.
She completed her BA in English Literature from Women's Christian College, Madras. Further, she did her Bachelor of Law from Government Law College, Madras, and subsequently her Master of Law in Constitutional and Public International Law, University of Madras. She went on to earn her PhD by the National Law School of India, University, Bangalore. She joined the chambers of senior advocate Shri V. Ramchandran upon enrollment and practiced extensively before the Supreme Court, High Courts, tribunals, and other appellate fora, as well as the Authority for Advanced Ruling, specializing in direct and indirect taxes and corporate laws. She held the position of Special Government Pleader, Taxes, Madras High Court before her elevation. In October of 2016, she was appointed a permanent judge of the Madras High Court. I request Honorable Dr. Justice Anita Sumanji to please bless the eager audience.
Respected judges on this virtual days, the plethora of dignitaries that we have, including the president and the office bearers of the All India Federation for the Tax Practitioners, delegates, very large number of delegates I see, members, ladies, gentlemen, and my dear friends. Namaskaram and good morning to all of you. The conference chairman, in the course of his address, said that this was in the nature of a family gathering. And I couldn't endorse that sentiment more than what he expressed it as. My association with the Federation has been from the late 80s, from the time my late senior was associated with the Federation. And it's been a pleasure and a privilege to be part of the Federation. And it is a pleasure and a privilege to be part of this gathering here today. Thank you very much for inviting me to be part of this meeting. The last 6 months, I think we will all agree, have been very unusual and rather disturbing. And society, all components of society have addressed the demands and challenges thrown up in our own ways. We have, perhaps those of us gathered here, have been able to, or at least tried to contribute what we could in terms of our efforts, our time, our resources. And each one of us have tried to hone our skills, perhaps, have tried to catch up on reading, have tried various measures to come to terms with the new challenges that are presented. In fact, one thing that struck me as being wonderful was when the conference chairman said that instead of the meal breaks that one normally has during conferences of this nature, you have, the Federation has in fact distributed breakfasts and lunches to destitute people and those in orphanages and in other centers. I think that's an amazing example of how to convert adversity into opportunity. Hats off, kudos to the Federation for this fantastic measure. And I think there would be great value in continuing measures like this. That's the silver lining perhaps one has in a pandemic, where these opportunities present themselves to us to be carried forward long after the pandemic itself, one hopes, has evaporated and gone. The conference itself, which is themed as how to address challenges for tax professionals post-COVID-19, has a star-studded galaxy of speakers who will be addressing us on the various topics. Though I see that the topics are not specifically aimed at addressing post-COVID challenges, I assume that the learned speakers and the experts who will be addressing us will also be talking about those facets of the topic post the epidemic and how to address those issues. My brothers who spoke before me also touched upon some of the technical challenges that this pandemic throws up. Now, I, for one, do not propose to therefore touch upon any of the technical challenges, because we do have experts who are going to be addressing us on those. What I thought I would share my thoughts on is something that all of us as stakeholders have been affected by or have been trying to grapple with over the last 6 to 8 months. And that is a new method or a mode of conducting judicial proceedings itself. Justice Surana, who spoke before me, did touch on it briefly when he said that the age of information technology has now become all the more important when it comes to addressing issues going forward. And he could not be more right. Though he was very humble in saying, in attributing erudition only to the rest of us, I would, speaking for myself, make it very clear that he was only being humble and nothing more. And he is perhaps, speaking for myself again, equally, if not more erudite than what I might be. Video conferencing is not a novel venture. We have been having video conferencing for several years. In fact, I recall more than 10, 12 years ago, the Madras High Court had started a pilot project where 3 courts were identified as being courts to test the efficiency of video conferencing. The tax bench headed by Justice Chitra Venkatraman at that point in time was one of the benches. And the members of the revenue bar, small bar that it is, had all stepped up to try and convert all the existing briefs into soft form and assist the bench in the conduct of these proceedings on a virtual platform. It was tested for about 6 months. It did not, unfortunately, gain ground, and therefore it stopped thereafter. But what I was coming to say is that video conference as a mode of conduct of judicial proceedings has been long been prevalent pan-India. And now what the pandemic has taught us is that it is a very, very able support to traditional methods of conducting judicial proceedings. I think several of the high courts in the country have already issued guidelines to deal with how to conduct virtual proceedings. Quite apart from etiquette itself, what are the official platforms to be accessed, how one accesses them, how one goes about the entire process. And that apart, this is where I come to the request that I wanted to put forth to the Federation. It's very important that we have the input of the bar on this aspect. I would urge the Federation to devote some time, effort, perhaps set up the requisite committee to examine the virtual mode of conduct of proceedings and to put together your heads and come out with a white paper on how best one could take forward virtual court as a concept. I think virtual courts are here to stay. Nobody can deny that. But at the same time, we would all agree that it can, at least at this juncture, only be a support to physical hearing and cannot substitute physical hearing. We have all, my colleague judges would agree, have had very interesting incidents and episodes when it comes to virtual hearing. We have had hearings conducted by learned counsels sitting in cars. In fact, we've had moving vehicles where in addition to making their submissions before the bench, sometimes they make comments to passerbys on the road, etc., without realizing the sanctity of the court proceedings. These are all various things that one would have to take into account when you look at virtual proceedings as a way forward in the future. Therefore, this is one thing that I would put forward to the Federation to explore and to assist the courts in making sure that virtual courts are as easy and as optimally used as possible. You will agree that virtual courts are a necessity insofar as they provide a level playing field to all learned counsels wherever they may be situated, not just in your district, in your city, in your state, or in your country. You may be situated anywhere in the world, but still conduct your case before a high court bench. There are any number of learned counsel professionals who are situated in remote corners who have been unable to access a high court hearing simply because of the difficulties presented by geography. Now geography has melted away, and you have a position where anybody sitting anywhere can make their presence felt before a high court bench. I think we should, as it has been said, seize the moment. This is one of the silver linings that the dark cloud of the pandemic has presented to us. I don't want to take much more of your time, and we are looking forward to the technical sessions that follow. I will end with a quote that appeared to me to be very apt. Strength, it has been said, does not come just from physical capacity. It comes from an indomitable will. And that will is what is called for each of us to express and to display. My best wishes for the conduct of a very successful, very purposeful conference. Again, it's a pleasure having been with all of you here today. Namaskar.
Thank you, Madam Justice. It is a matter of pride to have you as a part of our AIFTP family, Madam. Thank you for showing us the way forward. I also thank you for motivating us to do even more for the society. Thank you once again.
Thank you.
I now request Madam Shilpi Satyapriya Satyam to introduce the guest of honor, Honorable Mr. Justice Ujjal Bhuiyan, Judge, Bombay High Court. Shilpi Madam, please.
Thank you, Puniji. I feel delighted in introducing Honorable Mr. Justice Ujjal Bhuiyan. He was born on 2nd of August 1964 in Guwahati. His father, Mr. Sujendra Nath Bhuiyan, was a senior advocate and a former Advocate General of Assam. Justice Bhuiyan did his schooling from Don Bosco High School, Guwahati, and thereafter studied in Cotton College, Guwahati. After graduating in arts from Kirodimal College, Delhi, he obtained his LLB degree from Government Law College, Guwahati, and LLM degree from Guwahati University. He got enrolled with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh on 20th of March 1991. He has practiced before the principal seat of the Guwahati High Court at Guwahati and appeared before the Agartala, Shillong, Kohima, and Itanagar benches of the Guwahati High Court. He has also practiced before the Central Administrative Tribunal, Guwahati, and the Assam Board of Revenue. He has appeared before the Labour Court, Guwahati, and various civil courts and the State Consumer Forum, Arunachal Pradesh. He was the Standing Counsel of the Income Tax Department for long 16 years and has started as Junior Standing Counsel since May 1995 and was subsequently appointed as Senior Standing Counsel of the Income Tax Department on 3rd of December 2008. He was the Additional Government Advocate Meghalaya in the principal seat of Guwahati High Court from April 2002 to October 2006. He was engaged as a Special Counsel for the Forest Department, Government of Arunachal Pradesh from December 2005 to April 2009. Justice Bhuiyan was appointed as Standing Counsel of Guwahati High Court on 3rd of March 2010. He was designated as a senior advocate by the Guwahati High Court on 6th of September 2011. He was appointed as Additional Advocate General Assam on 21st July 2011. Justice Bhuiyan was a member of the Guwahati High Court Bar Association, Lawyers Association Guwahati, Bar Association of India, All India Federation of Tax Practitioners, and Indian Law Institute Assam chapter. He was appointed as Additional Judge of the Guwahati High Court on 17th of October 2011 and got confirmed on 20th of March 2013. He was also the Executive Chairman of Mizoram State Legal Services Authority. Justice Ujjal Bhuiyan was closely associated with the Judicial Academy Assam and National Law University Guwahati. He was transferred to Bombay High Court and was given favorable reference on 1st of October 2019. He took oath as Judge of the Bombay High Court on 3rd of October 2019. I would now kindly request Honorable Mr. Justice Ujjal Bhuiyan to kindly address the delegates.
Thank you for the bit longish introduction. Anyway, my esteemed brother, Justice Bindal from J&K High Court, Sister Dr. Justice Sumant from Madras High Court, Brother Justice Surana from Guwahati High Court, Justice Agarwal from Allahabad High Court, Justice Saikia from Guwahati High Court, President of All India Federation of Tax Practitioners, Nikita Badeka, past President Dr. Saraf, North Zone Chairman, Mr. Asim Jafar, Conference Chairman, Mr. Sanjay Kumar, senior members of Tax Federation, office bearers of all the tax bar associations, members of the Federation, members of the tax bar associations, the delegates, ladies and gentlemen. A very good morning to all of you. All my learned previous speakers have elaborately dealt with about the Federation, about the conference, and about various aspects dealing with the topic, the theme of the conference, which is challenges for tax professionals post-COVID-19. So I would not like to add on to what has already been said,
As Justice Sumant has rightly pointed out, this COVID-19 pandemic has adversely affected our lives. Not only our lives, it has affected everybody across the board. All sectors of the economy, schools, colleges, courts, everything has been affected. Income tax department has also been affected. So that's why this theme has been very aptly chosen. And I suppose all the topics that are lined up for discussion today and tomorrow will have this particular perspective in mind during the course of the deliberation. Well, from a practical standpoint, we were having the bench, the text bench. In Bombay, we are having virtual mode, but we are having the roster, regular roster as it is. One petition was filed. I can say about this because the matter has been disposed of. One petition was filed the other day. Petitioner saying that I had applied for a certificate of no tax deduction under 197 of the Income Tax Act sometime in February this year for the certificate corresponding to the assessment year 2021. And that was rejected by the income tax officer on the ground that the period has lapsed. 31st March, the period has lapsed. Then the board had issued an order under 119 extending the time limit till 27th of April and giving making it mandatory for the applicants to intimate the assessing officer about the fact that they had filed an application and about pendency of that application. And that having not been done, his application was rejected. So he came before us contending that during this pandemic, how could an additional burden be placed on the applicant to intimate the assessing officer about filing of an application and pendency of the application as on the date of that order. Order was issued on 3rd of April. We heard the matter. We found that the government of India, the president, in fact, had promulgated an ordinance on 31st of March, extending the time limit, the limitation period for all the specified acts, including the Income Tax Act, till 29th, till 30th of June 2020, or even beyond, to be notified by the central government. So in the presence of that ordinance, which has the same force as that of an act of parliament, the income tax authorities could not have unilaterally fixed or curtailed the benefit extended to the SSCs by that ordinance to 27th of April. That apart, when the application was pending, it simply could not have been, the additional burden could not have been placed on the applicant. During this pandemic, applicant said that I could not move out of the house to gather the additional information sought for by the assessing officer. So on that ground, we interfered with this and set aside the rejection order and had remanded the matter back to the assessing officer. You decide now on merit. You could not have rejected the application during this extraordinary situation, more so when the situation was taken care of by this ordinance promulgated by the president. So this was a small issue, but it typically highlighted the problems that are being faced by the SSCs and the tax practitioners. I think the departmental authorities will also have to be flexible. They must be pragmatic to what is the situation that is unfolding and not cast additional burden on the taxpayers and the applicants than otherwise required. So this is an issue which only highlights the difficulties that may be faced. Last week, I had attended or judged one a tax moot competition organized by the Chamber of Tax Consultants Mumbai in association with the Government Law College Mumbai. And the topic was regarding Chapter 10A of the Income Tax Act on general anti-avoidance rules introduced by this. And in the morning, I was searching for, besides the Income Tax Act, whether there was any other material. And I found one book published by the All India Federation of Tax Practitioners on general anti-avoidance rules, including containing several articles there, and it was very, very illuminating. So this only goes to show the kind of efforts that are being put in by the Federation in discussing various aspects of the matter. And this, I'm sure this is going to be a topic of the future. I don't know whether it will be applied at all or not. This aspect of this general anti-avoidance rules, I think some more discussion needs to be held, not only amongst the tax practitioners. We may invite policymakers also, because the thought process, one way is, I would not, being a sitting judge, I would not like to make any comment on that. But a view can be taken that the thought process which ultimately led to insertion of Section 10A in the Income Tax Act perhaps may no longer hold good in today's context, when the governments, not only the central government, various state governments are aggressively pursuing investments. They are giving tax benefits. They are giving various exemptions. Now, the company or the company is situated at Bombay. The manufacturing unit is situated in the northeast, or for that matter, Uttarakhand or J&K. It doesn't make any business sense. The sole purpose is to avail the tax benefit. But can such an arrangement be termed as an impermissible avoidance arrangement under Chapter 10A? So these are issues, I think, which needs to be discussed before any tax officer applies this particular provision, because this targets tax planning, which at one point of time Supreme Court had said the art of dodging tax, though by not breaking the law. I don't know how far this thought process would be valid or relevant in today's context. So this is one area where I thought we can still have some debate and discussion. And I'm sure the learned members of the Tax Federation will certainly look into this. They have already published a book, and some more discussions and deliberations on this, I think, would be very, very beneficial for all of us, including the policymakers and the tax officials, lest we don't end up a situation where everything ends up in litigation and setting at naught the main intent and object of the legislation. I don't want to go on adding to it. These are difficult times. People are suffering. But as rightly pointed out, every challenge throws up an opportunity. Virtual court, we never thought that we would be having webinars, conferences through video conferencing, but that's a reality. I was not so tech savvy initially, but last 6 months have, at least I can now, not a tech savvy person, but I can calm chalao types I can do now. So that's at least I am before you participating with this. So therefore it has changed everybody. It has changed the habits of everybody. But all said and done, virtual courts or courts through video conferencing, certainly it's very useful, will be there, it is there to stay, but certainly it cannot supplant the physical courts, because we all know the effect of personal hearing, the effect of arguments that when a lawyer makes in the court, when the physical presence and the manner and mode of argument, it makes a world of difference. Virtual court can definitely act as a supplement to physical courts, but I don't foresee it supplanting altogether physical courts. I thank the organizers for inviting me to participate in this inaugural session of this North Zone conference. Well, it is only organized by the North Zone. It has, as I see, it has taken a pan-India character. So this is actually an all-India conference. So thank you very much once again for inviting me, and stay safe and God bless.
Thank you, sir, for highlighting the problems faced by all of us post-COVID and showing the way forward. Thank you, sir, for your blessings. I now request Mr. Alok Jain, Advocate, to introduce the eminent chief guest, Honorable Mr. Justice Rajesh Bindal, Judge, Jammu and Kashmir High Court. Mr. Jain, please.
Thank you, Puneet. A very good morning to all the dignitaries on the virtual platform, and cozy morning to the members logged in, and a relaxed morning to the technical squad on the 150th Jayanti of Freedom Provider and 116th Jayanti of Green Revolution Promoter as well. I have been given the arduous task of introducing the chief guest for today, and that too in the short span allocated to me. His Lordship was born in the profession in September 1995, though landed on this planet Earth on April 16, 1961 at Ambala City in India. Interestingly, Income Tax Department happened to be his client in the Honorable Punjab and Haryana High Court. In SYL water dispute in between the states of Punjab and Haryana, he remained associated on behalf of the state of Haryana before the Honorable Hereditary Tribunal and the Honorable Apex Court. His Lordship was elevated as Judge of the Punjab Haryana High Court on March 22, 2006, and presently is first puisne judge for the High Court of Jammu and Kashmir. He surpassed 14 years of judicial banwas before the onset of COVID-1 on March 22, 2020. As a judge of Punjab and Haryana High Court, he was chairman of the High Court Computer Committee and instrumental in development of good number of softwares, including web-based software MedLabor, whereby all records pertaining to MLR and PMR were not only computerized but linked and synced with the court files. This is now being replicated in other states. Ours was the only high court which has computerized all the judicial records in the country. Besides rendering many landmark judgments, the number of cases decided by him are soon going to touch six-digit figure. He was appointed as chairman of five-member committee in July 2016 in the conference of the chief justices of the high courts to formulate guidelines for the reception and retrieval, authentication and preservation of electronic records in the courts. Report was submitted to the Honorable Supreme Court in November 2018, which included the draft rules. Honorable Supreme Court has directed the central government to give it a statutory force. Ministry of Women and Child Development constituted a multi-member committee headed by His Lordship to study the scope of civil and legal aspects of International Child Abduction Bill 2016. This time also draft legislation formed part of the report. The issue has been taken up by the Honorable Supreme Court on judicial side for the enactment of law on this subject. He is also chairman of the committee constituted by NALSA for conducting assessment of optimal use of technology, including use of artificial intelligence, and was a member of the committee constituted to go into the existing framework of Lok Adalats and mediation. Such is the terrific journey so far of this astounding, towering personality, and many more pinnacles are still to come. Now let me roll over and no longer stand in between all of you and His Lordships. May I now invite His Lordships to share his experiences.
Thank you, Mr. Jain. A very good morning to all present. As we say, good morning, namaskar, adab, sat sri akal, because it's a national conference, not limited to area. And since morning, you see, there had been number of speakers. Everybody had taken the names of all the guests and also the organizers. So I will not repeat that. I will simply say, because we are on virtual mode, and in the virtual mode, we use IT, computer, language. So I will simply say cut, copy, and paste. So as is used in the computer language, we say. And now you see, we all have with us Justice Brother Ujjal Bhuyan, Sister Anita Sumant, Brother Kalyan Surana, Brother Piyush Agarwal, and Brother Sumitra Sekia. Now it is, and me from Jammu and Kashmir. Now it's like news. They say north, east, west, and south. We are from throughout the country, and the conference is being organized or managed at Prayagraj, almost the center. So the organizers certainly need to be congratulated for that. Brother Surana had referred to that what a speaker or a guest in a conference should do. His idea was that he should be brief in speaking, otherwise his depth of knowledge comes out. Yes, he is right. We should not speak much because we have a lot of learned speakers in the technical sessions. to share their views. And in one of the conference, I will share that Mr. P.P. Rao, senior advocate, we are certainly a constitutional expert. He said a chief guest or a speaker in a function, especially on an inaugural function, what are his jobs? He should say he should see the comfortable seat. He should smile a little bit in between. He should speak less and leave quietly. So leaving quietly, speaking less, yes. Leaving quietly is easy here because anybody can just say the poor connection and all that. So just we can switch off. There is connectivity problem. So we are on virtual mode. So that is very easy now. Now coming to the day. Yes, many speakers have already said this is a historic day, 2nd October. We all know. Had we been in Prayagraj, this would have been a long weekend. We would have all enjoyed. And seeing the number of registration, maybe we could have called it a mini Kumbh also, especially in Prayagraj. We have more than 3,500 registration. We know today is the birthdays of our Rashtrapita Mahatma Gandhi and our ex-Prime Minister Lal Bahadur Shastri. And what Gandhi said, there are many quotes of Gandhi. One has been referred to by Sister Anita also. Another is that be the change you want to see in the world. So we have to start from ourselves. As was only suggested by Brother Bhiyan also, IT. Yes, I'll touch that also. But we have to start ourselves, not wait that somebody else will do something and then things will move. No, we have to start from ourselves. As we say, charity begins at home. So one has to start. So that lead we have to take as a federation. And then our late Lal Bahadur Shastri, what he said, he had given us a slogan, Jai Jawan, Jai Kisan. We all know it. And we are seeing now the agriculture community, maybe rightly, wrongly, I'm not commenting on that. They are up in arms because of certain changes made by the parliament and army also. We are knowing we are facing a very difficult situation because I know little better because I am close to that area. And this fact is there that this virtual meeting is certainly a different kind of experience. In this, we have a lot of options. The lawyers also have a lot of options. I'm reminded of a very old joke. I'll share with you that that's the time when there used to be landline phone connections. So one son was having a conversation with his father. The telephone, the intercity calls used to be through booking. 180 probably was the number. You had to book and then maybe half an hour, 1 hour, you will be connected. So he was studying in some different city. He was asking his father that you send me some money. So money, my all finances are over. So father was saying, yes, yes, hello, hello, I'm not hearing, I'm not hearing. So operator was just fed up in between. He said, why you are not hearing? Everything is clear. And he is just asking for money only because he has finished all his money. The answer of the father was that if you are hearing, then you send the money to him. So this is what sometimes is happening in court also. A lawyer who is connected with you in one case, maybe uncomfortable case, will say, no, I'm not hearing anything. There is some problem in audio or video. But in the other case, maybe after 10 minutes, maybe DB or single bench. So these kind of experiences also we are having in court now. Now coming to the title of the theme. Yes, this is very important. They have chosen the title as Gyan Pravaha 2020. Now, if we see the virtual meaning, Gyan means knowledge and Pravaha means flow. This is a pandemic year. Yes, we have all faced this, still facing. Nobody knows when this will end. Word over, everybody is affected. Now, as we normally see, Pravaha, flow of a river or water is from upside down. But this is a kind of flow where the sea level has no meaning or the level of the place has no meaning. We are sitting at Prayagraj. and the knowledge is flowing throughout the country. And this is a flow of knowledge from the experts or experienced persons in the field, which has no barriers, no obstacles in between. And this year, as the pandemic is there, a lot of you see the jokes or messages are being circulated. Living is more important, because what we are seeing, and one of the messages said, somebody said, is July now, congratulations, you have crossed level 6, you are on level 7. So we are on level 10 now, 12 levels in this year. So we have to take care. And this fact is not unknown to all, that how this pandemic has changed our lives. Lives changing is not only the professional life. Our personal life has also changed. Our priorities have changed. Our way of being made because of this pandemic. Our younger generation now feel that your fast food is not the only thing. There are many options at home also, because during the initial period, everybody was at home. And they have explored, the younger generation also explored many things and learned. This had given a positive part of it, that this has given a time or opportunity to the families to live together. Otherwise, everybody was busy in their own work. So as sister had touched the issue, that we should take opportunity in this problem time. Now in this, we are seeing more than 3,000 members and the experts will share their knowledge. And as a last speaker, it's very difficult because most of the content is already shared. And as far as tax is concerned, I was elevated in 2006, yes, but I think initially for 1.5 years I was on the tax bench, and thereafter most of the time I'm doing civil and criminal work. In Jammu Kashmir, if you say, there are very few tax cases because a lot industry or your business is not that much as is there in the other states. In Punjab we had, and Bombay is a yes commercial capital, a lot of commercial issues or taxation issues. So in that, as we sit in the court, we have been 6 speakers in this inaugural function. And as we do in the court, as a last person, suppose some judgment is reserved and the judgment from other brother and sister comes, the last man only says simply, I agree. So I will not venture into anything. So I will simply put my thumb mark on that, I agree. So that will save me from touching anything. Now you see, coming to the profession. Yes, little bit. I will also share some experiences. I was just hearing the recorded version of Prime Minister's lecture on 13/8/2020 he had given. This was on tax reforms, transparent taxation, and honoring the honest. Maybe somebody has thought of honoring the honest also. Otherwise, the honest taxpayer was sometimes taken to be a evader only. So he referred to 3 issues: faceless assessment, faceless appeal, and taxpayer's charter. Good, maybe this was already in the agenda of the government, but it had come in the time of COVID-19. Yes, now faceless assessment, they say there would be regional electronic assessment centers. So as a result of which, all the assessments in the country, because what figures he had given, that the assessment is now, scrutiny is probably in 0.28% cases, earlier it was 0.7 or something cases. So very few cases are taken up in scrutiny. So what this idea is, that the assessment of any SSC can go from place A to place B. And that means from north to south and east to west. No personal interaction. Now in this case, the problem, I don't know, this is a new thing coming up. How, as we are seeing in the court also, sometimes we are facing difficulty in hearing complicated cases through VC. How the opportunity of hearing will be affected, how it will be given, how all these facts will be appreciated. Like what I foresee, I don't know, future will tell what solutions we have. There are problems relating to maybe the taxation related to mining. and suppose the case is transferred to a place where nobody knows about what is mining, what are the intricacies thereof, or some orchard in Jammu and Kashmir, and the case is transferred to a place, maybe in Odisha, no orchards. We have cases regarding coastal areas, regarding fishing. Nobody knows how this will go, how the people work, what kind of expenses are made. Like one of the persons shared with me that we have spinning mills, and in the spinning mills, this is a system that you give the jaggery to the employees because a lot of dust is there so that it can settle down. And if the assessee claims expense on that account, some ITO sitting at a far off place who may not have idea of that kind of industry may disallow that expense. So that kind of problems will come. And the other problem which I foresee may be the language of documents in different areas. There may be connectivity problems also, and there may be issues regarding IT related uploading of large number of documents because we have problems at some places. And another thing is that the sometimes inquiries are also made locally. So how all these facts will be taken care of? But still, we need a very robust website for that, the system IT platform of the department. We all know that when GST was introduced, though the government had engaged a private company for that, initial times it also crashed because of the load. So that also the government has to take care of. But it is a challenge in the profession in the way that competence will be the top. Because now, as has already been shared, there is no barrier. We have seen Mr. Salve appearing from London. He is living in London now, England, and appearing in the cases in Delhi and other states also, other high courts also. So that barrier is not there. Anybody can engage a counsel from anywhere, any chartered accountant for conducting a case. Faceless, maybe the government thought of that, yes, it may be good, maybe some corruption is taken care of, but it may have its own problems which may be sorted out with the passage of time. And another important aspect in this case, as has already been touched, is the training of the professionals. They have to train themselves in IT. Otherwise, we will all lag behind. They may have to depend on some staff, some support, which may not be good in a long term because everybody has to be independent in this. And this problem with this pandemic, in fact, we had faced in the courts also because a lot of our lawyers or their clerks are not trained in this IT part. So the E-Committee of the Supreme Court, which guides all the high courts on e-platform, we have opened, the E-Committee has directed opening of e-Seva Kendras in all the high courts, which will help the litigants, the lawyers or their clerks to file the cases, soft copy of the paper book, scanning and all that. So that kind of a facility may have to be created by the income tax department if it has to go IT, and to give the places also like kiosks to upload the documents also, because connectivity and the speed, especially as we say in Jammu and Kashmir, we have 2G only. At some places it is 4G, though broadband is there, but people have some difficulties. Now, another thing which professionals may have opportunity or may not have, because a lot of defaults are there. So a lot of companies are restructuring. So in that also the role of tax professionals is certainly very important. And as is shared by Sister Anita, yes, we need to have some norms because this is a new thing which has come, and all of a sudden, maybe we were not ready to take it as the only solution. Though off and on we had been doing in Jammu Kashmir also, we had been using the IT platform for VC because there had been hearing of cases from Jammu to Srinagar, Srinagar to Jammu, the lawyer at different places, and even the benches also, one judge at Jammu and one at Srinagar, and the lawyer also maybe at 2 different places. So we have been doing it, but it was not that 100% we were doing it as now we are doing, because a lot of cases are there in Kashmir and Jammu. So sometimes we had to close the court also, and it was total virtual. Now also we are doing total virtual, only the soft copies of the paper book and hearing through VC. There is no court hearing. So this we have to see. And the advocates conduct also, yes, Supreme Court has also commented upon. There was a video being circulated. A senior counsel in the Supreme Court was smoking also. He was having hookah. And there are other car also. Some people are appearing in T-shirts also. So that kind of a thing, yes, we have to maintain some decorum in the profession. And that message, I think we can give from this platform and to the lawyers to start with that, no, if the system is to remain in place, I think we should maintain it, not like doing, because what difficulty we are seeing there, that number of lawyers, they have just opened 3-4 laptops. They are attending the hearing, sitting in their office, 3-4 courts simultaneously. And the mic of all the courts is on. So cross arguments also we are hearing. So that is disturbing. In a lot of counsels, they don't wait. They just start speaking. One is arguing the case. He will also just all of a sudden interject and say, my case is this one. Because you see, practically, we are not able to maintain the cause list in the way that serial number wise cases are taken up. Because those practical difficulties are there, whosoever counsel joins. So we take up his case and maybe he has 3-4 cases, so we finish off all these 3-4 cases, maybe a different serial number. This is what we are following there, because we can't allow them to wait because they all remain in the waiting area or continue joining on the VC. So, but still we have to have some norms, some discipline is required for that. And another thing which the professionals have to take care, because we all know that in this time there has been very less revenue generation to the government and the spending is more. So maybe, I don't know, I have no idea as such, but maybe as seeing that there may be some effort by the government to generate revenues. So there are two parts of it. One is that we should not be party to evasion of tax. I always say that we should be honest in that, because any burden of an honest taxpayer, burden of a dishonest taxpayer, a tax evader always falls on the honest taxpayer, because the government has to have his revenues, whatever is required. And secondly, the compliances, especially the technical compliances which are picked by the computers, because artificial intelligence is used now to pick up the cases. So wherever there are technical violations, non-compliances, the computer may pick up those cases. So we have to ensure that we don't give that opportunity. There is no intention to evade tax. There is no evasion of tax, or maybe some fault here and there. So that I think we need to take care. And regarding revenue, yes, pending I have touched, yes. Now, as far as the backlog of cases is concerned, yes, this period is really difficult. We will face this difficulty, I think, in the year to come also, because of the backlog being forwarded in the carry forward, like the counts we say. But what we are trying in Jammu and Kashmir is that we are listing all the old matters also, very, very old matters. And we have been able to take up those matters. Maybe some are covered by any judgment, not taken care of by the lawyers also, court also, because the present cause list is very long. And sometimes the lawyers or the professionals can also help judgment of the court with the passage of time, or may have been rendered infructuous with the passage of time. If that help is given by the professionals, maybe we are able to use this time positively. And not that all the cases we carry forward, because if all the cases are carried forward, yes, we will face difficulty in next year also, just to streamline the working. And there may not be effective working in court. There was another thing regarding the technical part, but I can just share you, because there are a lot of anecdotes in the Yes, am I audible?
Yes, sir, you are.
Okay, okay. So there was some disconnection in between.
Yes.
So on the technical part, lot of, you see, anecdotes are there in the court. I will just share that. One of the lawyers, he just argued a case and came out of the court So his client, he was semi-literate, he could not understand everything. So he said, Vakil Sahab, what was the law point argued by you? I could not understand. His answer was that law point, I don't tell even the judge, he can ask me 10 times. You are saying I should tell you this law point. So that kind of a thing, these legal issues, because these may come to the court, we can't comment on that. But yes, for discussion point of view, these are very important issues. And in this pandemic, there are a lot of amendments being made in the law, and we need to be update and guide and advise our clients accordingly so that there are no defaults as such. So I think I will not take much time. Time was only up to 10:45. Mr. Sanjay had strongly directed. So I will only end by saying that I am thankful to the organizers for giving me this opportunity to meet all the friends. It would have been good had it been in Prayagraj. We would have come, shared our views, and enjoyed the hospitality also. Now we are enjoying the virtual hospitality, but I wish the conference a great success. Thank you very much.
Thank you, sir,
for sharing the pearls of wisdom with all of us and touching upon the pertinent issues. Looking forward to host you very soon in Prayagraj and Varanasi, sir. Friends, AIFTP has compiled an e-publication digest of 151 landmark judgments of the Honorable Supreme Court of India that are applicable today. The publication is dedicated to late Dr. Justice B.P. Saraf. I request Dr. K. Shivram to handle the proceedings for release of this publication. Over to Shivram, sir.
Yes, thank you. Thank you. Thank you very much. In fact, I thought of, like follow the what Lordship Justice Rajesh Bindal followed. But I thought that I should not miss opportunity to address our own members, my lord. So otherwise possibly I may not get one more opportunity to see all the judges together. That's why I will refer the names of the honorable my lord, because this is possibly, I think, maybe I have opportunity, because otherwise all our colleagues earlier had long relation with them. My Lord Justice Rajesh Bindal, my Lord Justice Ujjal Bhuyan, Ladyship Justice Dr. Anita Sumna, my Lord Justice Kalyan Rajwarna, my Lord Justice Mr. Piyush Agarwal, my Lord Justice Thomas Saika, National President Nikita Badeka, Past President, Chairman of the Conference Sanjay Kumar, I must refer his name, and the June Mr. Chairman Azim Jaffar, Vice President North June Nikesh Srivastav, and of course our Energy Secretary, already that he is doing a lot of work on this, Mr. Singh, that is very known to us, and his father also very close to us when he was active and was one of our pillar of our association. But good morning to everybody. Of course, we are reached up to lunch time now. One of the objects of the Federation is promoting to the, that the citizens and the taxpayers regular publications. AIFTP published more than 41 publications to its name, and today is the title that 151 landmark judgment of Supreme Court of India, direct and allied laws, 150 of Mahatma Gandhi. May I request now our Lordship Justice Rajesh Bindal to release our publication, please, my Lord.
Yes, I will just add one line, Mr. Shivram.
Yes, my Lord.
We all know it has been referred to that Gandhi ji, Mohandas Karamchand Gandhi, as we know, freedom fighter in the forefront. But I think as a lawyer professional, lawyer community, we should be proud that he was the only lawyer who was given the title of Mahatma. There is no other person in the country. So as a lawyer fraternity, we should be proud of it. Yes. So yes, you can just release the book. It's a great effort made by the Federation.
Thank you, my Lord. Thank you, my Lord. My Lord, this publication is very prestigious, important published AIFTP for two reasons. Firstly, the 2nd October, it is the auspicious occasion of the 150th birth anniversary of the father of the nation, Mahatma Gandhi, one of the greatest human ever born in India. It is an occasion for all of us to salute the great soul. Secondly, it is raised by our Lord Justice Mr. Rajesh Bindal, in the presence of the honorable judges, were or members of the AIFTP before elevation and are all currently sitting judges, various high courts, who are practicing on the tax law. Our young research team of 27 members who regularly appear before the tribunal, High Court have digested 101 landmark judgment, direct taxes, and 25 cases on indirect taxes and 25 cases on allied laws. And our editorial team of the 13 members have devoted their time and shared their experience for editing the editorial to all the case laws. We are grateful to each member of research team and editorial team. This publication is dedicated to Justice Dr. V.P. Saraf, former Chief Justice of High Court of Jammu and Kashmir. In fact, we have reproduced the speech of the Honorable Prime Minister of India, Shri Narendra Modi, on the occasion of the 150th birth anniversary of Mahatma Gandhi at UN on September 25th, which discusses the relevancy of Mahatma Gandhi in the current era. Honorable judges have provided their valuable messages and wisdom. We are grateful to their words of wisdom in the message. And of course, today also we heard their wisdom, and we'll be a small note on that. We're preparing and we're publishing soon on that. In the beginning of our publication, one will find a detailed index, section-wise, reference, brief issues of the case laws, all the landmark judgment of judges publication will relevance of today and also in the future. Indirect case law digested will have great aid to the understanding of development of GST law. That is very important. And each case as an editorial, this is a value addition which will immensely benefit to the readers. Each case has the one editorial which is written by very seniors. Subject-wise index, section-wise reference, and case laws index will help readers for quick reference. And after each case law, one quote of Bapuji is added, which is an inspiration to readers. After reading the case laws, if you can see the one quote, that itself will most experience and throughout the year enjoy this book by reading the case laws and also reading the quote of Bapuji is concerned. This publication teamwork under the leadership of Nikita Badeka, National President, AIFTP Chairman of Mr. Mitesh Kotecha, Chairman Committee and General Committee, Mr. Our Janak Wagani, CA, and our senior most past President, Sri P.C. Joshi, and Pradeep Kappa. Beginning and their effort to be really to be appreciated. And of course, I should appreciate really grateful to Dr. Ashok Saraf, senior advocate and my friend, who has wholeheartedly supported this publication and other publication of AIFTP. And this publication will be hosted on the website of AIFTP and is made available to all the members and also non-members on AIFTP online org, can be downloaded and free of cost. It can be very useful to all the members. We are able to bring out publication within 1 month time. This is made possible of the diligent efforts of Mr. Kotecha, Chairman of the General Committee, and of course very efficient staff of the AIFTP, Mr. Ravindra Potode, the Chief Executive Officer of the AIFTP. His effort I cannot forget at all. Finally, are very positive the followers of Gandhian principle, and they used to guide us and help us by sharing their knowledge and experience. Though they are not with us, we have firm belief that their soul will guide us and continue to inspire us. Thank you very much. Wish you all happy and peaceful Gandhi Jayanti. Thank you once again.
Thank you, Shivram sir, for bringing this treasure to us. Friends, on the occasion of VNTC 2020, we are releasing an e-souvenir. I hereby invite the Chairman AIFTP Northern Zone, Mr. Asim Zafar, to handle the electronic release of the publication. Mr. Zafar, please. Mr. Zafar, please unmute yourself.
2020.
Please go ahead.
Thank you, Mr. Puneet. Good morning to all of you. On the occasion of this virtual National Tax Conference 2020, Gyan Pravah, we have come out with a useful and informative e-souvenir. I would like to inform the August virtual gathering that e-souvenir has been possible only due to untiring efforts of our Vice President North Zone, Shri A.K. Srivastava, with active assistance of Shri O.P. Shukla, member of the National Executive Committee, AIFTP. Now, I request our Chief Guest, Honorable Mr. Justice Rajesh Bindalji, Judge, Jammu and Kashmir High Court, to kindly announce the release of e-souvenir.
Justice Bandal.
One line before this also changed our way of working. Published on paper, lot of paper and it effect on environment then. We all know how much trees are used for manufacturing paper, how much forest has to be cut. So these are both e-books. Everybody can have these on their computers and use at any time. Now we know that everything is available in the mobile phone only. We need not carry even the computer. So this is a very good practice. I think in future also we can follow that. So yes, this also souvenir can be released. Sure.
Thank you, sir. Friends, the e-publication and the e-souvenir are available in Google Drive, and the link for the same is shared in email, on YouTube, as well as in the chat box. I would now like to invite Madam Jamna Shukla to present the vote of thanks. Jamna, Madam, please.
Thank you, Puneet. Thanks again. Honorable Chief Guest, Guest of Honors, President AIFTP, distinguished guests, and esteemed participants. Myself, CA Jamna Shukla, express my pride and privilege to deliver that vote of thanks at this memorable inaugural session of Gyan Pravah Virtual NTC 2020 with theme Challenge for Tax Professionals Post-COVID-19, organized by AIFTP North Zone. I wish to express our sincere appreciation to our Chief Guest, Honorable Mr. Justice Rajesh Bindal, Judge J&K High Court, for delivering a truly inspiring and memorable inaugural address. Our heartfelt thanks to you, sir, for sparing your precious time for us. I express our sincere thanks to our guest of honors, Honorable Mr. Justice Ujjwal Bhuwan, Bombay High Court, Honorable Dr. Justice Anita Suman, Judge, Madras High Court, Honorable Mr. Justice Kalyan Ray Surana, Judge, Guwahati High Court, Honorable Mr. Justice Piyush Agrawal, Judge, Allahabad High Court, Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court, for their words of wisdom, which has provided us and regulators a valuable perspective in the times to come. I thank you, our National President AIFTP, Mrs. Neetika Videkar, to our Deputy President AIFTP, Mr. M. Srinivas Rao, to CA Anil Kumar Srivastava, Vice President AIFTP North Zone, to Mr. Asim Jafar, Zone Chairman AIFTP North Zone, Mr. Sanjay Kumar, Conference Chairman, Mr. Puneet Singh, Secretary North Zone AIFTP, for their untiring efforts, contribution to the whole program. Our sincere thanks to CA Vijay Keval Ramaniji, NEC member AIFTP, for his rich and unmatchable guidance throughout the program. I extend our sincere thanks to our distinguished guests, all the delegates, for your gracious participation and making the inaugural so grand. I extend my thanks to Achars and Batukji for their beautiful Swasti Vachan. My sincere thanks to technical supporters, media person, and all whoever has contributed to this program and mega event. Last but not the least, I express my sincere thanks to Tax Sutra for extending their valuable support to the program. Thank you everyone. Jai Hind, Jai Bharat.
Thank you, madam.
Thank you, Puneet. Over to Puneet again.
Thank you.
Thank you,
so
madam.
much.
Thank
Friends-
you for all the senior judges.
Yes, I'm thankful to all the dignitaries and all the delegates who are here.
Thank you, Lordships.
Friends,
Thank you very much.
Successful.
a most graceful inaugural session comes to an end. Please stay with us while we rearrange the dais and commence the first technical session on income tax, in which Dr. Girish Ahuja ji is the keynote speaker. Dr. Girish Ahuja ji is already with us. We'll not take a lot of time, just quickly rearranging the dais. Meanwhile, we present a short presentation by Tax Sutra, whose support has been a big help in organizing the conference. Thank you.
Thank you all. Thank you.
चैट बॉक्स में दोनों डालना है ना, जो आपने व्हाट्सएप
The only difference is we'll have to have a cup of tea at our home. Thank you.
Puneet ji, start.
Friends, welcome back to the first technical session of Virtual National Tax Conference 2020. The Gyan Pravah continues. Friends, the Honorable Past President of the country, Dr. APJ Abdul Kalam, used to say, knowledge with action converts adversity into prosperity. I am confident that we will take a step forward in doing so by enriching ourselves with the wealth of knowledge. The topic for this session is charitable trust, educational institutions, hospitals, and discretionary trusts under the Income Tax Act 1961. Friends, at the end of the session, we will be taking questions from the audience. Please send in any queries you have on the Q&A panel so that the same may be taken up by our panelists. The dais for the session is ready. The chairman for this session is respected Dr. Ashok Saraf, senior advocate, and the keynote speaker for the session is the charismatic speaker, Dr. Girish Ahuja. The moderator for the session is the eloquent advocate, Mr. Arvind Shukla. I welcome you all. I now request Mr. Shukla to take over the proceedings. Over to Mr. Shukla.
Welcome to the first session of PNTC 2020. Which is going to contemporary topic
Friends, kindly bear with us. Mr. Shukla ji will be back shortly. Please join me. Come.
Extremely sorry for that small problem. I restart. There are several entities under the Income Tax Act which are given exemptions from tax on fulfillment of prescribed conditions. Some of the most important of them are public charitable institutions, education institutions, and hospitals. The topic for the session is charitable institutions, educational institutions, hospitals, and discretionary trusts. Friends, any questions related to the session will be posted on the Q&A box for being addressed by the tax experts. To deliberate upon this issue, we have invited one of the most popular star auditors on the subject, Dr. Girish Ahuja. The chairman of this session is Dr. Ashok Saraf, another doyen in the field of legal fraternity, who is past president of AIFTP, senior advocate Dr. Saraf, passed his BCom honors from Guwahati University with honors in business management, secured first class second position in the university, passed MCom examination from Guwahati University, secured second position in the university in the LLB examinations in 1986, awarded doctorate of his thesis, corporate taxation in India by the Guwahati University, joined the Guwahati High Court Bar in 1986, had an extensive practice in the High Court, especially in writ taxation, corporate and commercial law, designated senior advocate by the Guwahati High Court, served as special standing counsel for the Income Tax Department. He was also former Advocate General of Arunachal Pradesh. He has authored many publications and has held various posts with the tax bar associations. Our key speaker, Dr. Girish Ahuja, is so well known and popular amongst all tax professionals that he needs no formal introduction. His in-depth knowledge on finer points of law, duly supported by latest case laws, make his words the final authority on any tax matter. Dr. Ahuja did his graduation and post-graduation from Sri Ram College of Commerce and was position holder. He got his PhD from Faculty of Management Studies, University of Delhi. He has been teaching direct taxes to students at various levels for over 35 years. He is a fellow of the Institute of Chartered Accountants of India and was placed in the merit list of both intermediate and final examinations. He is senior faculty member of Sri Ram College of Commerce, Delhi University, and also visiting faculty member in the Institute of Chartered Accountants of India, Institute of Company Secretaries of India, and various management institutes. He has been nominated by the government to the Central Council of the Institute of Company Secretaries of India for 2 terms. He is member of Fiscal Law Committee of ICAI and editorial board of ICSI. He is also on the board of directors of many companies and has a vast and rich experience in the field of taxation. With 2 great doctors commanding the session, in order to get the maximum benefit from them, we have to very patiently digest each word of wisdom coming from our learned speakers. I respectfully hand over the mic to the chairman of the session for further conducting the proceedings and to start with his opening remarks. Over to Dr. Ashok Saraf, sir.
Thank you, Shuklaji. I'm grateful to the organizers of the National Convention for giving me this opportunity and honor to chair the first technical session of the virtual National Convention. In fact, as the chief guest of the first in the inauguration session said, that the role of the chief guest is very simple. He has to see the chair, comfortable the way to go out, and rest to allow everybody to speak. In fact, when I was requested to be the chairman of the session, I specifically told Mr. Sanjay Kumar that when the speaker is like just Dr. Girish Ahuja, then I don't think that there is any role of the chairman of the session to be there to say anything. In fact, the chairman's role is only to request the speaker to speak on the subject. Friends, the subject which has been chosen for today is really very interesting. As you all know, whenever any exemption is provided under the Income Tax Act, the controversy starts. The department always, with some way or other, tries to deny the benefit of the exemption and thereby frustrate the very purpose of the incorporating the provisions for the exemption. The provision for granting the exemption is very loud, but the various controversies that what is the charitable purpose, what is all those things, the controversies are still going on. Various judicial precedents are there, one way or other, which makes the things more complicated. And in fact, we like to hear from Dr. Girish Ahuja, who is an eminent person, a faculty in the field taxation law, that what is the detail about the subject. And without going into anything further, I will request Dr. Girish Ahuja to kindly deliver his speech.
Good afternoon to all. Let me, sir, first, before I address everyone, let me tell you one thing. When I was hearing the previous speaker, I was wearing a green t-shirt, very bright green t-shirt. The moment he mentioned that people have to appear, they appear in t-shirt and all that, I thought I must change myself. So I immediately rushed and slipped onto the jacket and of course the shirt also. So sorry if I had been there, because I thought it is a holiday and one must enjoy and have wear a t-shirt. But very rightly he pointed out, so I have changed myself to that dress. And secondly, let me give you an advice before I proceed. Please don't go to the Google at all for income tax, at least for this purpose. Whatever biodata which has been read about me is only 20 years old. It's only 20 years old. They just downloaded from the Google and read it out as it is. I retired from Shriram College about 11 years back, and there is no fiscal committee in the Institute of Chartered Accountant of India for the last 18 years. And there are so many things are there. So the biodata, please don't read whenever you are going to do income tax. You have to be very up-to-date. Update means you have to be very careful that whatever you are downloading, it has been properly updated. Chaliye, ye to baat maine kar di. Let me start with this. The chairman of this technical session, of course, Dr. Ashok Saraf ji, the moderator, Mr. Arvind Shukla ji. We have other dignitaries I've seen. I don't know whether she's still there. Honorable Justice Sumitra Sakia ji. We have the National President, Advocate Mrs. Nikita Bazoika ji. The chairman of North Zone, we call it president or chairman, I don't know, Asim Jafri ji, vice president, of course. And Vice President A.K. Shrivastava ji, Sanjay Sharma ji from Delhi, Advocate Sanjay Sharma ji, Advocate Sanjay Kumar ji also sitting here, other dignitaries, Mr. D.K. Gandhi ji, the other Arvind Mishra ji, the other dignitaries hearing me, ladies and gentlemen. Let me tell you first preference, let me tell you, sir, there are 3 sections in 11, 12, and 13 for trust, charitable trust and religious trust, maybe educational institution also. And there is one more section, section 10, clause 23C. So let me tell you, I will have to tell you before, what is the difference between section 10, clause 23C, and of course, section 11, 12, and 13. I am saying section 10, clause 23C. You may say it should be subsection 23C. It's absolutely wrong. It is not subsection 23C. Why I'm saying this is that there are many sections in Income Tax Act which does not have subsection. It does not have subsection. Although we know income tax is a very complicated subject. You have section, you have subsections, you have thereafter clause, you thereafter have subclause, and there also it is not complete. Thereafter you have item, after that you have sub-item, then you start with first proviso, provided that, you start with the second proviso, provided further that, you start with the third proviso, provided also that, then you can keep on adding the proviso by saying provided also that. Like when you say, I thank Dr. Ashok Saraf, I thank Dr. Justice on this days, I also thank, I also thank, I also thank, I also thank. Keep on adding the also, and you can have 20 proviso given under section 10 clause 23C. Still it is not complete. There is explanation number 1, explanation 2, and maybe third explanation also. You are looking for a full stop, the comma is after 6 lines. So what I'm trying to explain, there are certain sections which do not have subsection. What are those sections? Generic name, common name of the section. Then you don't have subsection there, you have clauses there. Section 2, what is the heading the section 2? Definition. There is no one definition given. When you talk about subsection, it talks about the main section. But when you talk about general section, the common section, it has clauses. It does not have subsection. So section 2, clause 31, meaning of a person. Section 2, clause 34, total income. Section 2, clause 7. Section 2, clause 9. Section 2. This is the way of section. Now section 10. Section 10 is income which do not form part of total income. There is not one income which do not form part of income. There are so many incomes which are exempt. So section 10 does not have subsections. It has each clause. Section 10, clause 1, agricultural income. Section 10, clause 2, share of profit from HUF. Section 10, clause 3, 2A, share of profit from firm. I have seen many Supreme Court judges also saying subsection. And even the senior most lawyers saying section 10 subsection. But section 10 does not have subsection. It has clauses. Why I gave you so much of thing? Because I'll be using section 10, clause 23C, subclause 3IA, 3IAB, 3IAC. You'll say, what is he talking about? So let me now start. We have 2 sections for exemption for charitable trust. One is section 1023C. Another is section 11, 12, 13. Let me first take section 11, 12, 13, then I'll come to section 1023C. Now, what really is that this is relating to charitable or religious trust. Section 2, clause 15 has given you the definition of what is a charitable purpose. Charitable purpose includes relief to the poor. Number 1, relief to the poor. Why I'm saying? Because I have to compare with 1023C. Relief to the poor. Second is education. 3 is yoga. 4th is medical relief. Preservation of environment, including watershed, wildlife, forest, preservation of monument and places of interest, and advancement of any other object of general public utility. This is the definition of a charitable purpose. Why I'm saying? Relief to the poor, number 1. 2, education. 3, yoga. 4, medical relief. 5, preservation of environment, including watershed, forest, wildlife. 6, preservation of monument and places of importance. And the 7th is advancement of any other object of public utility. Now, 7th limb, there is a proviso. First 6 limb, there is no proviso. 7th limb says, advancement of any other object of general property will not be called a charitable purpose if it involves an activity of carrying on any. May I request, at least 3-4 persons should be in front of me. You know, everybody goes away and then I'm talking to wall. I have in front of me Mr. Arvind Shukla only. The others have shown their photograph or they have gone. I cannot enjoy. I have to ask them many things. Now Mr. Asim Jafri is also come. Because what I'm trying to say, unless and until I know to whom I'm talking, I'm not talking to the walls. The virtual is only this thing. When you come for the audience, when you have a virtual, you don't enjoy. So I want to read the face of each person, whether they are understanding, am I running fast, or whether they are not able to understand. Sometimes I will name I will ask them, have you understood or not? So I want two more. National President is with me now. Madam Nikita ji also is there. Asim Japri is not there. Arvind Shukla is not there. Where is the Vice President, Mr. A.K. Srivastava? He should also come in front. Where are the other persons? I must have 5-6 person in front of me. I don't enjoy. I can't enjoy without talking to each and every person. So I'm coming back. I said there are 7 limbs in a charitable purpose: relief to the poor, education, yoga, medical relief, preservation. I told you 2 kinds of preservation. In these 6 limbs, you can do an activity of carrying on a business. There is absolutely no restriction to carry on a business by these charitable trusts, provided it is incidental to the attainment of the objective of the trust, and separate books of accounts have been maintained for that. We have absolutely no objection that a charitable trust of first 6 category may do business, but that business must be incidental. Everybody has disappeared except Mr. Arvind Shukla. Everybody has disappeared again. What should I talk to whom? Everybody has disappeared again, sir. I'm not saying those who are interested can come and show my face. Now Mr. D.K. Gandhi has come back. Thank you very much, Mr. Gandhi. I'm noticing I have to have some persons in front of me. Otherwise, I don't enjoy. So first 6 limbs of categories of charitable can do any activity of business, provided the business is incidental to the attainment of the objective of the trust, and separate books of accounts have been maintained. But the last category, advancement of any other object of general public utility, said that it will not be treated as a charitable purpose if it involves an activity of carrying on any trade, commerce or business, or any adventure or concern in the nature of for rendering service to trade, commerce or business, whether for any consideration or for any fee or for any remuneration, unless the receipt from this business activity does not exceed 20% of the gross receipt. So if you are covered under advancement of general public utility, you can do business, but your gross receipt from that business cannot exceed 20% of your total receipt. If it exceeds 20%, exemption will not be given if you are covered under advancement of any other object of general public utility. But if you are in education, if you are having relief to the poor, or you are a hospital or a medical institution, or you are a preservation environment, you can do business. And commercial activity receipt can be more than 20%. The only condition is that business should be incidental to the attainment of the objective of the trust, and separate books of accounts are maintained. And all business are incidental to the attainment of the objective of trust. Thanti Trust has decided, Supreme Court in that case. So there is absolutely nothing to worry. But now I'm comparing with, this is meaning of charitable purpose. Religion, meaning of religious activity has not been given, because religion is only for propagating of religion. And once you propagate a religion, there is absolutely no need to tell you the definition of a religious trust. So religion can do even business activity, provided it is incidental to the attainment of the objective of the trust, and separate books of accounts are maintained for that. This I'm talking about section 11 I'll be taking. But now come to section. Now try to say, Arvindji, try to listen carefully. And of course, I would like D.K. Gandhiji to give attention. There is section, sir, section 1023C, clause 3 IAB, subclause 3 IAB. Section 10, clause 23C, subclause 3 IAB. Next is subclause 3 IAC. Next is subclause 3 IAD. Next is subclause 3 IAE. Next is subclause IV. Next is subclause V. Subclause. Then is section 10, clause 23C, subclause VI. And there is section 10, clause 23C, subclause VIA. ये सब कुछ आपको आता है. मैंने तो इंप्रेशन डालने के लिए क्लॉजेस सुना दी ताकि आपको पता लगे कि मुझे क्लॉजेस भी पता है, मुझे इनकम टैक्स आता है। अदरवाइज आपको पता है, क्लॉज नहीं याद होगी, सब क्लॉज याद नहीं होगी, लेकिन कंटेंट्स आपको याद है। मैं बताने जा रहा हूं। सेक्शन 10 क्लॉज 23C सब क्लॉज 3IAB, income of a university or educational institution not for making any profit but for imparting education, who is substantially or wholly financed by the government, shall be fully exempt. क्या मैंने कहा? Income of a university or an educational institution not for making any profit but for imparting education, which shall be exempt if it is wholly, Gandhi ji, if it is wholly financed by the government or substantially financed by the government. Substantially का मतलब होता है more than 50% grant is coming from either the central government or the state government. तो 50% से ज्यादा ग्रांट है या 100% है तो you are funded by the government. ये सेक्शन 1023 3IB की एजुकेशनल इंस्टीट्यूशन को कहता है. And income of this educational institution is fully exempt. Fully exempt. इसमें कोई बुक, कोई आपको ऑडिट नहीं कराना है. कहता है कराना, उनका कहता है वो अलग बात है. कोई आपको ऑडिट नहीं कराना, कोई 85% 15% वाली कंडीशन नहीं है कि 85% टू बी स्पेंट, 15% टू बी एक्यूमुलेटेड. ऐसी कोई कंडीशन है ही नहीं. कोई भी आपको कंडीशन मेट नहीं करनी है. एक ही है मैंडेटरी, दैट इज यू हैव टू फाइल रिटर्न ऑफ इनकम, जो पहले नहीं थी. 3 साल पहले आ गया that every university or educational institution, though wholly financed or substantially financed by the government, will have to file return of income under section 139 subsection 4C before the due date of return. ये रिटर्न कंपलसरी है, बाकी कोई कंडीशन नहीं है. कोई कंडीशन नहीं है 85 वाली, 50 वाली, कॉर्पस डोनेशन या कोई भी ऑडिट कराने की कोई कंडीशन नहीं. ये क्लियर हो गया गांधी जी? बिल्कुल ऐसा ही है सेक्शन 1023C 3IAC, income of a hospital or a medical institution not for making any profit but for philanthropic purposes will be exempt if it is wholly or substantially financed by the government. So जितने भी हॉस्पिटल्स हैं, मेडिकल इंस्टीट्यूशंस हैं जहां मोर देन 50% ग्रांट या 100% ग्रांट गवर्नमेंट देती है, उसकी भी इनकम टोटली एग्जेम्प्ट होती है, चाहे वो एजुकेशन, वो हॉस्पिटल हो या मेडिकल इंस्टीट्यूशंस हो. लेकिन यहां भी एक ही कंडीशन है, बुक्स. क्या कंडीशन है? रिटर्न मैंडेटरी. रिटर्न ऑफ इनकम डालना मैंडेटरी है 139(4)C के अंदर. सर ये दो क्लॉज, सब क्लॉजेज हो गई, 3IAB 3IAC. अब मैं जा रहा हूं. इनकम ऑफ ए यूनिवर्सिटी और एजुकेशनल इंस्टीट्यूशन नॉट फॉर मेकिंग एनी प्रॉफिट बट फॉर इम्पार्टिंग एजुकेशन whose gross receipt do not exceed 1 crore. जिसकी 1 करोड़ से ज्यादा ग्रॉस रिसीट नहीं है, फंडेड बाय गवर्नमेंट नहीं है, ग्रॉस रिसीट डू नॉट एक्सीड 1 करोड़, तो वो भी इनकम टोटली एग्जेम्प्ट है. अरविंद जी, टोटली एग्जेम्प्ट है. उसमें भी कोई कंडीशंस नहीं है, कोई ऑडिट एज पर इनकम टैक्स कंपलसरी नहीं है, कोई ऑडिट रिपोर्ट नहीं बनानी है, सिर्फ करना है रिटर्न मैंडेटरी है. रिटर्न ऑफ इनकम मैंडेटरी है. कोई 15% 85% की कंडीशन नहीं है. ये मैं आपको बता दूं, ये भी बता दूं वो कंडीशन नहीं है. फिर आता है इनकम ऑफ हॉस्पिटल और मेडिकल इंस्टीट्यूशन नॉट फॉर मेकिंग एनी प्रॉफिट बट फिलैंथ्रोपिक पर्पसेस whose gross receipt do not exceed 1 crore. ये भी वही वाली चीज है. इसके क्या सेक्शन है? सेक्शन 1023C 3IAE. एजुकेशन का था 3IAD. AD और AE 1 करोड़ वाले हैं, और AB और AC सब्सटेंशियली या होली फाइनेंस्ड बाय द गवर्नमेंट है. तो इनके बारे में समझ में आ गया सर. कोई रिटर्न नहीं भरनी, सॉरी कोई 85-15 नहीं है, कोई ऑडिट कंपलसरी है मिस्टर श्रीवास्तव जी, ये कोई ऑडिट कंपलसरी नहीं है, कुछ नहीं करना. एक ही चीज है, रिटर्न भरना कंपलसरी है, और कोई चीज आपसे मांगी नहीं हमने. क्लियर है सर? क्लियर है. अब मैं 4 और 5 को बाद में लेता हूं. 1023C सब क्लॉज VI. अब जरा ध्यान से सुनना. income of a university or educational institution, not for making any profit, but for imparting education, whose gross receipt exceed ₹1 crore. अगर 1 करोड़ से ज्यादा है तो आप 1023C VI में आ सकते हैं। और दूसरा सेक्शन 1023C VIA, अगर आप हॉस्पिटल और मेडिकल इंस्टीट्यूशन हैं, नॉट फॉर मेकिंग एनी प्रॉफिट बट फॉर philanthropic purposes, तो इफ योर ग्रॉस रिसीट एक्सीड ₹1 करोड़ तो आप VIA में आए। ये क्लियर हो गया सर? सो सेक्शन 1023C VI एजुकेशनल के लिए है, ग्रॉस रिसीट एक्सीड 1 करोड़। सेक्शन 1023C VIA हॉस्पिटल मेडिकल इंस्टीट्यूशन के लिए ग्रॉस रिसीट 1 करोड़। लेकिन रुकिए, थोड़ी देर पहले बताया था कि 11-12 में भी तो एजुकेशन है और मेडिकल रिलीफ है, वहां भी तो एजुकेशन है और मेडिकल रिलीफ है। तो दोनों में फर्क क्या है और कौन से सेक्शन में जाना चाहिए? मेन तो पॉइंट ये है। देखिए, यहां 1 करोड़ तक था तो पूरा माफ था, लेकिन जो 11-12 में जाता है, 1 रुपया भी इनकम कमाएगा, एग्जाम कराना है तो उसको रजिस्ट्रेशन करानी पड़ती है। तो मैं आप कंपैरिजन कर रहा हूं अरविंद जी, बिटवीन 1023C एंड 11-12 फॉर एजुकेशनल इंस्टीट्यूशंस, यूनिवर्सिटीज, हॉस्पिटल और मेडिकल इंस्टीट्यूशन। कंपैरिजन देखिए असीम जी, कंपैरिजन देखिए, जाफरी जी कंपैरिजन देखिए क्या है। इन द केस ऑफ 1023C यू नीड टू हैव अप्रूवल लेनी पड़ती है। कमिश्नर ऑफ इनकम टैक्स एग्जामिनेशन से अप्रूवल चाहिए, अप्रूवल। लेकिन 11-12 वालों के लिए आपको रजिस्ट्रेशन चाहिए, 12A में अप्लाई करके रजिस्ट्रेशन। इधर राइट साइड में रजिस्ट्रेशन है, लेफ्ट साइड में अप्रूवल है। राइट साइड में फॉर्म आपको 10A भरना पड़ता है रजिस्ट्रेशन कराने के लिए, लेफ्ट साइड में फॉर्म 56D भरना पड़ता है अप्रूवल के लिए। आप कहेंगे फर्क क्या है? तीनों चीजें तो दोनों में माफ है, उधर भी माफ है, इधर भी माफ है, तो फर्क क्या है? अभी बताता हूं। पहले अप्रूवल और रजिस्ट्रेशन। अभी एक अमेंडमेंट भी बताऊंगा, लेकिन वो अमेंडमेंट पोस्टपोन कर दी 1 अप्रैल तक, क्योंकि री रजिस्ट्रेशन री अप्रूवल जो 1 अक्टूबर से शुरू हो जानी थी वो पोस्टपोन कर दी गई है अगले साल के लिए। तो वो मैं थोड़ा देर में बताता हूं। इधर अप्रूवल है, इधर रजिस्ट्रेशन। क्या फर्क है जी? गांधी जी जरा सुनिए। अगर आपके पास रजिस्ट्रेशन है और आपका केस स्क्रूटनी में आ गया, तो असेसिंग ऑफिसर जब स्क्रूटनी करता है तो वो देखेगा वेदर यू आर फॉलोइंग द ऑब्जेक्ट, वेदर यू हैव एक्यूमुलेटेड द फंड अंडर 11(5), आर यू मिसयूजिंग द फंड्स, और आपके ऑब्जेक्ट को कोई नहीं फॉलो कर रहे, तो एओ मे नॉट गिव यू एग्जेम्पशन फॉर दैट ईयर। मैं कैंसिलेशन की तो बात ही नहीं कर रहा। AO may not give you exemption of that year because you have misused the fund, you are not following the object, or you have not accumulated the money under 11(5). इस वजह से वो मना कर सकता है। लेकिन अगर आप 1023C में रिटर्न भरते हैं, रिटर्न तो भरे यार, रिटर्न तो एक ही फॉर्म में जाती है, फॉर्म 7 में, चाहे आप 11-12 में हो या 1023C में हो, रिटर्न तो फॉर्म 7 में जाती है। आपने फॉर्म 7 में रिटर्न भर दी, आपको टिक करना पड़ता है। तो अगर 1023C में है, तो अगर आपका केस स्क्रूटनी में आ गया, गांधी जी केस स्क्रूटनी में आ गया, उस केस में अगर एओ को लगता है यू हैव मिसयूज्ड द फंड, यू हैव डाइवर्टेड द फंड, या आपने यूज कर लिए फॉर पर्सन रेफर टू इन 13(3), यू हैव नॉट एक्यूमुलेटेड अंडर 11(5), तो सुनिए, एओ आपको एग्जेम्पशन रिफ्यूज नहीं कर सकता ना, वो मना नहीं कर सकता। एओ को एक रिपोर्ट बनानी पड़ेगी। ही विल प्रिपेयर ए रिपोर्ट गिविंग द रीजंस for that and will send that report, refer that report to the Commissioner of Income Tax who had granted the exemption, कि kindly withdraw their approval, kindly withdraw the approval। ये कौन कर रहा है? एओ स्क्रूटनी कर रहा है। एओ को लग रहा है कि ये एग्जेम्पशन नहीं मिलनी चाहिए, एओ रिफ्यूज नहीं कर सकता। एओ को लिख के देना है कमिश्नर एग्जेम्पशन को कि इनकी अप्रूवल को विड्रॉ कर दीजिए। और कमिश्नर एग्जेम्पशन आपको अपॉर्चुनिटी ऑफ बीइंग हर्ड देगा, आपको बुलाएगा, शो कॉज देगा, व्हाई योर अप्रूवल बी नॉट कैंसल्ड, आप दीजिए। अब आपकी हियरिंग होगी, उसके बाद कमिश्नर अप्रूवल डिसाइड करेगा कि आपकी अप्रूवल को विड्रॉ करना है या नहीं करना। अगर तो अप्रूवल विड्रॉ नहीं करी, उसने कहा नहीं ठीक है, तो एओ is duty bound to give you exemption. AO के हाथ में कुछ नहीं है. AO is duty bound to give you exemption. उसके हाथ में कुछ है ही नहीं. लेकिन अगर विड्रॉ कर लिया अप्रूवल तो AO will not give exemption. तो पहला डिफरेंस देखा सर, वहां AO के पास पावर है क्योंकि वो रजिस्ट्रेशन वाला केस है. यहाँ AO को अप्रूवल कमिश्नर ने दी है. जब तक अप्रूवल विड्रॉ नहीं होगी वो कमिश्नर को उसकी एग्जेम्पशन AO को उसकी एग्जेम्पशन देनी ही पड़ेगी. ये क्लियर हो गया सर. अब दूसरा लेने जा रहा हूं. दूसरा डिफरेंस देखिए, आप 1023C में जो ऑडिट रिपोर्ट बनाते हैं वो उसका नंबर है फॉर्म नंबर 10BB, और जो आप 11-12 की ऑडिट रिपोर्ट बनाते हैं उसका फॉर्म नंबर है 10B. वहां 10B है या 10BB है. लोग ये भी गलती करते हैं और वो भरते 1023 से हैं, रिपोर्ट 10B की लगा देते हैं. फिर कहते हैं जी CPC पागल है, उसने कह दिया कि आपकी रिपोर्ट, आपकी रिटर्न डिफेक्टिव है. अरे पागल CPC थोड़ी है, आपने रिपोर्ट ही गलत लगाई है. आपको पता है कि आप 1023C में है तो रिपोर्ट का फॉर्म 10BB है. आप 11-12 में है तो रिपोर्ट का फॉर्म 10B है. आप गलत लगा रहे हैं. गलती का गाली उनको दे रहे हैं. मत दीजिए गाली, पहले अपने आप को सुधारिए, फिर दूसरों को देखना. यह सेकंड डिफरेंस है सर. तीसरा डिफरेंस सर देखिए, बहुत इंपॉर्टेंट है सर. ये गांधी जी सुनने वाला, अरविंद जी सुनने वाला है. एक है एक्सप्लेनेशन बिलो सेक्शन 11(1). उसमें क्या लिखा है कि सपोज यू आर फॉलोइंग मर्केंटाइल सिस्टम ऑफ अकाउंटिंग. सर आप मर्केंटाइल सिस्टम ऑफ अकाउंटिंग है. देयर इज अ इनकम विच यू हैव टेकन इनटू अकाउंट, क्योंकि मर्केंटाइल सिस्टम है तो इनकम आपने ले ली, बट इट हैज एक्चुअली नॉट बीन रिसीव्ड. फॉर एग्जाम्पल, मैंने एक FDR बनवा दी थी 5 करोड़ रुपए की और उसको 5 साल के लिए इकट्ठी बनवा दिया कंपाउंड इंटरेस्ट से. इंटरेस्ट में हर साल नहीं ले रहा. सो गांधी जी पहले साल इंटरेस्ट तो ड्यू होगा मुझे अपने, क्योंकि मर्केंटाइल सिस्टम है, मुझे अपने इनकम एंड एक्सपेंडिचर में लेना पड़ेगा. लेकिन इनकम तो आई नहीं, खर्चा कहां से करूं? पैसे तो है ही नहीं, तो कहां से अप्लाई करूं? आप एक अंडरटेकिंग दे सकते हैं इन फॉर्म नंबर 9A. प्लीज नोट द वर्ड फॉर्म नंबर 9A. इलेक्ट्रॉनिकली 9A भर देते हैं हम और भेजकर कर देते हैं कि आई कुड नॉट अप्लाई फॉर दिस रीजन. तो उसमें क्या होता है, और उसमें लिखा जाता है आई विल अप्लाई इन द ईयर ऑफ रिसीट और ईयर फॉलोइंग दैट. सपोज आपने 3 साल की FDR बनाई तो आप लिख के देंगे 3 साल प्लस 1 मोर ईयर, 4 साल तक खर्च कर दूंगा. अगर 5 साल की FDR बनाई, 5 साल प्लस 1 मोर ईयर, 6 ईयर तक खर्च कर दूंगा. 7 साल की FDR बनाई, 7 प्लस 1 मोर ईयर. तो इसको क्या करते हैं, इसका डीम्ड एप्लीकेशन मान लेते हैं, आपको एग्जेम्पशन दे देते हैं, क्योंकि आपने अंडरटेकिंग दे दी फॉर्म नंबर 9A में इलेक्ट्रॉनिकली बिफोर ड्यू डेट ऑफ रिटर्न. बाद में नहीं, बिफोर ड्यू डेट ऑफ रिटर्न आपने दे दी, हम आपको एग्जेम्पशन दे देंगे, डीम्ड एप्लीकेशन. फिर हम इंतजार करेंगे 5 साल प्लस 1 ईयर, 6th ईयर में अगर आपने नहीं स्पेंड की, या अगर आपने 3 साल की अंडरटेकिंग दी तो 3+1, चौथे साल आपने उसको अप्लाई नहीं किया तो उस चौथे साल की इनकम मान ली जाएगी और उसमें आपको टैक्स देना पड़ेगा जितना आपने अप्लाई नहीं किया. सर हम तो अप्लाई कर ही देते हैं, हम पिछला अप्लाई कर देते हैं, नए की अंडरटेकिंग दे देते हैं. हम तो ऐसे ही करते हैं, हमने तो कभी टैक्स दिया ही नहीं है. हमने मतलब आप सबने मिलकर. एक और उसमें भी है एक्सप्लेनेशन, किसी और कारण की वजह से, फॉर एनी अदर रीजन यू कुड नॉट स्पेंड दैट इनकम, उसके लिए भी एक अंडरटेकिंग दे दीजिए. इनकम आ गई है लेकिन सपोज 25 मार्च को आई, 31 मार्च को क्लोज हो रहा है, मेरे पास पैसे आ गए, खर्च करने का टाइम नहीं है. कहते हैं आप अंडरटेकिंग दे दो, आई विल अप्लाई नेक्स्ट ईयर. और आप अगर अंडरटेकिंग दे देंगे आपको अप्लाई नेक्स्ट ईयर, तो आपको ये एप्लीकेशन मानकर इस साल एग्जेम्पशन दे देंगे और अगले साल उसको अप्लाई कर दीजिए. नहीं अप्लाई करेंगे तो इनकम मान लेंगे. हम तो कर ही देते हैं, हम तो बड़े शरीफ आदमी हैं. पिछले साल वाली अगले साल कर देते हैं, अगले साल वाली लिख को अगले साल कर देते हैं. टैक्स तो हमने देना नहीं, हमने टैक्स थोड़ी देना है, लेकिन हम तो एप्लीकेशन दे देते हैं 9A में. और ये 9A बहुत जरूरी है ड्यू डेट तक. अब अलाउड नहीं होगा, पहले तो अब कभी भी दे सकते थे, अब ड्यू डेट तक फॉर्म भर के देना है. गांधी जी ये सेक्शन 1023C में नहीं है. सेक्शन 1023 अगर कॉलेज यूनिवर्सिटी है तो उसकी कोई FDR बनी हुई है और वो कंपाउंड है, मैं नहीं जानता, उसको अप्लाई करना ही पड़ेगा. उसको अप्लाई करना ही पड़ेगा। वो ये नहीं कह सकता आई विल अप्लाई नेक्स्ट ईयर और आई विल अप्लाई इन द ईयर इन विच आई रिसीव और ईयर फॉलोइंग दैट। सबसे बड़ी मुसीबत ये है, सबसे बड़ी मुसीबत ये है कि आपको अप्लाई करना ही पड़ेगा। अगर अप्लाई आपके पास पैसे नहीं है तो भी करना पड़ेगा, हम नहीं जानते। 85% अप्लाई करना ही करना है, 15% एक्यूमुलेट कर सकते हैं, ये तो आपको पता ही है। वो तो 11-12 में भी लिखा है 85-15%, लेकिन आपको अप्लाई करना ही पड़ेगा। ये डिफरेंस है सर गांधी जी, ये डिफरेंस है। तो ये 11-12 वालों को फायदा हो जाता है कि वो ये अंडरटेकिंग दे देते हैं। यहां पर तो अंडरटेकिंग दे ही नहीं सकता ना, तो मैं कह सकता हूं नेक्स्ट ईयर अप्लाई करूंगा, मुझे तो इसी साल करना पड़ेगा, ना ही मैं कह सकता हूं कि हाँ एक ही अंडरटेकिंग दे सकते हैं, वो जो फॉर्म 10 है कि भैया मैं अक्यूमुलेट करूंगा मोर देन 15% और उसके ऑब्जेक्ट बताऊंगा किस लिए अक्यूमुलेट किया, और मैक्सिमम एक्यूमुलेशन अलाउड है 5 साल, आपको मालूम है। सो वो फॉर्म 10 भर के हम अक्यूमुलेशन देते हैं ना सर, जो आप मोर देन 15% एक्यूमुलेट करना चाहते हैं। तो गांधी जी उसके लिए भी सुनिए, अगर तो आप 11-12 में हैं तो आपको ड्यू डेट ऑफ रिटर्न से पहले पहले वो फॉर्म देना ही पड़ेगा। अगर आपने डिले कर दिया तो आप एक्यूमुलेशन अलाउड नहीं होगी। लेकिन 1023C में ये लिखना भूल गए, इसलिए ये बाद में भी दे सकते हैं फॉर्म। ये वाला 11 टू आप 15% से ज्यादा एक्यूमुलेट करना चाहते हैं तो आप 1023C वाला ये फॉर्म बाद में भी दे सकता है। लेकिन 11-12 वाला ड्यू डेट तक दे दे तो मिल जाएगी, नहीं तो अब नहीं मिलेगी। पहले तो हम रिटर्न के वो प्रोसीडिंग के टाइम में दे देते थे, रीअसेसमेंट के टाइम पे भी दे देते थे, अब वो अलाउड नहीं है। ड्यू डेट रिटर्न से पहले पहले फॉर्म 10 अपलोड कर कर आपको एक्यूमुलेट जो किया है वो करना पड़ेगा। लेकिन ये बेनिफिट 1023C में है कि आप बाद में भी दे दीजिए। क्लियर हो गया सर? क्लियर हो गया। अब आया कॉर्पस डोनेशन। क्या होता है? वॉलंटरी कंट्रीब्यूशन विद ए स्पेसिफिक डायरेक्शन दैट इट विल फॉर्म पार्ट ऑफ द कॉर्पस ऑफ द ट्रस्ट। ये तो गांधी जी आपको मालूम है सही से, कॉर्पस डोनेशन। अब इस कॉर्पस डोनेशन में क्या लिखा है? कॉर्पस डोनेशन सेक्शन 11(1)D में माफ है। कहां माफ है सर? 11(1)D में। 11(1)D तो उनके लिए होता है जो 12A में रजिस्टर्ड है, और कॉर्पस डोनेशन 1023C में माफ नहीं थी और आपको अप्लाई करना पड़ता था 85 और 15, क्योंकि कॉर्पस डोनेशन को अप्लाई करने की जरूरत ही नहीं है, पूरा माफ होता है। लेकिन वो 11(1)D में है, 1023C में नहीं थी। लेकिन रुकिए, डलवा दी गई। अब डलवा दी गई है कि कॉर्पस डोनेशन 1023C में भी इस साल डाल दी है, वो भी थर्ड प्रोवाइजर के नीचे एक्सप्लेनेशन डाल दी है कि कॉर्पस डोनेशन 1023C में भी माफ हो जाएगी। ये डलवा दी गई सर, पहले नहीं थी। क्यों डलवाई गई इसका रीजन भी मैं बता दूंगा अभी थोड़ी देर में। क्लियर हो गया? ये क्लियर हो गया सर गांधी जी कि मैंने दोनों को कंपैरिजन कर रहा हूं। दोनों का फॉर्म वही है, 7 में रिटर्न भरनी है, लेकिन जब आप 11-12 में होंगे तो आपको वो टिक करना है, आप 1023C में तो युक्त करना है। आपके पास अप्रूवल है, आपके पास रजिस्ट्रेशन है, कईयों के पास दोनों है। ये सुनिए सर शुक्ला जी, दोनों के पास दोनों हैं। आपकी तो मैडम को भी सुनना चाहिए, जमुना जी होंगी यहाँ पर, मुझे पता है। उन कईयों के पास दोनों हैं। अब जब दोनों हैं तो वो क्या करते थे, कभी तो 1023C में चले जाते हैं और कभी का 11-12 में चले जाते थे। क्यों चले जाते थे? 11-12 में कॉर्पस माफ था, 1023C में माफ नहीं था, तो वो आपकी मर्जी करते थे। लेकिन रुकिए, अमेंडमेंट आ गई है, लेकिन पोस्टपोन करा दी गई है अगले साल तक के लिए। पहले ये 1/6/2020 के बाद अमेंडमेंट आ गई थी कि आपको एक तो री रजिस्ट्रेशन करना है, और आपको री रजिस्ट्रेशन करना है, और आपको ये बोला गया था कि आपके पास अभी एक ही होगा, या 11-12 या 1023C, दोनों नहीं हो सकते। लेकिन पहले से तो है, लेकिन ये 1 साल के लिए पोस्टपोन कर दिया गया। जो मैंने री रजिस्ट्रेशन के लिए कहा था, री अप्रूवल के लिए कहा था, पहले क्या कहा गया था कि 1 जून से 3 महीने के अंदर अंदर आप जो ऑलरेडी रजिस्टर्ड हैं या ऑलरेडी अप्रूव्ड हैं उसको अप्लाई करना है फॉर री रजिस्ट्रेशन और री अप्रूवल इन ए सिंप्लीफाइड फॉर्म। वो कोरोना आ गया, पेंडेमिक हो गया, इन्होंने डिले कर दिया कि जी फॉर्म निकालेंगे। अब कहा गया कि अक्टूबर से लेकर दिसंबर में करना है। अब फिर ये नया बिल आ गया और नया बिल जो पास हो गया उसमें कह दी गया ना। देखिए बड़ी इंटरेस्टिंग, आज सुनने वाली बात है, सारे सुने ध्यान से, ये सुनने वाली बात। सेक्शन 1023C में और 11-12 में गांधी जी क्या किया था कि इन्होंने 1 जून 2020 से कुछ प्रोविजन हटा दिए थे, कुछ प्रोवाइजो डिलीट कर दिए गए थे, कुछ सेक्शन डिलीट कर दिए गए थे 1 जून 2020 से, ये कह के क्योंकि अब नए प्रोविजन आ गए हैं तो पुराने प्रोविजन हम डिलीट कर रहे हैं। ये प्रोवाइजो डिलीट, ये प्रोवाइजो डिलीट, ये प्रोवाइजो। फिर इन्होंने एक टाइम दे दिया कि भैया अप्लाई जो करना है वो 1 जून से नहीं करना, 1 अक्टूबर से कर देना फॉर री अप्रूवल और री रजिस्ट्रेशन, 1 अक्टूबर दिसंबर तक कर देना। तो चलो हमने कहा कोई बात नहीं, वो प्रोविजन वही के वही रहे। अब इन्होंने कह दिया कि वो अगले साल करना, तो अब क्या करें, इस साल का क्या होगा? तो जितने प्रोविजन डिलीट किए थे ना, दोबारा इंट्रोड्यूस कर दिए, दोबारा आ गए सारे के सारे। जो 1 जून को डिलीट कर दिए गए थे, दे हैव बीन रीइंट्रोड्यूस्ड अप टू 31 मार्च। लोग पागल हो गए। जब मैंने वो बिल देखा, मैंने कहा ये तो पागल कर दिया, सारे के सारे डिलीट करके उसको कह दिया दिस विल बी सब्स्टिट्यूटेड बैक विद इफेक्ट फ्रॉम 1 जून। जिनको हटाया उनको वापस ले लिया। ये कौन सा तरीका है? ये कोई चाइना की आर्मी है जिनको कहा वापस जाओ, हमें तुम्हें आगे नहीं रखना है? उनको वापस ले गए, वापस सारे के सारे दोबारा आ गए वो प्रोवाइजो। और फिर क्या लिखा है? 1 अप्रैल से वो हट जाएंगे, 1 अप्रैल से सब्स्टिट्यूट कर देंगे। लोग मुझे कहने लगे सर समझ में नहीं आ रहा। मैं कहा तुम्हें क्या समझ में आएगा? मुझे इतनी मुश्किल समझ में आया तो तुम्हें कहां से समझ में आ जाएगा? वो पागल हो गए। ये क्या करा क्या कि सारे के सारे प्रोविजन जो डिलीट किए गए थे फाइनेंस एक्ट 20 द्वारा, सारे के सारे दोबारा री इंट्रोड्यूस कर दिए गए। ये जो नया एक्ट आया है रिलैक्सेशन एक्ट वाला, उसको सारा रिप्रोड्यूस कर दिया। मेरा तो इनकम टैक्स एक्ट जो मैंने बनाया था, अब उसका क्या करूं? क्योंकि इनकम टैक्स एक्ट में अब जब नया इनकम टैक्स बनेगा, पहले मुझे वो दोबारा डालने पड़ेंगे और डाल के फिर उसको दोबारा, क्योंकि हम तो उसको हटा दिए और उसको नीचे फुटनोट में डाल दिया था। अब फिर फुटनोट से वापस लाओ और फिर उसके बाद अगले साल उसको दोबारा लिखो और फिर उसको नीचे ले आओ और फुटनोट को ऊपर ले जाओ। ये क्या है? ये क्या हो रहा है? लेकिन ये बता दूं, अब क्या हुआ कि अब आपके पास 1 अप्रैल के बाद सिर्फ एक ही होगा, या रजिस्ट्रेशन या अप्रूवल। डिसाइड आपने करना है। अब 1 अप्रैल से 30 जून में आपको री अप्रूवल या री रजिस्ट्रेशन सबने अप्लाई करनी है जिनके पास थी। आप कहेंगे ये क्यों लिखा गया? ये मैंने करवाया था। संजय जी भी आ गए जरा सामने। मैंने क्या कराया, जब हम रीराइट कर रहे थे इनकम टैक्स एक्ट, तो मैंने उन्हें बोला सर हमारे यहाँ रजिस्टर्ड चैरिटेबल ट्रस्ट हैं, अप्रूव्ड चैरिटेबल ट्रस्ट हैं, लेकिन इनके पास रजिस्ट्रेशन नंबर या अप्रूवल नंबर तो है, लेकिन सर्टिफिकेट है 30 साल पुराना, 40 साल पुराना, या तो फट गया है या खो गया है, फाइल में है नहीं। आप रिटर्न भरते हो तो ये कहता है सर्टिफिकेट दिखाओ। रजिस्ट्रेशन नंबर तो मेरे पास है, अप्रूवल भी नंबर है, लेकिन सर्टिफिकेट नहीं है। वो कहता है मैं तो दूंगा नहीं, मुझे क्या पता ये आपका रजिस्ट्रेशन है, सर्टिफिकेट लाओ। तो मैं कहां से लाऊं? मैंने कहा सर इनको एक तरीका ढूंढ दो, मैं तरीका बताता हूं। तो क्या कर, मैं एक बार इन सबको कहो दोबारा अप्लाई कर दे, री रजिस्ट्रेशन, री अप्रूवल, कोई क्वेश्चन ना पूछना, कुछ नहीं, सिर्फ एक फॉर्म भरवाना, सिंप्लीफाइड, नेम, एड्रेस, पैन नंबर और आपका रजिस्ट्रेशन नंबर या अप्रूवल नंबर, और आप 1 महीने के अंदर अंदर इनको दोबारा ऑनलाइन यूनिक आईडी, अब तो ऑनलाइन होगा ना सारा इलेक्ट्रॉनिकली, इनको एक यूनिक आईडी दे देना ताकि फ्यूचर में कभी खोएगा भी नहीं और सबके पास नया आ जाएगा, और जो हमें एओ तंग करता है वो तंग नहीं करेगा। और आगे से तंग करना नहीं है, फेसलेस असेसमेंट है, हमारी सुनना किसी ने नहीं है। पहले तो फिर भी हम सुना दिया करते थे, समझ गए ना, अब तो सुना ही नहीं सकते। तो हमने कहा भाई यूनिक आईडी दे दो, और यूनिक आईडी मिल जाएगा तो उनके पास अब दिक्कत नहीं होगी, आपके पास भी रिकॉर्ड होगा, हमारे पास भी रिकॉर्ड होगा। तो ये मेरी बात मान ली थी। लेकिन मैंने तो मनाई थी, गए थे ईद मनाने, गांधी जी रोजे गले पड़ गए। मैंने कहा था ये वाला कर दो, लेकिन इन्होंने पता क्या किया है, अब री अप्रूवल री रजिस्ट्रेशन तो करेंगे, लेकिन आगे से जो आपको सर्टिफिकेट या अप्रूवल मिलेगा उसकी वैलिडिटी 5 साल होगी। 5 साल। मैं कहा मर गए, कहता रहा हूं, गए थे ईद मनाने, रोजे गले पड़ गए। हर 5 साल बाद रिन्यूअल के लिए अप्लाई करना पड़ेगा विद इन 6 मंथ प्रायर टू द एक्सपायरी ऑफ 5 ईयर। 4.5 साल से पहले आप रिन्यूअल के लिए अप्लाई करो, और उस वक्त वो सारी चीजें पूछेंगे जो फ्रेश रजिस्ट्रेशन के लिए पूछते, रगड़ देंगे उस वक्त। हर 5 साल बाद रिन्यूअल। लो जी, अब मैं क्या करूं। लेकिन ये पोस्टपोन हो गया। पोस्टपोन क्या किया? अब 1 अप्रैल से 30 जून के अंदर आपने अप्लाई करना है, री रजिस्ट्रेशन, री अप्रूवल, फिर आपको मिलेगा 5 साल के लिए, फिर री रिन्यूअल कराना है 5 साल के लिए, चाहे वो अप्रूवल है चाहे रजिस्ट्रेशन है। लेकिन रुकिए, मैंने क्या कहा कि ये वाला केस हो गया तो उन्हें ये भी लिख दिया आगे से दोनों नहीं रखेंगे, या तो इधर जाइए 1023C में या इधर जाइए 1112 में। किनको नुकसान हो रहा है? कॉलेजेस, यूनिवर्सिटी, हॉस्पिटल, मेडिकल इंस्टीट्यूशन। उनको डिसाइड करना पड़ेगा कि वुड दे लाइक टू रिमेन अंडर 1023C और वुड दे लाइक टू गो अंडर 1112 एग्जेम्पशन। क्योंकि 1112 में कई चीजें फायदेमंद हैं, 1023C में कुछ बेनिफिट है, कुछ नुकसान है। सबसे बड़ा नुकसान 1023C में फॉर्म 9A वाला है। 9A वाला, जिसकी तो कैश सिस्टम है उसको तो प्रॉब्लम नहीं है, जिसको मर्केंटाइल सिस्टम है वो तो मारा जाएगा। कोई कंपाउंड इंटरेस्ट का करा दिया या उसने नेक्स्ट ईयर कहा मैं खर्च करूंगा, तो उसके लिए पॉसिबल नहीं होगा। तो ये क्लियर हो गया सर। यहां तक ये सारा का सारा जो भी प्रोसेस था, जो आपने अक्टूबर से दिसंबर तक करना था, वो पोस्टपोन कर दिया गया अगले साल के लिए 1 अप्रैल से 30 जून में। ये क्लियर हो गया। इवन 80G का जो सर्टिफिकेट था अप्रूवल, उसके लिए भी री अप्रूवल के लिए अप्लाई करना था 80G का, उसको भी पोस्टपोन कर दिया गया है अरविंद जी नेक्स्ट ईयर में। वो भी पोस्टपोन हो गया, पुराना चलता रहेगा। लेकिन वहां पे भी तो मार दिया। अब जो भी एग्जेम्पशन मिलेगी अगले साल वो 5 साल के लिए मिलेगी, फिर रिन्यूअल करो। मर गए ना, काम बढ़ गया आप लोगों का, कोई बात नहीं, वो काम बढ़ गया, लेकिन क्लाइंट के लिए तो मुश्किल हो गई ना। एवरी 5 ईयर अप्रूवल, एवरी 5 ईयर रिन्यूअल, ये कराना पड़ेगा, याद रखिए। अभी तो मैं बड़ा वार्न करता था, लेकिन अब मैं वार्न नहीं कर रहा। अभी आपके पास टाइम है, 31 मार्च के बाद अप्लाई करना है, अप्रैल से जून तक। लेकिन जब अप्लाई करेंगे तो एक ही में अप्लाई करेंगे, या 1023C या 1112। अब दोनों में नहीं होगा। अगर आपको बाद में लगता है गलती हो गई तो आप एक बार चेंज करवा सकते हैं कि आप इधर से इधर शिफ्ट कर दें, ओनली वंस इन द लाइफ टाइम। अदरवाइज डिसाइड कर लीजिए, अपने लॉयर कंसल्टेंट से पूछ लीजिए मुझे क्या करना है, और वो फाइनल है। ये समझ में आ गया सर? दोनों के डिफरेंस मैंने बता दिए। ये समझ में आ गया सर, दोनों के डिफरेंस? आइए अब आगे बढ़ते हैं। अगला पॉइंट, मेजर पॉइंट जो अगला है वो ये मैं आपको बताने जा रहा हूं कि provisions of section 40AI(a) and 40A subsection 3 and 4 shall mutandis will also apply to charitable trust. पहले चैरिटेबल ट्रस्ट ये कहा करते थे हम बिजनेस तो करते ही नहीं, तो हम बिजनेस नहीं करते तो जो 40IA में 30% का डिसअलाउंस होता है, क्योंकि आपने TDS काट के जमा नहीं कराया या काटा नहीं, तो आपका 30% डिसअलाउंस होता है सर। वो कहता है जी अब तो चैरिटेबल ट्रस्ट को भी लगेगा। अगर चैरिटेबल ट्रस्ट ने कोई पेमेंट करी जिस पे TDS कटना था, उसने TDS काटा नहीं, तो जितना भी एप्लीकेशन आपने किया 30% ऑफ दैट एप्लीकेशन शैल नॉट बी ट्रीटेड एज एप्लीकेशन ऑफ इनकम। आपको 30% पे टैक्स देना पड़ जाएगा। वो एप्लीकेशन माना ही नहीं जाएगा अगर आपने TDS काटकर ड्यू डेट तक जमा नहीं कराया। समझ में आ रहा है सर? वो तो अब आपका रूल बन गया कि TDS काटकर ड्यू डेट तक जमा करा दी, ड्यू डेट ऑफ रिटर्न तक नहीं, ड्यू डेट रिटर्न तक करा दीजिए, नहीं तो 40IA लग जाएगा, 30% नहीं माना जाएगा। इसी तरह 40A(3) अगर आप पेमेंट करते हैं कोई भी रेवेन्यू की या कैपिटल पेमेंट करते हैं and the amount of payment exceed ₹10,000, it should be made in a day. It should be made by account pay check or account pay draft or through electronic clearing system or through any other electronic system as may be prescribed. अगर आप उसे नहीं करेंगे तो जितना भी अमाउंट 10,000 से ऊपर किया है, सारा का सारा अमाउंट, आपने एक 20,000 रुपया खर्चा कर दिया, पूरा का पूरा अमाउंट आपका नॉन एप्लीकेशन माना जाएगा, मिस एप्लीकेशन माना जाएगा और आपसे टैक्स देना पड़ेगा। पता ही आपको क्या मतलब है। लोग क्या करते थे, पैसे निकाल के रख लेते थे कैश, क्योंकि ट्रस्टों में क्या होता है, मेरा ट्रस्ट। सपोज अरविंद शुक्ला जी ने ट्रस्ट बना दिया एक कॉलेज, तब शुक्ला जी कहते हैं मेरा कॉलेज। शुक्ला जी आपका कोई कॉलेज नहीं है, ये पब्लिक एट लार्ज का कॉलेज है, आपका कुछ भी नहीं है। आपने तो एक बार दे दिया तो भूल जाओ कि आप डोनर हैं। लेकिन लोग कहते नहीं नहीं मेरा कॉलेज है, ये तो मेरा कॉलेज है। लोगों ने तो पुराने जमाने में कच्चे का पैसा सारा का सारा कॉलेजेस में लगा दिया, हॉस्पिटल्स में लगा दिया, जब तक अनोनिमस डोनेशन नहीं होती थी। सारे यही करते थे। और हर कॉलेज के पीछे, हर मेडिकल इंस्टीट्यूशन के पीछे कोई ना कोई पॉलिटिकल लीडर है, मैं इससे ज्यादा नहीं बोलूंगा। उसका पैसा लगा हुआ है, 1000 करोड़ रुपया लगा दिया, 500 करोड़ लगा दिया। किसी ने पूछा कहां से आया, कहता जी पता नहीं, गुल्लक में को डाल गया। तो एओ कहता था मैं इसको इनकम मानूंगा। कहता मानना क्या क्या, मैं खुद कह रहा हूं इनकम है, लेकिन मैंने अप्लाई कर दिया है, तेरे को एग्जेम्पशन देनी पड़ेगी। मैं तो खुद कह रहा हूं इनकम है, तू क्या कह रहा है इनकम है, मैं तो खुद कहता हूं। तो वो करते थे। फिर तभी तो अब एनोनिमस डोनेशन आया कि भैया नाम बताओ, डोनर का एड्रेस बताओ, सब कुछ बताओ। वो एनोनिमस डोनेशन कौन लाए, गांधी जी? ये पॉलिटिशियन ही लाए। क्यों लाए? कि इतने कॉलेज खोल दिए, इतने हॉस्पिटल खोल दिए, अब तो स्टूडेंट ही नहीं है, तो काम ही नहीं चल रहा था। अगर और कोई कॉलेज खुल जाते तो कंपटीशन बढ़ जाता। उन्होंने कहा एनोनिमस डोनेशन ले आओ, ताकि वायबल ही नहीं है कॉलेज कच्चे के पैसे के बगैर, तब आप कोई कॉलेज खोलता ही कोई नहीं। तो पहले तो नंबर 2 का पैसा सारा लगा हुआ है, अब इनको याद आया नंबर 2 का निकला लगा हुआ है, ये निकालेंगे बोगस खर्चे डाल के। क्यों नहीं निकालेंगे? पैसा तो आप ही है, मालिक तो अरविंद जी है, और अरविंद जी ने पैसा लगाया तो वापस निकालना चाहेंगे। हालांकि कहते तो चैरिटी के लिए दिया है, लेकिन फिर भी वो चैरिटी के लिए निकालना चाहते हैं। तो इसलिए उन्होंने कह दिया 10,000 से ऊपर की कोई भी पेमेंट है अकाउंट पे ही चेक से करना, अब निकाल के देखो। उधर से एनोनिमस डोनेशन कर दिया ताकि टैक्स कर देंगे 30%, तो धन्यवाद हो गया। बात को समझ रहे हैं? सो मेरा पॉइंट ये समझ लीजिए, ये वाला पॉइंट जो मैं आपको बता रहा हूं बहुत इंपॉर्टेंट है, ये पर्पस है। तो आइए, मैं जो कहने जा रहा था कि अगर 10,000 से ऊपर कोई भी पेमेंट करोगे, चाहे रेवेन्यू की हो चाहे कैपिटल की हो, इट शुड बी बाय वे अकाउंट पे ही चेक और अकाउंट पे ही ड्राफ्ट। अदरवाइज आपको पूरा का पूरा नॉन एप्लीकेशन मानकर टैक्स लगा देंगे। क्लियर हुआ सर? ये क्लियर हुआ? अब दूसरा पॉइंट देखिए, बड़ा इंपॉर्टेंट पॉइंट है। हम कहा करते थे कि हम चैरिटेबल ट्रस्ट हैं, लेकिन हमारी कुछ इनकम है जो सेक्शन 10 में माफ है। अगर सेक्शन 10 में माफ है तो उसको अप्लाई करने की क्या जरूरत है? वो तो एग्जेम्प्ट है, आपने एग्जेम्प्ट कर रखा है, तो अप्लाई करने की क्या जरूरत है? जैसे डिविडेंड आता था तो डिविडेंड 1038 में माफ था, तो एग्रीकल्चर आपको क्या अप्लाई करने? इन्होंने लिख दिया ना। अगर आप 11-12 में जाएंगे, सुन लो, या 1023C में जाएंगे, तो आपकी अगर इनकम एग्जेम्प्ट है किसी सेक्शन में तो वो नहीं मानी जाएगी, आपको अप्लाई करना ही पड़ेगा। सिर्फ एक इनकम छोड़ दी, एग्रीकल्चरल इनकम, उसको अप्लाई करने की जरूरत नहीं है। लेकिन कोई ऐसी इनकम जो सेक्शन 10 में माफ है, आप कहते थे सेक्शन में माफ है तो इसको अप्लाई करने की जरूरत क्या है? उन्होंने कह दिया ना, आपको अप्लाई करनी ही पड़ेगी। हम उसकी एग्जेम्पशन सेक्शन 10 में नहीं देंगे एक्सेप्ट 1023C। वो तो है ही है, 1023 तो एग्जेम्पशन आप ले ही रहे हैं, लेकिन 10 बाकी किसी सेक्शन में नहीं देंगे। इसलिए ध्यान रखना, कोई भी इनकम अगर सेक्शन 10 में माफ है एग्रीकल्चर छोड़कर, उसको भी 85% और 15% अप्लाई करना पड़ता है, वो नहीं होगी। अब एक सवाल आया गांधी जी और शुक्ला जी और संजय जी, मेरे से किसी ने पूछा सर ये 15% जो एक्यूमुलेट करना है वो ग्रॉस रिसीट का करना है कि इनकम का करना है? गांधी जी, इनकम का मतलब होता है आफ्टर एक्सपेंडिचर, वो तो ग्रॉस रिसीट नहीं है, तो किसका करना है? ये बहुत डिस्प्यूट होता था, बहुत डिस्प्यूट होता था। मैं बार बार इनको डिपार्टमेंट को कहता था क्या करार रखा है, ये इनकम कर रहे हो, और इनकम का लोग तो ग्रॉस रिसीट का करते हैं और आप इनकम कह रहे हैं, लेकिन वो मानते नहीं थे। अब इन्होंने क्या किया है, सुन लीजिए, आपका जो फॉर्म आया ना 7 फॉर्म तो नोटिफाइड है, नोटिफाइड तो बाइंडिंग होता है, उसमें कह दिया है कि 15% ऑफ ग्रॉस रिसीट का करना है। तो अब आपको दिक्कत नहीं है, आपको इनकम का नहीं करना, 15% ऑफ ग्रॉस रिसीट एक्यूमुलेट करनी है। Gross, please note the word gross receipt, not the income. Gross receipt includes everything. उसको 15%, चाहे वो इंटरेस्ट से इनकम आई, चाहे स्कूल में फीस आई, चाहे कोई और आया फंड, सब उसका 15% आप एक्यूमुलेट कर सकते हो, कॉर्पस को छोड़कर। कॉर्पस तो माफी है ना, उसका थोड़ी एक्यूमुलेट करना है, वो नहीं, कॉर्पस को छोड़कर जितनी भी आपकी रिसीट्स है 15% उसका एक्यूमुलेट कर सकते हो। अब जरा अरविंद जी सुनना, बड़ी इंपॉर्टेंट पॉइंट बताने जा रहा हूं, जरा सुनना। मेरी इस साल की ग्रॉस रिसीट 5 करोड़ रुपया है, 5 करोड़ सर, कॉर्पस को छोड़कर 5 करोड़ है। मैंने 4 करोड़ 80 लाख रुपया खर्च कर दिया, तो मैं कितना एक्यूमुलेट कर सकता हूं, कोई बताएगा? मैंने 4 करोड़ 80 खर्च कर दिया, 5 करोड़ की ग्रॉस रिसीट है, हाउ मच कैन आई एक्यूमुलेट? मुझे लाया गया 15%, तो कितना एक्यूमुलेट कर सकता हूं, कोई बता सकता है अनम्यूट करके?
75 लाख कर सकते थे।
आवाज नहीं, सॉरी मेरे निकल गया मेरा। हाँ जी,
75 लाख कर सकते थे, लेकिन 20 लाख बचे हैं मेरे पास।
नहीं सर, 75 नहीं कर सकते, उस पे लिखा है इफ देयर इज एनी अमाउंट सेट अपार्ट और एक्यूमुलेटेड, सो मच ऑफ द अमाउंट सेट अपार्ट एक्यूमुलेटेड व्हिच डज नॉट एक्सीड 15%, इफ एनी अमाउंट सेट अपार्ट और एक्यूमुलेटेड। आपने तो सेट अपार्ट, आपके पास तो बचा ही 20 है, तो आप 20 के ज्यादा एक्यूमुलेट कर ही नहीं सकते, ये 75 नहीं कर सकते। कभी सोचो, लोग करते हैं, अरे मैंने कहा कैसे कर सकते हो, करंट इनकम का 15% करना है। अगर आपने 5 करोड़ का 5 करोड़ खर्च कर दिया अरविंद जी, तो एक पैसा भी एक्यूमुलेट नहीं कर सकते, एक पैसा भी नहीं कर सकते। लेकिन अगर आपने 4 करोड़ खर्च किया तो आप 75 का एक्यूमुलेट कर सकते हैं, और 4 75 हो जाएगा, या तो 25 के ऊपर टैक्स दीजिए या फिर 11(2) का फॉर्म दीजिए। एम आई राइट? अगर 5 करोड़ है, आपने 4 करोड़ अप्लाई कर दिया, 15% 5 करोड़ का 75 ये भी ले लीजिए, 4 करोड़ 75 लाख, बाकी 25 बचा, उस 25 को या तो खर्च कर, या तो आप एक्यूमुलेट कर लीजिए 11(2) में, नहीं तो टैक्स देना पड़ेगा। ये क्लियर है ना? अब मैं इसी से क्यों समझा रहा हूं, सपोज करिए इस बार मैंने 5 करोड़ के बदले 5 करोड़ 40 लाख रुपया खर्च कर दिया,
बिल्कुल सही।
अब क्या होगा? अब क्या होगा संजय जी? संजय एडवोकेट साहब देखते हैं कि अब क्या होगा संजय जी? कहता है जी 5 करोड़ तो आपने खर्च कर दिया, तो एक्यूमुलेट तो एक पैसा भी नहीं कर सकते, एक पैसा भी एक्यूमुलेट नहीं कर सकते। तो गांधी जी वो 40 लाख क्या करूं? उसको हम लॉस नहीं कहते, ये पता नहीं लोग इसको लॉस कहते हैं, ये एक्सेस एप्लीकेशन है, एक्सेस एप्लीकेशन है ओवर द रिसीट। पहले कहते थे हमारे पास बहुत जजमेंट है कि जो इस साल की एक्सेस एप्लीकेशन है वो अगले साल की एप्लीकेशन मानी जानी चाहिए। उसमें शुरू हुई थी महाराणा मेवाड़ चैरिटेबल ट्रस्ट 164 ITR राजस्थान हाई गुजरात, उसके बाद कई जजमेंट आई, रघुवंशी चैरिटेबल ट्रस्ट गुजरात, इंस्टीट्यूट ऑफ बैंकिंग पर्सनल सिलेक्शन, इतनी जजमेंट आई, सारी की सारी कहते हैं आप अगले साल एप्लीकेशन मान सकते हैं, लेकिन डिपार्टमेंट मानता ही नहीं था, कहता था हम तो सुप्रीम कोर्ट गए हैं, हम नहीं मानते, हम तो नहीं मानेंगे, आपको तो अप्लाई नहीं करा तो वो गया क्योंकि आपने अप्लाई किया। मैंने कहा यार कैसे नहीं मानोगे सर, अब जजमेंट आ गई है सर। गांधी जी सुब्रोज फाउंडेशन, सुब्रोज फाउंडेशन सुप्रीम कोर्ट की जजमेंट है, SUBROS, सुब्रोज फाउंडेशन की जजमेंट आ गई, जिसमें कहा अगर आपने एक्सेस एप्लीकेशन किया है तो आप अगले साल की उसको मान सकते हैं एप्लीकेशन, अगले साल कैरी फॉरवर्ड करके उसकी एप्लीकेशन अगले साल की मान लीजिए। मुझे फोन आया, मैंने उनको फोन किया, मैं सर ये लॉ आ गया है, अपना फॉर्म चेंज कर लो 7, क्योंकि फॉर्म में तो कहीं लिखा ही नहीं है कि अगले साल की एप्लीकेशन माने। कहते कैसे चाल करूं? मैं कहा सुब्रोज की जजमेंट है, आप कैसे कहोगे कि सुप्रीम कोर्ट नहीं है? मुझे कहने लगा मुझे क्या पता आप कहां से खर्च किया। मैंने कहा कहां से खर्च किया, मेरे पास पड़ा हुआ है बैंक में, कैपिटल फंड है, जनरल फंड है, तो उसमें से खर्च कर दिया, तो तुम्हें क्या लेना देना? नहीं फिर तो आपने उसको खर्च किया तो आपने तो 15% की एग्जेम्पशन ले रखी थी, उसमें मैं कैसे दे दूं? मैं क्या बातें करते हो यार, बढ़िया की दुकान भी अच्छी होती है तुम्हारे से, तो ये क्या कर रहे हो तुम यार कि यार 15, अरे मैंने क्यों खर्च कर दिया एडवांस में, अगले साल की एप्लीकेशन मानो, तो उसमें क्या बात है? कहते अच्छा मान लेते हैं, लेकिन कोई कॉर्पस से करेगा तो क्या होगा? मैं कहा जी कॉर्पस की डोनेशन तो माफ होती है, उसको तो 15% देखते ही नहीं है, तो आप ये लिख दो कि कॉर्पस से नहीं होगा, अदर देन कॉर्पस का अगर है तो 15। कहता जी अलग अकाउंट बनाना पड़ेगा। मैं कहा प्रभु जी बना देंगे, पर लॉ तो लाओ, प्रभु जी बना देंगे, फॉर्म तो चेंज करो, अभी तक फॉर्म चेंज नहीं हुआ है, पता नहीं आ जाएगा। करेंगे, उनको करना पड़ेगा एक्सेस एप्लीकेशन। ये क्या तरीका है? तो अगले साल की एक्सेस एप्लीकेशन सबरोज फाउंडेशन में मान ली गई है, तो आप ले जा सकते हैं अगर इस साल ज्यादा खर्च किया। लेकिन कॉर्पस डोनेशन क्योंकि फुल्ली एग्जेम्प्ट है, तो गांधी जी उससे कोई एप्लीकेशन नहीं मानी जाती, उससे कोई भी चीज लो तो एप्लीकेशन नहीं मानी जाती। ये पहले बता दूं, आपने कॉर्पस डोनेशन से कैपिटल एक्सपेंडिचर किया या रेवेन्यू एक्सपेंडिचर किया, हम नहीं जानते, वो एप्लीकेशन है ही नहीं। कॉर्पस डोनेशन की एप्लीकेशन आप दो जगह थोड़ी माफ करा लोगे, पहले कॉर्पस डोनेशन माफ करा लोगे और फिर एप्लीकेशन माफ करा लोगे, ये तो पॉसिबल नहीं है ना। तो कॉर्पस वाली तो इसको एप्लीकेशन मत मानो, बाकी को एप्लीकेशन मानो। मान लिया मैंने, ठीक है सर, मान लिया ना, आप उसको एप्लीकेशन मान रहे हैं आपकी इनकम का, तो इसको एप्लीकेशन मान के अगर आपने एक्सेस कर दिया तो अगले साल की एप्लीकेशन मानी जा सकती है। ये क्लियर हुआ? ये क्लियर हुआ सर? ये सुब्रोज फाउंडेशन की जजमेंट मैंने आपको बताई। दूसरी, अरविंद जी, आपने कोई कैपिटल एक्सपेंडिचर खर्च किया, वो एप्लीकेशन माना जाता है, उस पर डेप्रिसिएशन नहीं मिलेगी,
नहीं मिलता,
उस पर डेप्रिसिएशन नहीं मिलेगी। अगर तो आपने कॉर्पस का अमाउंट खर्च किया तो कुछ भी नहीं मिलेगा, लेकिन अगर किया तो आपको डेप्रिसिएशन नहीं मिलेगी, एप्लीकेशन माना जाएगा। अगर आप डेप्रिसिएशन लेना चाहते हैं तो फिर इसको एप्लीकेशन मत मानना, एक चीज मिलेगी, दोनों नहीं मिलेगी। पहले तो दोनों लेते थे हम, चित में जीता पट तुम हारे, दोनों में हम ले जाते थे, लेकिन अब दोनों नहीं मिलती, अब एक ही मिलती है। या तो मानो एप्लीकेशन फुल कैपिटल एक्सपेंडिचर, या क्या मानो वो। ये समझ में आ गया? ये भी क्लियर कर दिया कि एप्लीकेशन नहीं मानी। अब आया अगला पॉइंट। अगला पॉइंट ये आया सर कि क्या हम बिजनेस कर सकते हैं 1023C में, 11-12 में? जी हाँ, कर सकते हैं। एक कॉलेज है सर, वो कैंटीन चला सकता है, किताबें बेच सकता है, यूनिफॉर्म बेच सकता है। एक हॉस्पिटल है, नीचे डिस्पेंसरी खोल सकता है, मना नहीं है, बिकॉज इट इज इंसिडेंटल टू द अटेनमेंट ऑफ द ऑब्जेक्टिव ऑफ द ट्रस्ट। कंडीशन सिर्फ यही है, separate books of accounts to be maintained. Am I right? And if it is more than a limit, tax audit required. उसके लिए टैक्स ऑडिट है, बाकी के लिए नहीं है। टैक्स ऑडिट रिक्वायर्ड है क्योंकि आप बिजनेस कर रहे हैं, बिजनेस अलाउड है। इवन उसमें भी मैंने बताया था 11-12 में, उसको छोड़कर, कौन से वाले को छोड़कर? advancement of any other object of general public utility where total receipt should not exceed 20%. बाकी में तो अलाउड है, it should be incidental to the attainment of the objective. मिस्टर राव देख रहे हैं कि ये मैं क्या कर रहा हूँ। राव साहब, मैंने आपका नाम लेना भूल गया, अब ले रहा हूँ। ये नेशनल वाइस प्रेसिडेंट और उनका नाम लेना भूल गया, शक्ल नजर नहीं आई, अब मैंने देख लिया तो मैं उनका नाम ले रहा हूँ। तभी तो कहता हूँ मेरे सामने रहो, बहुत फायदा रहेगा। फोटो दबा लोगे तो फायदा नहीं रहेगा, मैं आपका नाम लूंगा। तो चलिए राव साहब, थैंक यू, वेलकम बैक। अब आगे बढ़ रहा हूं, अब सुनिए, आगे सुनिए सर। मैंने आपको कहा कि आप बिजनेस कर सकते हैं इंसिडेंटल वाला, और आप सेपरेट अकाउंट्स बनाइए, हमें कोई ऑब्जेक्शन नहीं है, उसका जो प्रॉफिट आएगा उसको अप्लाई कर दीजिए, और हम कुछ कह ही नहीं। लेकिन एक चीज मैं आपको बताऊं, लोग क्या करते हैं सर, देखिए कोई इनकम को टैक्स कराते हैं ना, अब हाउस प्रॉपर्टी है, आपकी रेंट आया है उस ट्रस्ट को, तो अगर आपकी इनकम क्या मानी जाती है? व्हाट इज योर ग्रॉस रिसीट? पूरा का पूरा रेंट ग्रॉस रिसीट है, और उसमें एक्चुअल एक्सपेंडिचर अलाउड होते हैं, चाहे वो म्युनिसिपल टैक्सेस हो, चाहे वो आपके रिपेयर के हो, चाहे वो इंटरेस्ट के हो। आप ये नहीं कह सकते कि सर ये 30% डिडक्शन दे दो। अरे भैया, 30% डिडक्शन तो उसमें मिलती है इनकम में, या तो इनकम कमर्शियल सेंस में निकालनी। Income has to be computed in commercial sense. You will not get 30% deduction at all. You will get actual deduction of interest, actual deduction of municipal taxes, actual deduction of repairs and everything. लोग ये कहते हैं, लोग कहते हैं मुझे कैपिटल गेन हुआ ट्रस्ट वाले को, तो मैंने कहा क्या हुआ, फिर क्या करूं? कहता है जी इंडेक्सेशन दे दो। मैंने धन्यवाद, कोई इंडेक्सेशन नहीं है। आपने इनकम कमर्शियल सेंस में निकालनी है, आपने प्रॉफिट ऑन सेल ऑफ एसेट निकालना है। एक्ट में सर इतना कंफ्यूजिंग एक्ट है, 11(1)A में कैपिटल गेन लिख दिया। अरे भैया, कैपिटल गेन कहां से हो गया? प्रॉफिट ऑन सेल ऑफ एसेट है, लिखा हुआ है, चला आ रहा है, लिख दिया। हमने तो चेंज कर दिया नए लॉ में जो नया बनाया है, लेकिन पुराने में तो बेड़ा गर्क कर रखा है। कहते हमें कुछ समझ में नहीं आता, हम तो प्रोवाइजो डालते रहते हैं, प्रोवाइडेड दैट, प्रोवाइडेड आफ्टर दैट, प्रोवाइडेड आल्सो दैट, प्रोवाइडेड आल्सो दैट, प्रोवाइडेड आल्सो दैट, प्रोवाइडेड, डालो जाओ। उनको कहता हमें समझ में आता नहीं, हम करें क्या? तो ये तो पहले आपको बता दूं, समझ में नहीं आता। अब देखिए सर, मैं बहुत इंपॉर्टेंट चीज बताने जा रहा हूं, क्योंकि एक और जेंटलमैन मेरे सामने आ गए हैं, नाम पढ़ रहा हूं, रविंदर जी है, क्या नाम है? तो मैं एक बड़ी इंपॉर्टेंट चीज बताने जा रहा हूं। राव जी जरा सुनिए। आई वॉन्ट टू परचेज ए बिल्डिंग फॉर चैरिटी। 5 करोड़ की बिल्डिंग है शुक्ला जी, मेरे पास तो बैंक में 2 करोड़ पड़ा हुआ है, मैंने 3 करोड़ का लोन लिया इस साल, 5 करोड़ की बिल्डिंग खरीद ली। तो मुझे कोई बताएगा कि एप्लीकेशन कितनी मानी जाएगी करंट ईयर में? हाउ मच इज द अमाउंट ऑफ एप्लीकेशन? 5 करोड़ की बिल्डिंग खरीदी है तो हाउ मच? शुक्ला जी कह रहे 5 करोड़, मैं कहूंगा बिल्कुल गलत, बिल्कुल गलत। ये नहीं, ओनली 2 करोड़। जो 3 करोड़ आपने लिया वो लोन है, और लोन इज नॉट एन इनकम, लोन इज नॉट एन इनकम। शुक्ला जी, आपकी एप्लीकेशन 2 करोड़ है। लोग कहते हैं जी बैलेंस शीट में तो 5 करोड़ दिखाई है। मैं कहा अकाउंटेंसी को अलग चीज है, इनकम टैक्स अलग चीज है। अकाउंटेंसी को इनकम टैक्स में मत बोलो, क्योंकि अकाउंटेंसी ने इधर 5 करोड़ दिखा दी, 2 करोड़ का बैंक बैलेंस कम कर दिया, 3 करोड़ का लोन दिखा दिया आपने। यही क्या ना अकाउंटेंसी में तो 3 करोड़ का लोन, लेकिन एक्चुअली एप्लीकेशन 2 है। जब लोन को रीपे करेंगे और साथ में इंटरेस्ट देंगे तो वो एप्लीकेशन माना जाएगा। रीपेमेंट ऑफ लोन along with the interest will be an application and not 5 crore। और लोग सारे ही गलती करते हैं।
वेरी क्लियर,
क्या करूं?
वेरी क्लियर, बहुत अच्छा
है,
बहुत बढ़िया,
समझ में आ गए ना सर रीजन? क्योंकि इनकम 3 करोड़ इनकम नहीं है, वो तो लोन है, और लोन को अप्लाई करना कोई एप्लीकेशन थोड़ी है। लोन इज नॉट एन एप्लीकेशन, लोन को इनकम। सो लोन मांगिए, जब लोन की रीपेमेंट करेंगे ना शुक्ला जी, और साथ में कभी इंटरेस्ट भी देना है तो उसको एप्लीकेशन मानिए, क्योंकि हमें अकाउंटेंसी अलग है और इनकम टैक्स अलग है। सो 10B की रिपोर्ट जब जाएगी तो चार्टर्ड अकाउंटेंट को समझाता हूं, लेकिन वो भी गलती करते, वो कहते हैं सारे के सारा एप्लीकेशन है। जी नहीं, ओनली 2 करोड़ एप्लीकेशन। जब दोबारा रीपे करोगे तब एप्लीकेशन माना। अब एक और उल्टी चीज ले रहा हूं, सुनिए शुक्ला जी, मैं कॉलेज हूं और मेरे ऑब्जेक्ट में लिखा है कि मैं बच्चों को लोन दे सकता हूं एजुकेशन के लिए, और मैंने एक बच्चे को लोन दिया 5 लाख रुपए का एजुकेशन के लिए। तो बताओ क्या एप्लीकेशन है? रिफंडेबल है, लोन है तो रिफंडेबल होता है। पूरा 5 लाख रुपया एप्लीकेशन मान ली जाएगी, पूरी 5 लाख रुपया। लेकिन जब लोन वापस आएगा तो इनकम मान ली जाएगी। वाह, ये तो चीजें हैं सुनने वाली, समझने वाली। When you are advancing loan for education, it is your object, it is application. When you are getting back the money, it is the receipt. लोन जब वापस आएगा, अगर इंटरेस्ट भी ले रहे हो तो वो भी रिसीट मानी जाएगी। तो ये भी गलतियां करते हैं लोग। मैं तो बता रहा हूँ, चैरिटेबल ट्रस्ट में तो लोग करते हैं। हाँ जी, क्या कुछ कह रहे हैं कोई?
डॉक्टर आहूजा, काइंडली इफ यू कुड पॉसिबल काइंडली कंप्लीट विद इन 5 मिनट्स।
सर मुझे तो कहिए तो 3 घंटे बोलता रहूंगा, मुझे कहिए तो 2 मिनट में खत्म होने वाला है। अभी लीजिए, अभी लीजिए, अभी लीजिए सर, अभी लीजिए, अभी। I am going to conclude because you have other functions also. I am not denying that way. Now please, जब भी आप रिटर्न भरें फॉर्म 7 में, प्लीज, एक तो आपके पास पैन नंबर गलत है, आप कईयों ने एओपी का पैन ले रखा है। यू शुड हैव पैन नंबर ऑफ टी ट्रस्ट, लेकिन कईयों ने एओपी का ले रखा है। जब फॉर्म भरें तो प्लीज टिक करना कौन सा सेक्शन 1023C है, तो जो भी उसकी सब क्लॉजेज हैं, अगर सब क्लॉज 3 IAB कर दिया तो आपसे रिपोर्ट नहीं मांगेगा। सेक्शन 1023 VI करा, वो कहेगा पहले ऑडिट रिपोर्ट लगा। तो कई चीजें, फॉर्म 7 भरना है, कईयों के पास रजिस्ट्रेशन नहीं है या कईयों के पास अप्रूवल नहीं है, तो उनकी पूरी की पूरी डोनेशन टैक्सेबल है अंडर सेक्शन 56 सबसेक्शन 2 क्लॉज 10। 50,000 से ऊपर की कोई डोनेशन जितनी भी एग्रीगेट आई, सारी की सारी 1 अप्रैल 2017 के बाद उसकी इनकम टैक्सेबल है। तो मैं यही कंक्लूड कर रहा हूं, क्योंकि देयर विल बी मेनी क्वेश्चन फ्रॉम योर साइड, आई नो दैट। तो लीजिए, आस्क क्वेश्चंस एज मेनी एज यू कैन। थैंक यू वेरी मच।
सर कुछ देर और चल सकता था सर, 10 मिनट चल सकता था
सर। मुझे डर लगता है आपके क्वेश्चन को, मैं जितना बढ़ा लीजिए, जितने क्वेश्चन पूछने पूछ लीजिए, आई हैव नो प्रॉब्लम।
थैंक यू।
क्योंकि दोबारा बुलाएंगे नहीं आप, मेरे को कहेंगे ये तो टाइम लेगा मेरा, मैं नहीं हूं। मैं जितना कहूँगा उतने में कंप्लीट कर दूंगा. चलिए.
बिल्कुल सही है. Thank you very much, Dr. Ahuja, for the wonderful tackling of the subject and the nice deliberation. 2-3 issues I will like to, which are not on the subject. First of all, the organizers. I will request them that for the very important persons, the introduction may not be given, because they always within a week more figures are added to them, and you give the introduction 15 years, 20 years back, and even in the morning session also.
Oh, sir, it was a joke, sir. Please don't take it seriously.
The question is that the introduction of the person should be given very tactfully and very after taking all the inputs. In fact, they could have asked Dr. Ahuja also to give the introduction of biota so that proper could have come. So they should take care of the same in the future.
अगली बार से ड्रेस कोड भी बता दिया करे सर, मेरी को गलती हो गई थी इस बार.
नहीं. And Dr. Ahuja, after hearing you, I was feeling like I was sitting in the classroom and when teacher was teaching me. Because in fact, I will fully appreciate that I don't know the intricacy provisions of all the law, because I practice only in the High Court. So the provisions of the different clauses and all those things which are there, we don't deal with in it.
Obviously, sir, obviously.
We deal with only when the matter comes to before us. But you have explained very nicely the provisions of the Act and within short span. In fact, I know that the subject is very vast, so it needs a lot of time and energy. Now, only one thing, Dr. Ahuja, being a very big person, I am a baniya. So please don't leave the baniya ki dukan. That word I think is.
Sir, बहुत famous है बनिया की दुकान तो बहुत famous होती है.
But the controversy, in the words context it was said, I think that it should be not be there.
Sir, don't take it seriously. ये बातें करने वाली होती हैं. हम कई बार कहते हैं उसके 12 बज गए तो उसका मतलब ये नहीं है कि मैं उसको सुना रहा हूँ.
नहीं अहुजा जी, आपने तो बोल लिया.
12 बजे वाले को मैं समझा, उसको नहीं सुना रहा किसी को.
अहुजा जी, आपने तो बोल लिया. अब मैं भी तो अपनी फीलिंग बोल दूं, because
please
being the chairman, I also must explain my feelings, because I don't.
Please, welcome.
I always am the firm believer that I don't keep anything in my heart. Whatever is there, whatever I think, I explain, because I don't keep in my heart. As the same thing, the way you, because you explained that the things you don't keep in your heart, you always speak. As you said that certain persons who are not present in the webinar and they just close the video and all those things, that gives a difficulty. I fully appreciate, because the technical sessions, whatever is there, in the physical sessions also you will find that people are there very 50 or 70 are available, and rest all go here and there. They're not interested in learning and the subject. And when the person like Dr. Ahuja is available, then every person should take the advantage of it and should listen and should learn whatever is there. One thing was there, the Income Tax Act, new Income Tax Act, as I could understand, because I have a little idea of all those things, that Income Tax Act is being prepared by you, the new Income Tax Act. I hope and trust at least that whatever deficiencies are there in the present Act, they will be all taken care of by you.
They have been taken care, sir.
All the provisions would go, all the explanations would go.
Sir. There are about 555 sections in the new old Act. We have reduced it to 275 sections without any proviso. No proviso. Explanation is there. No proviso.
It is very harmful for the lawyers like us and the professional harmful. It will be a great harm caused by Dr. Ahuja to the lawyers by
मेरे को भी लगेगी ना, मैं भी तो अपने लिए कर रहा हूँ.
By deleting the provisos and the explanations. But I can assure you, Dr. Ahuja, that let the new Act come. The lawyers are there who can get the provisos and explanations added within 1 year itself by different judicial decisions. When they will come, then the provisos will be inserted, the explanations will be added, and it will become more complicated than what Income Tax Act is as on today.
पक्की बात है.
So you always take care of preparing something. When the new Act came, when the VAT was there, then we took it that every problem now VAT has come, so all India, everything is removed. Then the GST came, then we said that, oh, very good. Now one nation, one tax, things are over. And I think the GST now has become the most complicated and favorable subject for the tax lawyers who are present, arguing in the high courts at least. It may be difficult for the practicing lawyers who are practicing the department to get the implementation of the act and rules, but the lawyers, they are in a boon. And according to me, such a GST act, such an income tax act is always welcome. Now, practical difficulties which you have pointed out to the chartered accountants who are practicing and all those things, I think that will be a great help to them from the deliberations. They can understand the difficulties, they can understand the problems that they will be facing in the coming future, and how to tackle with it. I don't know what in fact, I've not understood. In fact, when you said that, what is the amount, somebody said 75 lakhs. I mean, for me, the 75 lakhs or 50 lakhs, it was one and same, because I have not money, because I don't deal with it. So the subject was not there, but you have made them understand fully by giving every example within the time framework. Even according to me, the given time framework was very short. The organizers should organize a full day webinar during taking your precious time. You're taking your precious time. They should organize at 2.5 hours in the morning and 2.5 hours in the evening a subject, and may invite you so that you may explain each and every subject on it. And I personally feel that I will be present there so that I can learn each and every proviso of the provisions of the act. I'm really grateful to Dr. Ahuja for his wonderful deliberations, and look forward meeting you again in some other platform and meeting you again. Now, if the queries, some questions and answers there, Dr. Ahuja is there. You can, some members, if you ask the questions, I think Dr. Ahuja will be glad to answer the questions.
Thank you, Dr. Saraf. मैं डॉक्टर आहूजा साहब ने बहुत अच्छी बातें कही और बहुत क्लियरली कई पॉइंट्स को एक्सप्लेन कर दिया. मेरे ख्याल से जितने क्वेश्चंस आए हैं उसमें कुछ क्वेश्चंस तो अपने आप आंसर हो गए हैं. 2-3 क्वेश्चंस मेरे पास जो लिखित आए हैं वो मैं करता हूं, उसके बाद क्वेश्चन आंसर चैट बॉक्स से लेंगे. सर, in a registered charitable trust, in accordance with the main object of providing medical relief to the poor and needy, can the medical services provided out of custom barriers of the country be considered as being in accordance with the aims and objects of the country? सर, नेपाल में भूकंप आया, किसी कंपनी चैरिटेबल ट्रस्ट में, वहां मेडिकल रिलीफ दी, उसका क्या?
देखिए ऐसा है, वहां लिखा है you have to spend the money for charitable purposes in India to the extent it is applicable in India. But if you have sent somebody for abroad for treatment, so that they have been very liberal in giving that exemption. Otherwise, let me tell you, relief to the poor, no poor is sent abroad for treatment. They are sent here only. They cannot afford to send that poor man to the outside country, you know. But it is basically for spending that money in India. That is there.
Dr. Ahuja, the bank transaction tax which is there now for withdrawal of the amount.
Section 194N, you are talking about more than 1 crore.
So whether that
more than 1 crore.
Whether that will be applicable in respect, whether that will be applicable in respect to a charitable trust also if they withdraw the amount?
Anyone, any person you withdraw except those given exemption, like government, like other, there is a list given for exemption. The others are supposed to, it is applicable to everyone.
I think I came across one decision of Madras High Court wherein it will not be applicable.
Decision, you may be doing anything. 194N is the new one. It is recently introduced.
No, 194N, I think one decision has come wherein it was, I came across.
They have again changed, sir. They have again changed the law this time from 1st October.
Okay. So 1st October to change now.
Sir, one more question. Registered charitable trust running a hospital provides treatment to the family members of the managing trustee and also spends substantial amount of medication, outsourced surgeons and expert consultations. लाखों रुपया खर्च किया.
Section 33 says that if you apply any amount for the benefit of the person referred to in Section 33, which includes the relative also, then that amount it is not treated as application of income. But there is a concession given that if you give this benefit of education or medical, only that part of income, whatever concession you have given, that will be taxable. The other will remain there. So 2 concessions have been given. That is for education. If in a school, some relative is taught and they are given concession, or in a hospital, some relative of the trustee or the person who has donated is treated, and instead of 5 lakh, they have charged 2 lakh, then that 3 lakh rupees will be taxable. if there is a concession. Otherwise, absolutely no problem.
Right, sir. Sir, a charitable trust was registered about 15 years back. Both 12A and 80G were there. For assessment year 10-11, it has an assessment order where 12A and 80G certificates are mentioned. However, the original certificates got misplaced and assessment proceeding for 15-16, the assessment or AO passed orders by treating the trust as non-registered, unregistered trust. Request to the CIT to provide duplicate copy of the original registration.
They don't have in the record. They don't have in the record.
Oh, don't have. Unka sab read out hoga.
And that is the reason we ask for re-approval, re-registration. But
so,
they will win the case. They will win the case. They will win the case without. Yeah, AO, sir, वो अब मैं कुछ बोलना नहीं चाहता इस वर्ड पे. AO को देना चाहिए था जब पिछले ऑर्डर हैं. How can he prove that it is not there? But you understand my point. But that's why faceless, don't worry. Now we are going to give you unique ID, and the moment you are given unique ID for registration, you will never lose it. They will also not know it, and you get it. That is the reason why this was, I suggested that let them apply once again so that the benefit may be given to them and they may not have to go for litigation for unnecessary things.
Right, sir. Sir, Q&A box में बहुत सारे सवाल हैं सर. क्या आप देखेंगे सर या कि
मैं आपको जोतने को जवाब दे दूंगा, लेकिन आपको टाइम देना है. मेरे को कहोगे मैं देख देता हूं, मुझे कोई दिक्कत नहीं है, लेकिन आप मैं क्या होता है, मैं क्यों नहीं पढ़ता, क्योंकि लोग कहते हैं जो इनको आता था उसका जवाब दे दिया, बाकी हमारा क्वेश्चन पढ़ा ही नहीं है, जान के कह देते हैं. तो इसलिए आप पढ़िए, आप पूछिए, मैं जवाब देता रहूंगा हर सवाल का. लोगों की आदत होती है, इवन टीवी चैनल में भी देखा है कि वो कह देते हैं यार इस सवाल का जवाब मेरे को नहीं आता, इसको मत पूछना, इसका नहीं आता मुझे मत पूछना. आप जो पूछना चाहते हैं पूछिए, मैं उसका जवाब दूंगा, लेकिन मैं खुद नहीं पढ़ूंगा इसी कारण से.
Okay,
चलिए.
Shukla ji, I think the time, because the next session will also be there. So आपने important questions तो आपने पूछ लिए जो पूछने हैं. Rest always you can subsequently contact Dr. Ahuja and take the answer, and thereafter you can circulate into the AIFTP journal, because I think now you must, it's 1:45 now. You have the next sessions also, and after some lunch break. So I think it's better now to conclude.
Okay, sir. I respect your feelings, sir. और हम लोग हमेशा सर प्यासे रह जाते हैं. आहुजा साहब जब भी आते हैं लगता है और मिल जाए और मिल जाए. और जैसा अभी डॉक्टर सराफ ने कहा भी, ये हम लोग को आपके साथ में पूरे दिन का सेशन होना चाहिए. हम कोशिश करेंगे कि जल्दी उसको भी किया जाए. तो सर इसी के साथ साथ I will request Mr. D.K. Gandhi ji to propose a vote of thanks for this session. Wonderful session. Sir, over to D.K. Gandhi. Gandhi sir?
Yes. Am I audible?
Yes.
Sir, respected chairman sir, respected Dr. Ahuja साहब, आज का सेशन, आज का जैसा हमारा इनॉग्रल सेशन था उसी तरह हुआ. इट वाज ए मास्टर ब्लास्टर इनिंग ऑफ डॉक्टर आहूजा एज यूजुअल. और सब लोग जानते हैं उनकी तारीफ में जितने शब्द कहे जाएं वो कम हैं, लेकिन एक छोटी सी बात जरूर कहना चाहूँगा मैं कि गिरीश का मतलब होता है हिमालय पर्वतों का राजा. तो जो इनकम टैक्स जैसा टफ सब्जेक्ट है उसमें वास्तव में वो हिमालय पर्वत की ऊंचाइयों को छूते हैं और उनके ज्ञान की हम सराहना करते हैं. वो एक आयकर में हिमालय पर्वत हैं. और हमारे जो चेयरमैन साहब हैं डॉक्टर अशोक सराफ, उनकी सिंप्लिसिटी के बारे में तो मैं बस इतना कह सकता हूं कि वो सबको ऐसा बना देते हैं कि मुझको कुछ आता नहीं है, मैं चेयरमैन हूं, क्वाइटली बैठा हूं, बट जब वो आते हैं अपनी पर तो सबको आत्मविभोर कर देते हैं, सबको खुश भी कर देते हैं और अपने ज्ञान की गंगा से अपने उसमें प्रभाव में सबको बहा ले जाते हैं. बहुत प्रिसाइज बात करते हैं. सो थैंक्स टू बोथ द लर्नर्ड चेयरमैन सर और डॉक्टर आहूजा सर, आपका बहुत बहुत धन्यवाद. हमारा सेशन को, हमारी आज की कॉन्फ्रेंस को सफल बनाने के लिए, प्रथम तकनीकी सत्र को बहुत अच्छा करने के लिए आप सब बधाई के पात्र हैं. पूरे नॉर्थ जोन की तरफ से, हमारी टीम की तरफ से और मैं व्यक्तिगत रूप से आपका बहुत बहुत सारगर्भित रूप से धन्यवाद करता हूं. डॉक्टर आहूजा का, डॉक्टर अशोक सराफ का, दोनों ही डॉक्टर्स का हमें केयर और क्योर मिला है इस सेशन में, बहुत पैशन के साथ, प्यार के साथ. बहुत बहुत धन्यवाद.
Thank you, sir. Take care. Thank you. All the best. Take care, sir. Thank you.
Thank you, Gandhi ji. Friends, an enlightening technical session comes to an end. Hope that our keynote speaker was able to quench your thirst for knowledge. Friends, it is said that knowledge has a beginning but no end. This was just the beginning. We have a short presentation by Tax Sutra, followed by lunch break. Please join us back using the same link at 3 p.m. sharp for the second technical session on GST, in which Tarun Gulati, senior advocate, is the keynote speaker. Over to Rupesh ji from Tax Sutra.
Thank you, sir. Thanks a lot. Thanks. So good afternoon to one and all. Today morning, I was there in the session when the judges gave the opening remarks regarding this AIFTP Virtual National Conference. It was just so beauty to listen to them, the views and the contribution has done by the AIFTP, and literally even if you ask me, more than 10 minutes talking about the Tax Sutra. It was like I have spent from morning till now reading the 151 judgments of the book which was published. Literally thanks a lot, Sanjay ji, for this opportunity. So see, Sanjay sir has told me very clearly that you have 15 minutes, but now I'm standing between you and the lunchtime. So frankly, I will not take you much time. I'll just give you I just like to inform you what Tax Sutra is and what we do. So we started this our Tax Sutra maybe it's all around 10 years now. And with the one objective is to give the quality to our readers. And I would request to go to the next page, please. Go to the next slide. Kindly go to the second slide.
Ravi, kindly manage the presentation, please.
Ravi, just kindly put the second slide. So till the time we have a slides. So see, Tax Sutra from day one, we have been doing our great work to provide a non-stop solution to all practitioners, whether it's direct tax, whether it's indirect tax, GST, or practitioners who are practicing exclusively on transfer pricing or company law, IP law, competition law. So mainly what we focus in Tax Sutra is to give a niche kind of, very niche kind of the content which one should read. See, we all aware, being you all practicing on taxes, we all aware so many rulings come from Supreme Court, High Court and ITAT. But being a practitioner, whether it's possible to read everyone, yes or no, that you need to answer. But however, what we do at Tax Sutra is, we selectively report the ruling which is on the principles. There has to be some principles. So, and more than reporting, we are known for giving in-depth analysis. Like if once like we have also proposed to give you all delegates the trial access for 7 days. So one who likes to access, either he can approach me or either he can approach my colleague Anupam Mishra, and he is reachable at 8882592922. I will repeat again. We are happy to provide all the delegates a complimentary 7 days access to our portals taxsutra.com, GST, transfer pricing, and lawsuitindia.com. So one can approach either me or my colleague Anupam Mishra. He is reachable as 8882592922. Now coming to the content of Tax Sutra. So what I was telling you about the quality. So if you read about the analysis, about the alerts, what we inform to you, it is well in depth. Even we inform you which ruling has been relied on for why, what's the reason. And then Tax Sutra has an exclusive feature which is called a litigation tracker. Raviji, can you go to third slide? So till that slide comes, Raviji, third slide, please. So till the slide comes, I like to explain what is litigation tracker. So litigation tracker is one of the content where we track and we report live proceedings from the court. Live proceeding in the sense, if any important matter is there before the court, we cover the live proceedings, we take a notes over there from there, and we inform to our all readers like what's happening in Supreme Court, High Court or Tribunal. Happy to inform you, like you must have read a landmark judgment which was passed by Justice Anita Sumant of Sutherland. So it was passed in the November month, where the single judge member Anita Sumant has allowed the cess transaction under GST regime. So I like to inform you yesterday, the day for yesterday, it came before the division bench, because in the month of January, it was stayed by division bench. So division bench hearing started day before yesterday, and we covered the live proceedings, and we have informed our readers what is the kind of argument, what kind of issues, and what is the SEC argument, revenue argument followed by the question asked by judges. So this kind of all happenings in the court also you comes to know. So I will not take you much time. As I said, it's a lunch time. You all must be waiting. So I'll say again, thanks a lot for the opportunity. Thanks a lot, Sanjay ji, and the committee members of AIFTP. If you require, if you like, if you love, if you want a trial access, please approach us. We are happy to provide you. I request committee members and Sanjay ji to provide our contact details to all the delegates. Thank you. Thanks for the opportunity.
Thank you, Rupesh ji. Thank you so much. But you have not shared about the discount you are offering to the delegates. You forgot, I think.
Yeah. So sorry. So we will be also offering a 10% discount on the subscription.
Thank you.
My pleasure. Thanks for the opportunity, sir.
Thank you, Rupesh ji. Friends, we will have our lunch break now. Please join at 3 o'clock sharp for the session on GST using the same link. Thank you.
Puneet, good to go. Start.
I think we can start now.
Yeah, Puneet, good to go. Start. Yeah.
Friends, a very good afternoon to all. Welcome to the second technical session of Virtual National Tax Conference 2020. Friends, the famous journalist Margaret Fuller used to say, if you have knowledge, let others light their candle in it. In that spirit of sharing, the Gyan Pravah continues. The from the audience, please send in any queries you have on the Q&A panel so that the same may be taken up by our panelists. The dais for the session is ready. The chairman for this session is a doyen of the legal fraternity and Pitama of AIFTP, Mr. PC Joshi Advocate. And the keynote speaker for the session is Mr. Tarun Gulati, Senior Advocate. I welcome you, sirs. The moderator for the session is the articulate chartered accountant, Mr. Siddheshwar Yellamali. I now request Mr. Siddheshwar to take over the proceedings. Over to Siddheshwar ji.
Thanks to the Master of Ceremony, Shri Puneet Kumar Singh ji, for handing over the proceedings to start the second technical session of the virtual tax conference. Good afternoon to each and everyone. Firstly, I would like to thank AIFTP North Zone organizing team for giving me an opportunity to moderate this great session. With 3 years since the implementation of major tax reforms, goods and service tax, most of the SMEs have started receiving notices and orders from the Goods and Services Tax Department. The organizers of this National Tax Conference have picked up the topic, which is apt and timely, all about show cause notice, adjudication, assessment, and appeal under GST. Before I hand over the session to the chairman and speaker of this session, I would like to give a brief introduction of chairman and speaker of the session. Shri PC Joshi ji, advocate, started practice in 1959 and enrolled as an advocate in 1962. He has been the president of All India Federation of Tax Practitioners, the Chamber of Tax Consultants, Sales Tax Practitioners Association of Maharashtra, Sales Tax Bar Association. He has also been national president of Giants International Federation. Presently, he is a member of its central committee. He has been honored as Man of the Millennium at the National Convention of the All India Federation of Tax Practitioners in 1999. In May 2004, Shri Joshi ji was invited by the Law Society of England and Wales as a speaker on VAT. He has attended various international conferences all over the world. In November 2009, Shri Joshi ji represented AIFTP at the International Conference at Manila, Philippines, where he was honored by the international known journal Newsweek by publishing his photograph on the front cover page. He has been an editor of Sales Tax Review and Income Tax Review. Shri Joshi ji has contributed a number of papers on sales tax and acted as a chairman on various seminars on sales tax and delivered lectures on sales tax all over India. Shri P.C. Joshi ji, sir, I welcome you to the session, sir.
Thank you and good afternoon to everybody.
Thank you, sir.
As I said, north, east, west, and south, and center. It consists of whole country. And today I am really happy to see that the participants are not only from only north, but it is from all over the country. And that is called AIFTP. And the credit goes to all my soldiers, all my people here, and all my members, ordinary members, whom I'm told that the participants enrolled are more than 3,500. It may be more, but then I'm sure the participants will be immensely, I would say, enriched by the knowledge of the faculty members shared by them without any cost and without any service tax. Because we are all professional people who are rendering service to all our fellow members without any consideration, though in the course of our business. And that is why we are covered by exemption category. And that is how these webinars are going on. Well, friends, we had in the past, as far as Federation is concerned, several during lockdown period. We had webinars, debates, discussions, workshops. Then we had conclave. Then we have Gnan Jyoti, then Gnan Sangam, and then now Gnan Pravah. And when you say Gnan Pravah, it is most appropriate in this sense that the flow of knowledge continues forever. The development of law continues every moment. Every moment there is a change. And particularly when the notifications, circulars, orders, and whatnot are being issued day in and day out as far as GST is concerned, it is very much necessary for all of us to understand the development of law, not only through the enactment, through the amendment to the Act and rules, but also through notification, circulars, orders, etc. Now, friends, as far as today's program is concerned, let me tell you, the session subject is only regarding adjudication, assessment, appeal, etc. But as far as inauguration session is concerned, I was really happy to see that all our members, we are those whom we have enrolled as members, they are now elevated. And in fact, there are people, there are all retired judges right from Supreme Court to other high courts also. Those who are also blessing us when they are watching the development of AIFTP in this sphere. Now more than 8,000 people. Now, as far as the subject is concerned, I would like to say a few words. What is appeal? What is assessment? What is adjudication? Now, if you see the adjudication part of it, the adjudication starts with the submission either by the SSC or by the department. Now, as far as the scheme of the Act is concerned, scheme of the GST Act is concerned, there is a taxable person, there has to be a taxable supplier, and then there has to be service which is received, or service or supply of goods received by some recipient. And all these transactions have to be for a consideration in course of business. This in nutshell is the basic principle which we have to carry out. But unfortunately, the Act also provide for what you call avenues for those persons who are aggrieved by the actions of the lower authorities, that is the proper officer or maybe the adjudicating advanced ruling authority. Because I always say advanced ruling authority itself is what you call initiating litigation initiating authority. I recognize that it is initiating litigation authority or litigation initiating authority. Because if you see, as of today, all orders by advanced ruling authority are always pro-revenue. And that is why I always recommend that there has to be some what you call independent authority, which can be called real authority of advanced ruling authority. But here is a case where the authority, advanced ruling authority is manned by departmental people. And those people who are trained to earn revenue, collect revenue, somehow or the other, twist it, ignore the facts, or don't consider the relevant factors, and then pass an order. That is called advanced ruling authority. And that is why I never advise any of my clients to go to advanced ruling authority at all. Don't make the pay whatever you want and ask for the refund. And if they reject, go and file appeal, etc. But that's a better way of going rather than going to advanced ruling authority. Now, as far as the subject is concerned, as I stated earlier, the assessment proceedings for a taxable person, for a registered taxable person, begins with the submission of the return. And that is what is held by long back as in the case by Supreme Court by M. Ghanshyam Das in 14 STC 976. They had held that as far as the registered is concerned, the proceedings of assessment begins with the submission of the return, where in case of an unregistered person, it begins with the submission of the, issue of the notice by the authority. Those who have not filed the return, notice has to be issued. That is called initiation of the proceedings. Now, initiation of proceedings, again, will be very much essential to bear in mind that which is the law that will be applicable as far as the proceedings for those period is concerned. Suppose the X rate is there during 2017-18 and that has been reduced or increased in 2018-19 and there is a law, then the return submitted by 17-18 will be governed, continued even in appeal and all throughout by the same law which prevailed during 17-18. This is settled by our good old judgment Husam Kasam Dada 4 STC 114, and the latest judgment on that point is the Nagpur bench or Bombay High Court judgment 73 GSTR 187, where the SLP by the department was rejected by the Supreme Court. So therefore, these are two basic things which we have to bear in mind while considering the proceedings and the law applicable. One, the proceedings begin with the submission of the return, and even if the order is passed later on after the amendment, even then the law applicable will be the day on which the return was filed. And that is a basic principle which you have to bear in mind, and that continues even today. So that is one aspect of the matter. And the second aspect of the matter is that if you are taxable, if you are liable to pay tax, and if you are not registered, then the notice will be issued, and then that will be the time when the notice is issued, will be the initiation of the proceeding, and that law will apply all throughout. And this is the basic two principles which I would like, and that was relevant as far as today's subject is concerned. Now, as the scheme is concerned, if you see Section 41.1, Section 41.1 read with section 16(1) provide that the person concerned has to adjust the input tax credit what he has paid while inward supply against the outward supply. Against the outward supply, whatever is payable, that can be adjusted against the input tax, whatever he has paid while purchasing or while receiving the service for the purpose of input. Now, input, according to me, it doesn't uh, relate to only input of goods only. According to me, if a job worker is there and he is rendering service, and which is also required for the purpose of preparing a particular item duly manufactured and then supplied after manufacture. According to me, this word input would also include the input tax paid on the services which I have received for the job worker or the worker, whatever is there, what I have paid. According to me, that input doesn't relate only to input which goes in the manufactured goods only. Input is a broadly item, and therefore it should cover both supply of goods as well as supply of services. That's one aspect of the matter, because I've seen the controversies where they have held, and one of the Gujarat, I think one of the high courts come down to this extent that you grant only set off to the extent of input of goods, and you don't allow set off for ITC for services. That is absolutely what you call discriminatory hit by Article 14. But that apart, according to me, that word input would include also input of services also. That's one aspect of the matter. And then, friends, when we see the assessment, now there are various types of assessment right from the provisions of law, where chapter 12 is concerned as far as our CGST is concerned. It starts with section 59 to section 64. All various types of assessments are there, and if the authority find, which I don't know, I mean, the authority will never find. Authority will find that the return is complete and correct, and then there will be no action. These are all what you call ornamental words which I have seen. No authority is satisfied with the submission of the return or what details you give, and therefore, according to me, that's a provision which we have to consider. And that's a part of the scheme. Then you have 73 and 74. Whatever is left out, if it is because of ordinary mistake or honest mistake, the 73 will come in. If it is fraudulent, or if it is with the connivance, or if it is with the view of avoiding the payment of tax or dodging the tax, then it 74 will come. So these are all provisions which call for issue of a notice for payment of tax, and then the proceedings are to be taken within a period of 3 years or 5 years, because 3 years is 73, 74 is 5 years. Then when we go to appeal, my first question, my first objection to these appeal proceedings is, unless and until you have an all India judicial service similar to Indian Revenue Service or Indian Administrative Service, the authorities who are manning the appellate authorities are going to be deciding, or it will be a stamping master of passing an order. Whatever the order is passed by proper officer will be subjected to stamp by the first appellate authority. Then you have to go to the tribunal and high court, etc. Then we can get the relief. But according to me, unless and until, and I mean that Indian judicial service should have the basic principles which are called out recently by the Supreme Court in Roger Matthews case, Roger Matthews versus South Indian Bank, 7518. Supreme Court has very elaborately considered how a tribunal should consist of, how it should be made. And then that is why I would say this is a judgment which all of you should read to understand how the independent mind should work. And then, you see, what they have stated is that the person's manning should be judicious, independent, unbiased, transparent, patient, open-minded hearing, noble human being with clean background. This is very important. They said with clean background. And that's what I would say it's a scarce commodity for all of us to consider. But that is how I feel that we also should agitate that we must have appellate authority and independent authority not connected with the department or the revenue at all. Because if you see the advanced ruling authority, appellate authority is again the commissioner. And then the commissioner is bound to issue, bound to confirm what AR has held. Therefore, I mean, the worst example which I've seen is that, division of a big land into plots by supply of say electric wires and electric cables, and then it is held that it is an infrastructure supply, and therefore it is taxable. It is not covered by land at all. This is something which is, according to me, incorrect judgment, incorrect order. But I'm sure that will be confirmed by the commissioner, etc. So, friends, my time is up. 10 minutes is over. But let me tell you, the appeal is a very vast subject, very vast subject. In fact, we have included appeal, first appeal, second appeal, then the appeal to High Court on, substantial question of law, then there is a Supreme Court. These are all the provisions of our law, right from 107 to 109B of the CGST Act. But suffice it to say for us is try to understand, read the law properly, independently. Don't go by what AR has stated or what X authority has stated. Apply your mind, and I'm sure the God-given computer will give you proper reply instead of relying on only man-made computer. Thank you very much.
Thank you, Chairman Joshi ji, for laying the foundation for the session. Before I hand over the session to Tarun ji, I'd like to give a brief introduction of Tarun ji. Shri Tarun Gulati ji is a designated senior advocate based out of Delhi and practices in the Supreme Court of India. He has a vast 25 years of experience as a lawyer and is also a qualified chartered accountant. He is widely recognized as a specialist in tax and regulatory litigation. Prior to his designation as a senior advocate by the court, he was managing partner at PDS Legal and headed the Delhi office of economic law practice. Tarunji recently succeeded in a widely spoken about case of Bharti Airtel, where the Honorable Delhi High Court allowed Bharti Airtel to amend its GST returns to enable 900 plus crore of refund. He is one of the first lawyers to appear in the constitutional challenges in GST. Tarunji was featured as one of the top 3 law firm partners in taxation in 2018 by Vahura. Tarunji was also featured as one of the top 10 most admitted lawyers in India in 2018 by legal magazine Inside Success. Tarunji was awarded as Asia Litigation and Dispute Practice Leader of the Year 2016 by International Tax Review, a widely recognized online international magazine on taxation. With this brief introduction, I hand over the session to the chairman sir and Tarun sir to take over the proceedings. Tarunji.
Thank you, Sureshwar. And first of all, thank you for inviting me to this session. The Madhya National President, past President, Dr. Saraf, Mr. Sanjay Kumar, who is the conference president, Mr. Arvind Gupta, co-chairman of the conference, Joshi ji, respected Joshi ji, who has always guided us. I've seen him in many AIFT conferences which I have attended in of this session. Thanks to Mr. Jagdish Nankani, who had introduced me to the AIFTP at least 15 years back, and his love and affection I have attended. He used to, in fact, drag me to the conference to say that you must participate in these conferences, and I have found them so useful. So Jagdish uncle has, in fact, led me to this path, and I'm really grateful to him for having brought me to this forum, which I really enjoy participating. Of course, this today is a very different feeling. It's an online conference, and like in the novels session, many judges spoke about what this pandemic is doing to us today, that we are sitting in our own offices and doing work, appearing in cases, etc. But I think it will not give the same feel as I appear. I think appeared in at least 10 different high courts during this pandemic online, including Supreme Court and different tribunals. I can say that this is an alternative for the time being because of the kind of serious, health issues that have been created by the pandemic. But it is certainly not a substitute. It is not a substitute. It can supplement physical hearings, but it can never be a substitute. The physicality of a court hearing, the physicality of interaction is something which is missing, and if you have a very elaborate arguments to make, then I don't think this is the proper way of going about it. Similarly with conferences, whenever I've attended AIFTP conferences, it is such a it's a beautiful feeling to interact with hundreds of professionals from all over the country. And everybody comes together. It's not just the exchange of ideas, the exchange of knowledge. The personal interactions and all of that becomes so important, which is completely missing in an online conference. But AIFTP is such a vibrant organization that, even in these very difficult times, it is doing its best to keep the flow going. And this conference, the manner in which it has been organized, it is just wonderful to see how much we are trying to contribute and give back to the profession through the forum of AIFT. So I'm really thankful for being here, for being able to interact with you all in this session. We've spent 3 years now, plus 3 years plus in GST. And as we saw, the first 3 years, insofar as litigation is concerned, were more about challenges, constitutional challenges to GST provisions where they were palpably out of line, issues relating to credits which were being denied, Tran 1 issues all over the country. In fact, I was the first one to appear in Allahabad High Court, Justice Bharti Sapru's court. She, in fact, when she noticed this issue right on the first day to say that if there are technical glitches, and the word technical glitches came from there, from her judgment, to say that if somebody is not able to upload a Tran 1 form, how can you deny credit? Credit is something which is substantive in nature. And from there started the story of Tran 1 credits issue, and it went all around the country. Now you have at least 50 judgments, I think, of different high courts, some in detail, some summary judgments following other judgments on these issues. But now we are getting into the second phase of GST, where we are going to see now substantive issues which arise out of assessments, out of investigations will come up, and therefore the topic today, which is about show cause notices, adjudications, assessments and appeals, becomes absolutely relevant. And as Joshi ji said, it's the topical thing today and everybody should know. And one general remark before we dive into what all is there, and I think the topic is far too wide. And I think it can take hours together if you want to discuss these topics in depth. What we will try to do in this session is to concentrate, one, on the structure. How has the structure evolved? And second, what kind of provisions have been put in, and where are the pitfalls, where are the practical issues involved? We'll try and concentrate on these kind of issues for this session today. Now, as we all know that
GST is a melange or a sangam of various laws. You know, we were dealing with VAT laws, which were state legislations earlier. We were dealing with excise, central excise law, which was the central legislation for where excise duty was charged on manufacture of goods. We were dealing with a separate law of in relation to taxation of services under the Finance Act 1994. And we were dealing with a common SENVAT credit rules, which provided for a credit mechanism both for central excise and service tax. This was the structure which was divided, and there were several issues which arose because of the different buckets of taxes that people had to pay. There were issues of credits getting lost. There were issues of multiplicity of taxes, etc., which led to the formation of one common law. Although this is not a classical value-added tax, a classical value-added tax is one where there is only a single tax on output and credits flow completely freely so that the customer has to bear only that output tax. That is a classical value-added tax. Today, we still have a CGST, an IGST for interstate transactions, and SGST. And we have different buckets of credits. So it's not entirely a seamless system. And as we keep on going further, we have already seen amendments being made where restrictions are being placed on using credits. You will, with a priority being inserted to say that you will use IGST first, then CGST, and or SGST as the case may be. And all of this actually, they strike at the root of a value-added system where the entire purpose is that you avoid cascading of taxes and you allow the customer only to bear the incidence of the output tax. That should be the proper way of administering a value-added tax. Unfortunately, given the manner in which our federal system operates and the manner in which powers of taxations are divided between center and states, that is possibly not possible. But even within the possibilities, even within the realm of the possibilities that we have, what should be attempted is that the customer should bear on, and credit should never become a part of the cost of an enterprise. Because if credits become a part of a cost of the enterprise because their credits are not allowed to flow or not allowed to be used, then we are actually defeating the very purpose why we brought in a GST. This is where we are. This is how the GST law has been enacted today. And now in making this Sangam, if we look at the procedural side, which we have to deal with in today's session, facets of VAT and income tax law, facets of what was prevalent in central excise and service tax, all have been brought in together. And what will that lead to? We will see in the years that come. Now, as far as VAT and income tax are concerned, they were assessment-based proceedings in the sense that while we had a 143(1)(a) intimation process, and not in every case you would have a scrutiny assessment or thereafter a reassessment, but nonetheless it was an assessment-based proceeding. Wherever assessments were selected for scrutiny, there would be a scrutinized assessment, and thereafter, if there is income escaping assessment, a reassessment provisions were there. Insofar as excise and service tax is concerned, similarly in VAT, VAT also was an assessment-based proceedings, and there were provisions for audit, etc., which could lead to an assessment. So there were, regular assessments, audit assessments, reassessments, etc., in different VAT statutes. Insofar as excise and service tax were concerned, they were always basically self-assessment proceedings. There was nothing like an assessment at all. There were provisions for audit in excise and service tax, and then there was somewhat like a recovery or a recovery / reassessment kind of a proceeding, like under section 11A of central excise or under 73 of the Finance Act. That was the process in which it moved. Now, when we come to GST and we see what has been done, it seems that it's been made a complete hodgepodge. Complete hodgepodge. You pulled out elements from the excise and service tax, you pulled out elements from VAT, you pulled out elements from income tax. The result that I think is that this is going to lead to is proceedings coming in from all directions. And even if we see the manner in which audit provisions have been framed, I think going forward and the kind of trigger happy tax authorities that we have in our country, what we are going to see, I think the basic issue is going to be the multiplicity of proceedings that SSCs are going to face. And let's now see the structure, the broad structure of what this involves. And I want to concentrate, while show cause notices, appeals, etc., will have to be discussed, but I think the real meat of how one handles the proceedings is during the investigation phase. And what are the kind of powers that have been given to the authorities is what we need to look at. We start with section 59 of the CGST Act, which says that it will be the assessment will be a self-assessment, and your return filed under section 39 will be your self-assessment of tax. In these 3 years, we've seen that there's been a controversy as to what is the return under section 39. The government brought in a very aspirational scheme of invoice to invoice matching, of system-based reconciliation, and that is the Bharti Airtel case, which was mentioned about in my introduction, which we argued before the Delhi High Court. And that is what it related to, that you brought in by a statutory fiat a very elaborate scheme to say that this is how returns will be uploaded, this is how they will be reconciled, and this is how the final result, which will be final return, which will be auto-populated, will become your return under section 39. Very soon after implementation of GST in July 2017, I think the government realized that it is just impossible to effectuate the high aspirational statutory scheme which was envisaged. It was completely theoretical. It was not practical to be implemented, and they gave it up. And in comes in a summary procedure by form return 3B. Now 3B is not something what the statute contemplated. After a lot of disputes where many courts said that this is only summary, this is only interim, this is only provisional. In fact, notifications were issued saying it is provisional. Government comes out with a notification to say that that return itself will become the return under section 39. What is the implication of all this? Where are the SSCs going to, find solace? Where even after 3 years, the government is unable to determine what kind of returns the SSC will file. We still don't have formats for final returns. What happened to all your scheme of reconciliation? If it is a summary return, can that be the self-assessment return is the big question. So we start from section 59, which is riddled with ambiguity. Then we come to section 60, which talks about provisional assessments. Now, provisional assessments is something, at least in this section, is something where the SSC has a right to ask for a provisional assessment if the value is not determinable or the rate of duty is not determinable. But there is a limitation. Earlier, when provisional assessments were ordered, in fact, courts have said that unless a provisional assessment is ordered, you can't deem an assessment to be provisional. So if there is a genuine interpretational issue on value or on rate of duty, as Mr. Joshi has said, going to the AR is a fatality. It is a suicide because of the structure of the ARs and of the triple ARs. Because they're all government officers sitting there, and 98% of the ARs have gone against the SSCs. So the manner in which the structure of this whole adjudication and appellate authorities has been created, it seems as if there is no genuine relief available to the SSC until he gets to the High Court stage. I am saying that because the tribunal itself is not constituted today. Because of the constitutional challenges, we'll come to that later. And today, therefore, if somebody were to exercise the option of a provisional assessment, if it is ordered, how many assessing officers today will order it is the big question. If it is ordered, the limitation is that it has to be finalized within 6 months. You have to give bonds and sureties for the differential tax. Department will always say that the higher tax is payable. If you win, you pay the tax, differential tax with interest. If you lose, thankfully they have said that the refund will also be with interest. That is the structure of Section 60. But within 6 months, what will ever get settled is the big question. Even if you apply for provisional assessment, they will end up finalizing the assessment within 6 months, and that will lead to a demand. And in genuine cases also, you will be saddled with penalties, interest, etc., etc. All that will happen. That is Section 60. Then there are provisions of scrutiny of return. Now, this is where there is a diversion from excise and service tax and bringing in the concepts of income tax and VAT, that now you have provided for a scrutiny of return. What is a scrutiny of return? You have separate provisions for audit, and we'll come to audit. What kinds of audit? And audit is basically a scrutiny. So what is Section 61(1) for? Why have you brought in these provisions where an assessing officer has been given additional rights other than audit now to scrutinize returns and get into your books of accounts and do everything else? So additional provisions under 61 for scrutiny. Then let's come to, there are provisions under Section 62 and 63 for assessment of non-filers of returns, or where assessment for unregistered persons are concerned. These are akin to Section 144 of the Income Tax Act, where best judgment assessments would have been made. There were similar provisions in service tax also. So for non-filers also there is a provision. This is our enabling provision. One could have no grievance against that. Now, one important issue I think which needs to be flagged for all professionals is that they have also brought in now a process of summary assessment under Section 64. This was something which was not available earlier. And summary assessments, there are 3 ingredients under Section 64 which can be made. It has to be based on evidence. It has to be for the protection of the interest of revenue. And if the assessing officer who is recording those reasons feels that the delay may affect the interest of the revenue, he may make a summary assessment. What is a summary assessment? Now, this provision does not incorporate any provisions of natural justice. No provision for a hearing, no provision for a notice specifying the grounds why you have to make a summary assessment, and what will it lead to? In a situation where it leads to a huge demand, which according to the SSC is incorrect, what is the remedy available with the SSC? Can he ask? And when we come to the appeal provision, what we will point out is that look at the kind of pre-deposit provisions that have been made here. Earlier, at least in excise and customs and in service tax, the pre-deposit was 7.5% if it was a first appeal. Even if it went to the sestat, it was 7.5% in first appeal. And if it was a second appeal, 10%. These are the provisions subject to a maximum of 10 crores. What has happened in GST and what has changed at this time when GST was brought in? They have now put a minimum pre-deposit for first appeal as 10% and another 10% and 20% for second appeal. That makes it a cumulative of 30%. And the maximum amount of pre-deposit has been increased from 10 crores to 25 crores in first appeal and 50 crores in second appeal. And it is in addition to what you have paid in the first appeal. So the maximum is 75 crores today and 30% of tax. And in a situation like that, if you have a summary assessment where you have not been heard, where evidence has not been considered, and there is a demand, what happens to you? These are grave issues. I don't know whether this has been debated in any forum at all. What kind of provisions have been brought in under the CGST Act? In fact, really speaking, none of us have given attention to this when I was preparing for the seminar, for this webinar. For the first time, I myself looked at these provisions and I was aghast when I saw them. What kind of provisions have been put in here? how are they going to ultimately affect the professional, tax professional as well as the SSC? It's going to be impossible to deal with this. And the kind of approach that many courts have, hands-off approach, you can't actually approach a writ court in every other case. Courts have the tendency of relegating you to the alternative remedy. But is this kind of an alternative remedy going to be efficacious? Where 30% of mandatory pre-deposit, where the tribunal will not even have a power to waive it in any circumstance. You have a summary assessment kind of a situation where nothing is considered. And that mandatory pre-deposit goes up to 75%. Here again, 64(2) has a limited provision which says that on application within 30 days, the summary assessment can be withdrawn. But the caveat to that is that only if the joint commissioner or the assistant commissioner dealing with it feels that the order is erroneous. In our practice, all professionals will know how many assistant commissioner or joint commissioners will actually acknowledge that the summary assessment is erroneous. So it's a provision without any teeth. Really speaking, ultimately you will be forced to go and appeal to pay the pre-deposit, and many businesses will shut down because they are unable to pay the deposits where assessments are made on a best judgment without considering anything. So very serious kind of, I think, issues which arise on this. And I think one of the streams of litigation that we are going to see going forward is that many people will attempt, even if that attempt is a failure, but they will attempt going to the writ court to say that the alternative remedy is not at all efficacious. And I hope and pray that the courts see this in a light different from what is being seen till today. Because the provisions that have been made have become very, very onerous for SSCs. And if we see the track record, how many assessments ultimately get sustained right up to the Supreme Court? If we see the trend, many assessments, I think majority of the assessments, 80% to 90%, I dare say, of the assessments get diluted or get set aside, demands get set aside by the time the matters go up to the Supreme Court. In those situations, to expect the SSC to cough up 30% of the tax only to exercise the right of appeal is, in my view, very onerous. And if you have these kind of provisions of summary assessment, etc., then I think writ courts, I just hope, become a little more flexible and entertain writs. That's a hope. And I pray that this happens. Next provisions that I think we need to notice is audit. Now, audit again, at least the law recognizes 3 different audits. First audit is where you have to file an audit report by a chartered accountant or a cost accountant in GSTR 9C. So you have to voluntarily get your audit done. Second audit is by tax authorities under Section 65. Third audit is an audit provision which is provided for as a special audit, which under Section 66. There is a possible fourth audit, which we have seen in service tax, conducted by CAG. What we have seen in service tax is that you have multiple audits happening at the same time for the same period by different authorities, and SSCs are forced to go through that. There have been many challenges to these repeated audits which take place at the behest of SSCs. But earlier those challenges, in fact, got sustained, but in later times we've seen that courts have also become reluctant in challenging the issuance of a notice for audit. Let's see Section 65 first. Audit by tax authorities. Now, the audit for tax authorities can be made for any period, any frequency, in any manner as may be prescribed, subject to the rules to be framed in this. There is an option given under the section that it can be at the SSC's place or in the departmental office. Only 15 days notice is given. So the SSC may be going through whatever difficulty. If a notice for audit comes, you have to be ready in 15 days. Now, the explanation to 65, very important to consider this. It says that the commencement date when the documents, it is talking about, so the time period prescribed for audits is 3 months, and it can be extended for another 6 months for reasons to be recorded in writing. But when will that start ticking? That is given in the explanation that the audit is set to commence when it is when there is an actual institution of the audit at the place of the SSC, or a date when the documents which are asked for are made available. Now this is the start date, and the provision says whichever is later. What happens if the audit party, and this is bound to happen, gives a laundry list of 100 documents relevant or irrelevant? You can't submit everything together. So, and they will invariably find something or the other which you have not given. So the commencement date of the audit, therefore, is a flexible date. It is never going to end. 3 months and 6 months is there in the statute, but if the commencement is so flexible, then this can go on forever. One has to be very careful, therefore, to see that if a challenge is to be made, at least department should not get the opportunity to say that the commencement date has not started yet. The provision that has to be examined closely and seeing how, therefore, if challenges have to be made on limitation, how will you challenge? 65(6) says that the findings of the audit have to be made available within 60 days to the SSC. And 65(7) says that this can be made, therefore, a basis for a notice under section 73 or 74. So this can lead to a short levy wherever tax is said to be payable as a result of the audit report. Straight away, a notice under 73 or 74 can be issued. In service tax, a very good provision of pre-consultation was provided for. Now, when there is an audit, fine, you've been asked questions, you've replied and all that, and there is an audit report. Supposing the audit report is absolutely erroneous, they have failed to consider some evidence. The question that I'm asking is, should there not be a provision in the nature of pre-consultation which could have avoided the issuance of show cause notices? Because we know what happens when show cause notices are issued. 90% of the cases, they're going to be confirmed. If they're going to be confirmed, they're going to lead to an appeal, to a pre-deposit. So should there not have been a pre-consultation before the issuance of a notice under 73 or 70? Second, there is no hearing opportunity given. There is no provision for a hearing opportunity. Audit is an interactive exercise, but principles of natural justice are not at least engrafted in the statute here. Of course, where there are civil consequences, hearing it, courts will read into it, but that will lead to litigation. Somebody will have to challenge this provision. Somebody will have to challenge the notice for audit to say I was not given a hearing. And the courts may read into this provision principles of natural justice, as was done in C.B. Gautam's case. Constitution bench, chapter 20C was being challenged, Varies was being challenged. Similarly, in special audit under section 66, now very wide powers have been given. But one thing which is, I think, required to be noticed is that special audit, the 66(1) says that it can be ordered at any stage of scrutiny, inquiry, or investigation. And the reason why it can be actually it can be ordered is because if the officer notices that there's a complexity of the case and it is in the interest of the revenue, it can be ordered. And there are only two provisions when it can be ordered, where the value is not correctly declared or credit availed is not correct, is not within normal limits. Now, this is very different from the special audit provisions, say under income tax under 142(2)(a). 142(2)(a), if you compare, the power was very, very wide. It was expanded. You know, after challenges were made in Sahara India and in Rajesh Kumar's case, where court said that it has civil consequences, you have to give a hearing and it can be only on complexity of account, etc., etc. The section was amended to include nature and complexity of accounts, volume of accounts, doubt about the correctness of accounts, multiplicity of transactions of specialized nature, etc., interest of revenue, all these things were added. Now the power under section 66(1) of CGST is not that wide. And therefore, if special audits are ordered under 66(1), I think challenges will be open. Because the assessing officer has to come to a reasons to believe that the value is not correctly declared or the credit availed is not within normal limits. Now, this is a very specific power. It is not on general complexity of accounts. It is not on multiplicity of transactions or on a specialized nature of a business. Now, if your trend is, they'll have to calculate a trend, say on credit, to say that if your value addition is of the nature of 10%, if your credit is going beyond 10% and you're not paying cash at all, maybe they can order a special audit. Or if the value is completely disproportionate to what contemporaneous values are, maybe they can, but not in other cases. So here again, I think one will have to see, compare provisions and be conscious of the fact that the powers are limited. And if these powers are exercised, maybe a challenge is due. Now let's come to, I think before we get into show cause notices, etc., let's come to some portions of investigations. And powers, again, similar to what was there in the earlier law. Powers are extremely wide. And we start with how the investigation starts under GST and how it used to start in service tax. And given time frame, I'm going to summarize this. Otherwise, I think I've had different webinars in Punjab and in Delhi where we've spoken about these powers in great detail. And all I want to point out here is that it starts with the summons. There were at least 3 circulars which were issued in the service tax regime and in the excise context, one in 1989, one in 2007, and one in 2015, where the CBEC itself had very clearly said that summons should not ordinarily be issued. Summons is something where you are calling somebody who is not cooperating. If you want information, you can just write a letter. The department does not have to take disproportionate action against the SSC merely for calling for information. 3 circulars which clearly said that summons should ordinarily not be issued, and they should certainly not be issued against the top management of a company, because that amounts to a harassment. If I am a large public limited company, I am say a Tata company or I'm a Reliance, or even if not that big, I am a company of a very large order which has a large tax department. The tax people who are dealing with tax are ordinarily competent to answer the questions of the department. But just to create pressure, a summons is issued to a managing director. Should that be done? Circulars are there, although these are not circulars which are issued under GST, but I think they can be made use of. And SSCs should, and tax practitioners should try and see that their SSCs are not harassed by unnecessarily being summoned time and again. Certain very important principles have to be kept in mind. When summons are issued, these tax authorities, they exercise powers of a civil court and they can record evidence, which evidence will stick against these SSCs right up to the Supreme Court. And therefore, how should you guide your SSC when summons are issued? One, I think very important principle is one very short judgment of the Supreme Court called Ajit Jain versus DRI, reported in 102 ELT 521, where Supreme Court said that an SSC is not required to answer every question if he does not have the answer. You can't say that he has to jog his knowledge, jog his mind to come up with an answer. He is perfectly legitimately authorized to say that I don't have the answer presently. I will come back after checking records or after finding out. Today, the trend in investigation is that SSCs are browbeaten to give answers in a particular way, and because that will stick as evidence. Supreme Court has said that this is evidence. You have Ramesh Chand Mehta's case 110 ELT 324, where they have said that this is admissible evidence against SSCs. So SSCs will have to be careful in weighing their options while responding to questions. And tax practitioners should advise their SSCs that if you don't have the answer, you don't have to get browbeating. And now talking about browbeating, let's understand why the browbeating happens in these kind of proceedings. These kind of proceedings, the browbeating happens because along with powers of the civil court, now we have a toxic cocktail of powers by which these officers have been given the power of arrest also. And many offenses which are there specified in section 132 of the CGST Act have been made cognizable and non-bailable. And the threat of personal liberty being taken away is such a huge threat that SSCs will give right or wrong answers, voluntary or involuntary. It makes no difference. They fear arrest and they will have this. And I think at some stage, courts will have to understand that whether or not Ramesh Chand Mehta's case, which said that these statements will become admissible against SSCs, requires a review given the kind of both civil and criminal powers which have been given to these officers, who are tax officers. Will this power of arrest specified under section 69 become a reason for an SSC to give an involuntary statement is something which has to be tested. The reason why Supreme Court had earlier said that these are statements which are not statements before police officers, therefore the benefit of section 25 of the Evidence Act or the protections given under the article 20 or sub-article 3 or 21 or 22 of the Constitution of India will not apply to statements given to these officers was only because these officers were not entitled to file a charge sheet before a magistrate under section 173 of the CRPC. Now, given the fact, let's see what is the impact of these amendments which have happened from time to time. Given the fact that many offences have been made cognizable and non-bailable, arrests can be made by the CGST officers by knocking on the door of the SSC without the issuance of a warrant. The only safeguard is that you will get permission of a commissioner or a chief commissioner. How difficult is it to get a permission of a commissioner or a chief commissioner? We all know that. As tax professionals, we all know that it will be given for the asking. And while the department has all the right to collect the correct amount of tax, they have been given very wide powers to levy penalties. Interest has been made automatic, but how can you give the department powers to take personal liberties of the SSC, which will lead to the taking away of the voluntary character of statements which are admissible in law? It's a big question. And at least one, I think as tax practitioners, we should understand and we should advise our SSCs, what are those cases where offences have been made cognizable and non-bailable? There are only 5. First of all, the offence has to qualify for a punishment of 5, 3 or 1 year specified under section 32. And those are cases where the demand is more than 5 crores, 2 crores or 1 crore. Or in the case of 132(2), where it is a repeat offence. So 5 offences, without going into technicalities: 1 is clandestine removal, 2nd is fake invoice, 3rd is using credit on the basis of a fake invoice, and the 4th is collects but fails to pay the tax beyond 3 months. These are 4 or 5 offences only. So if as tax practitioners, our SSC's case does not fall under this, then first of all, the offence is not cognizable and not non-bailable. It's a bailable offense and it's non-cognizable. Therefore, you will have to necessarily take permission before arresting. So SSCs say there is a genuine interpretational issue on rate, or there is a genuine interpretational issue on value, or something like that. But SSC has raised invoice, there's no question of a fake invoice or anything else. Then it is for us to advise the SSCs to say that need not be overly concerned about arrest, because threats will come, invariably they will come, and therefore be careful in giving statements. One other safeguard, I think, which we must tell our SSCs, there is Justice Altamis Kabir's judgment reported in 345 ELT page 323 Supreme Court judgment, where Justice Kabir has said that the tax professional can be available. He cannot prompt the SSC while giving answers. But I think the physical presence of the tax advisor along with the SSC when he is summoned is a huge safeguard that we must keep in mind. That's available. Supreme Court has allowed it. Many high courts have allowed it. And that safeguard is an important safeguard when we advise our clients as tax professionals to keep in mind, to say and to cool their nerves so that they don't give wrong statements. Now coming to, sometimes what we see in this entire process, that proceedings are going in a completely southwise direction. They are just aggressive proceedings which are not justified. And the question often comes that should you challenge aggressive summons, repeated summons, where in a writ proceeding or not? The first answer to this is that whenever a decision is made to challenge a proceeding at the initial stage of summons, it is always going to be a difficult challenge. Like in criminal proceedings, a section 482 petition to quash an FIR or even a charge sheet is always difficult because courts say that it can be done only in exceptional circumstances. And the reason is the same reason in tax authorities as it is in a criminal proceeding, that at the initial periods of an investigation, no court likes to interdict an investigation because facts are not known. Even a court will not be able to know whether what the SSC is saying is correct or what the department feels that there is huge escapement of tax, etc., is something which is not correct. But there are some safeguards. There is a recent judgment of the Delhi High Court in National Building Constructions case 20 GSTL 515, where at least four circumstances where proceedings can be challenged have been delineated by the court. One is potent and gross misuse, ex facie grave and disproportionate hardship, inconvenience by other means, and malafide. If this is evident that any of these four circumstances exist, then perhaps it will be a case to challenge these proceedings even at the initial stage. There are other cases, especially two Jharkhand High Court cases, and so one is Sudhir Diora's case, which I think every tax professional should take care and note and read. 284 ELT 326 and TRF's case 293 ELT 172, two Jharkhand High Court cases where repeated summons were issued, people cooperated, still managing director was issued summons. Very few cases where courts have actually quashed such proceedings. These are two cases where it was done because the court found that this is unreasonable. That when SSC is cooperating, when everything is being done. In fact, I had the occasion to appear in a recent case in the Punjab and Haryana High Court, where something similar happened. SSC had cooperated, appeared 10 times, once not appeared, or he had sent his CEO who could not answer a question. The next day, they did a search at his place. Doing a search only to record a statement of a managing director. Immediately when we filed the writ and we pointed out the situation, The court appreciated it and quashed the Panchnama. They asked me, the court asked me, Mr. Gulati, now the search has happened. Why are you aggrieved by this? Of course, we said that we are aggrieved because this is disproportionate action. There is a doctrine of proportionality. Every action that is taken by the department has to be proportional to the wrong. It cannot be disproportionate. So I said, my lord, your lordship should quash this. You should quash it to send a message to the department to say that disproportionate harassment will not be tolerated. And they quashed it even without calling for a reply. Of course, there was imminent threat of arrest, and arrest was also stayed, but subject to the SSC cooperating. And that is what happens. And what needs to be kept in mind is these powers of arrest. In fact, one judgment of the Delhi High Court in Make My Trip, which has now been upheld by the Supreme Court also, has clearly said that these kind of powers under Section 69 should not be exercised prior to the issuance of the show cause notice. Court notes that Supreme Court has laid down the law to say that prosecution can be launched simultaneously with adjudication. But that does not mean that you can, even without issuing a show cause notice under Section 73 or 74, you can make an arrest. If the SSC is regularly filing returns, he is cooperating with the investigation, then these powers should not be exercised. And now this has been upheld by the Supreme Court. This has now also been applied in GST cases by the Madras High Court in Jayachandra alloys. Honorable Justice Dr. Anita Sumantu was there in our inaugural session. It's her judgment, beautifully written judgment, where she's followed the dictum in Make My Trip. And she said that this equally applies in the case of GST, whatever has been held in service tax. Equally, where there is a case of Akhil Krishan Magbu, 32, I think GSTL 516, Punjab and Haryana Code, where arrest provisions were being taken against tax professionals. Court has applied the same principles to say that these will not be allowed. These authorities, before issuance of show cause notice, cannot use arrest as a matter of recovery. These are not recovery provisions. These have to be used only in exceptional cases. And there are very strong observations made in Magbu's case saying power of arrest cannot be used to terrorize businessmen. Very strong cases. And these have to be kept in mind while we deal with the investigation phase before show cause notice has been issued. Coming now straight away, I'm not going to deal with search and seizure because I think that will take up the entire time of the session, whatever we have, because it's important to go into, some provisions in relation to show cause notices and appeals. There's some very important facets which have to be noticed, and I think we'll be failing in our duty if we don't deal with it. Search and seizure, again, there are very important principles to be dealt with, but I think we should keep that for another time because that is a subject which is going to take a lot of time in itself. Now, show cause notice, if you see, show cause notice provisions are, as Mr. Joshi had pointed out, in 73 and 74 of the CGST Act. Now, as we know that earlier under Section 11A or under Section 11A of the Central Excise Act or under Section 28 of the Customs Act or under Section 73 of the Finance Act provisions, later 73A also, the provision for issuance of show cause notice were there. And part of the very same provision was the extended period of limitation, which was if there was fraud, suppression, willful misstatement of tax with an intent to evade duty, the larger period of limitation, which was 5 years, could be invoked. What is different in CGST is that these powers have been now culled out separately in two sections. 73 provides for straight cases where there is no suppression, no willful misstatement, no intent to evade tax. Show cause notice has been issued. One very big change which has happened in 73, which was not there earlier, is that now this section prescribes a limitation not just for issuance of show cause notice, but also for adjudication. This was never there in excise and service tax. For adjudication, there was no limitation ever. So this is again making a mix of, what was prevalent in income tax and in VAT, where there was always a limitation for adjudicating under section 153, etc. of the Income Tax Act, and 149 also. There were limitations for adjudication. This was never there in excise. Now, here there is a limitation not just for issuing show cause notice, and the manner in which the limitation provision has been crafted is that the ultimate limitation given is for adjudication. In 73, show cause has to be issued 3 months prior to that limitation. And in 74, it has to be issued 6 months prior to that time limit. That is how the limitation provision is crafted. Like in service tax and in excise, there are provisions for mitigation of penalties if you were to pay duties along with interest prior to the show cause notice. So there are 3 stages. Both in 73 and 74, there are 3 stages that you could make a payment of the tax along with interest prior to the issuance of show cause notice. If it is a 73 case, no further proceeding, no penalty. If it is a 74 case, you will still have to pay some penalty. I think it's 15%. We come to 74 and we'll deal with that. But the question that I have in my mind, at least, is that which SSC will voluntarily pay duty along with interest to avoid the proceedings and also think that this is a case of fraud or suppression or a willful misstatement to attract 74 and not 73. It's a bit of a question mark that which SSC will acknowledge that it is a case of 74 and not 73. So it's a strange provision where you have different parameters for people who are paying duty even prior to the issuance of a show cause notice. So there is no allegation yet from the department that this is a case of fraud or willful suppression or a misstatement. But the SSC should himself assume, because what can happen that today I and SSC go and pay the tax and the interest on my own to avoid the proceeding. Assessing officer comes back and says, no, this is not a case of 73 and therefore I will still issue a show cause notice under 74. So all your good effort, your genuine effort of making a voluntary payment goes to waste because he says that it's a case of 74 and not 73. So somebody will have to weigh these provisions to see what is the impact of this. The first stage is that. Second stage is that you could still mitigate penalties by making a payment within 30 days of the receipt of the show cause notice. And this provision is there both in 73 and 72. That you could, if you find the show cause notice that the evidence cited in the show cause notice is something which is direct and you think that your SSC is well served by making a payment at this stage itself, you can actually help the SSC by advising them to make peace with the department by paying the penalty 15% of the 25% in 74, as the case may be, and before even testing it in adjudication. The third stage provided for is that even after adjudication within 30 days, you could still make peace with the department by paying the lower penalty, both under 73 and 74. So these are good provisions which are carried forward from the excise and the service tax provisions, and they will help, I think, in reduction of litigation if they were genuinely applied by tax professionals. One other thing I think which we...
Tarunji? Yes. Sir, you have another 10 minutes, sir. Then we have questions also lined up, sir.
Yes, we'll try and finish within 10 minutes. We'll quickly take, the appeal provisions also in 10 minutes, and then we'll take the question. But there are some very important issues, so I'll quickly,
I think, Gulati ji, we don't deal with appeal portion at all. That is a better way. Let us have another session for appeal.
Yes, I think
because that also is important.
Yes. No, we'll deal with the appeal provisions in a very summary manner if we have to. But anyway, let's go ahead with this. See, one other thing which I wanted to point out here as I go through these provisions is that 73, as we have seen, is a provision where there is no willful misstatement, no suppression, no fraud, no intent to evade. 73(11) still provides for a penalty that can be levied under 73(9). 73(9) talks about a penalty of 10% or 10,000 rupees, whichever is higher. So again, where are we coming from? In a situation where it's a 73 case and there is no question of a a fraud or a willful mistake, genuine mistake has happened and the self-assessment is incorrect. Why should you levy even a 10% penalty? And 73(11) says that if the penalty is leviable if the self-assessment tax has not been paid for more than 30 days. So why should you contemplate? Why should you not apply the Hindustan Steel principle to say that if a technical breach has happened, if a venial breach has happened, if there is no intent, this provision itself applies only in a case where there is no malafide. There is a genuine error. Then why should you apply this penalty provision? Of course, the other thing which has been done in section 74, I think in the explanation, earlier there was jurisprudence galore, I think, on what amounts to suppression. Tamil Nadu Housing Board's decision of the Supreme Court to say that intent to evade tax is a necessary ingredient. Lubricant, several other judgments to say that mere inaction of the SSC is not enough to allege. And those are really principles to invoke the larger period of limitation, where courts had said that the ingredients have to be suppression and a willful intent to evade tax. So in genuine interpretational issues, you would not invoke the larger period of limitation. Now here what has happened is, a good and a bad thing has happened. In explanation 2 of section 74, the word suppression has now been defined. Now by defining what is suppression, you have actually taken away the objectivity of judicial discretion, I would think, by taking away that discretion by which a court could say that this amounts to suppression or this does not amount to suppression. Now, the manner in which suppression has been defined in explanation 2 now. Two things: that if you had to give some information in a return or in a report or in a certificate to be filed with the department, which you have not filed or which is incorrect, that is suppression. And second, which is an extremely dangerous, I think, provision, to say that if some information has been called for in writing which you have not given, that also amounts to suppression. Now, the good thing in this is there used to be a Supreme Court judgment, a lone Supreme Court judgment in the earlier law, in the case of Gufic Pharma. I don't remember the citation offhand, but a case of Gufic Pharma, where Supreme Court had said that suppression can be only of something which you are obliged to disclose. So supposing there is an interpretational issue and you have genuinely felt that this is something which is not taxable, right? So supposing you are in the positive list scenario in service tax, you felt that this entry does not cover it. You could have relied on Gufic Pharma and said that I will not oblige to disclose this in my return because this is my bona fide feeling that this is not taxable. Now, the good thing is that that part is of Gufic Pharma is actually now part of the explanation that whether or not you were obliged to disclose it in a particular return is part of the statute itself. Second part, which is not so good, is that the department may want certain information in writing. It's not part of your return. Tomorrow in some audit proceeding or something, they ask for something. You've given something. That may or may not sit well with the department, but that can't amount to suppression. But this, by now statutorily defining what amounts to suppression. So whether it will be a case of 74 or 73, they have narrowed down the objective determination by a judicial authority or by a court by making it extremely narrow. So this, according to me, is a big change again from what we used to see in the service tax provisions and in the excise provisions and customs provisions. Again, coming back to what are the circumstances where show cause notices are issued? What are the circumstances in which one could advise a client to challenge a show cause even at this rate stage? Some classical cases are where you are challenging, where supposing a circular has been issued by the board, right? And there is nothing really left in the adjudication because authorities are bound by the circular. Okay, one other here, this is not related to adjudication or show cause, but I must point out one difference what has also happened in GST. Power to issue circulars is given under section 168 of the CGST Act. Always, if you see section 119 of the Income Tax Act or 37B of excise, central excise, or the parallel provision in service tax, the power to issue circulars by the board was always caveated by a proviso to say that it will not bind an appellate authority. Now that proviso is not being put in CGST Act under section 168. Although judicially, Supreme Court has said in several cases to say that appellate authorities cannot be bound by circulars, but this proviso should not have been taken away. It should have been enacted. We have seen, I've appeared in a recent case where we have challenged section 168 to this extent for the court to say that that caveat should be put in judicially if it has not been put in statutorily, that appellate authority should not be bound by circulars, because in that particular case, the appellate authority refers to a circular and follows it. So what is left of an appeal if an appellate authority is also feeling bound by a circular? So in a situation where there is a circular on this, show cause notice can certainly be challenged. There are cases of Vistar Construction, Delhi High Court 31 STR 129, 30 STR 689, 335 ELT 639, all Delhi High Court. Again, several judgments are there where they have said that if a circular has been issued, then a show cause notice can be challenged even at the show cause stage. Second, if it's an issue of limitation, one could try relying on the income tax case in Calcutta discount to say that it's a jurisdictional question and it can be challenged in the proceeding. Third, I think, is a very important judgment which I think many of us don't consider, where something which is without jurisdiction, we know that in one of the exceptions given in Whirlpool's case where writs can be filed is, and a proceeding is without jurisdiction. Supreme Court in Hindalco's case in 153 ALT 481 has said that if a show cause notice or a proceeding is partly within jurisdiction, partly without, then, and if the doctrine of severability does not apply, then the proceeding can be challenged. Very important principle. Of course, if you are challenging the varies of a provision also, then the show cause can also be challenged in that, and Supreme Court in Hindustan Zinc's case 303 ELT 321 has said that it is maintainable in such situations. Lack of jurisdiction, as I had mentioned, Godrej Sarali's case 2009 volume 14 SCC 338 again is a decision of the Supreme Court, says you can challenge show cause notices at that stage. So these are some cases. In some situations, Supreme Court has also said that supposing the commissioner or the person has already taken a view that a particular course of action should be followed, and the adjudication is happening by a lower officer, then again, the adjudication is absolutely meaningless. The decision is already taken by a higher officer. In that case, a writ will lie. And Supreme Court in Filterco's case, 24 ELT 180, has said a writ has to be entertained in a situation like that. So these are some cases. There are of course other cases where if a show cause notice is completely premeditated or vague allegations are being made. Again, there are several courts which have said that this should apply. Now, very quickly coming to the appeals provision. Appeals are contained in from sections 107 onwards. Now, again, in providing for these provisions, the department has again, and I think again a mix of what used to happen in service tax and excise and what happened in income tax and VAT has been brought in. Appeal 107 applies to any person who's agreed, with the phrase which has been used. 107.2 is a specific right to the department, which is given for departmental appeal. But along with that, now there is 108, which is a revision provision, which is quite similar to section 263 of the income tax. So where there is a decision is said to be erroneous and prejudicial to the revenue, a revision can be taken. Of course, there are safeguards there that it will not be exercised till the time of limitation for appeal, filing appeal is not passed, or where appeal has been passed, it will not apply. But one striking feature of 108 is, like in a 263 case, you could still go to the appellate tribunal. There is no appeal. In a 264 case where SSC files a revision, but against 263 orders, an appeal to the ITAT was maintainable. Now 108.3 says that if an order under 108.1 is filed, it is final and binding. It's a very strange thing that a revision is taken in a situation where a commissioner feels or the revising authority feels that it is erroneous and prejudicial to the SSC, and it becomes final and binding. The only recourse is to a writ court. So, in addition to departmental appeals, you have a revision provision, and here the limitation goes up to 3 years. So, even if they fail to file an appeal, a revisional power can be exercised. Again, very, very wide provisions have been provided for under 108.4, where this period of 3 years can be extended indefinitely, I think. If a case is pending of some other SSC before the High Court or the Supreme Court, then this period stands extended under 108 for extended for the period that it took time for the High Court or the Supreme Court to decide. All that jurisprudence which had evolved in that Simplex Concrete case, Austin Engineering, MEPCO's case, where the law was that reassessment proceedings or rectification proceedings or any proceeding on the basis of another judgment, assessments will not be reopened, goes out of the window. That if revisional proceedings can be taken and completed assessments can be reopened on the basis of another judgment, and even limitation will not apply and you are able to exclude, then one will have to see what kind of an arbitrary power is given to the authority. One concluding remark on appeals to say that I have already spoken about the kind of mandatory pre-deposits that have been created in GST. I think it is totally arbitrary. The amounts are too high. And while Supreme Court has upheld mandatory pre-deposit provisions, not just under tax, but also under DRT provisions and some other non-tax related legislation. But I think when we are talking about a 30% pre-deposit, with a final cap of 75 crores, 25 crores in first appeal and 50 crores in second appeal. I think personally that this mandatory pre-deposit without any recourse for a stay is very, very arduous and very, very difficult for people to comply and should be challenged. Today, we are in a situation where we are seeing in the CGST Act, Mr. Joshi had remarked in his initial comments that independence and judicial review is not something which the government has provided for adequately. You see, AARs, AAARs, they are all manned by revenue officers. Now, in 2019, there is a provision for creating a national advanced ruling authority, which is still not been formed, which will be manned by a judge. But that also has been restricted only for cases where the appellate authority for advance rulings in two different states has given conflicting judgment. Where will be the conflict? If 99% of the judgments by ARs and triple ARs are all negative, where is the question of conflict? So even if you are wanting to create a national authority, which will be manned by a Supreme Court judge or a retired High Court judge, you are cutting away its legs by saying that only in the case of conflicts, they will have jurisdiction. Now look at the manner in which they have formed the second appeal provision. That has been struck down by Madras High Court by excluding lawyers. Why are you excluding lawyers? As Mr. Joshi had said, Supreme Court in R. Gandhi's case, first of all, had laid down the parameters that should be there for banning tribunals. That the number of judicial members should always be more than technical members. In Madras Bar Association's case, again, it was reiterated. In Roger Matthews' case, it has been reiterated. Again, while in drafting, provisions for under the CGST Act, again you bring out provisions like that. What is the impact of all this? You have a national anti-profiteering authority, a first adjudication happening of serious issues which are manned only by bureaucrats and by revenue authority officers. And this is not an option-based jurisdiction. It is a complaint-based jurisdiction. Such important quasi-judicial, I would think they are judicial functions being exercised by revenue officers sitting there, by bureaucrats, and there is no appeal provision. Everybody has to go to the High Court, and we know the width of the writ jurisdiction. Only if there is a procedural or a process-related error will the writ court interfere. So while engrafting these provisions are even tax professionals being taken into confidence to say we are going to make these changes when we make these new laws, are the interest of SSCs being taken into account is a question that each and every one of us has to ask. National Anti-Profiteering Authority have appeared in many cases, and it's a disaster. It's a disaster. And it is a disaster because there is no judicial review and there is no judicial application of mind because there is no judicial member. Now, in Revenue Bar Association's case before the Madras High Court, a statement has been made by the central government to say that we are reconsidering the appellate tribunal provisions. We are going to look at the service rules. We are going to look at the provisions again. It will go back to the GST Council to see if we can follow the mandate given by the Supreme Court in Roger Matthews' case. Now, 3 years after CGST has come in, you don't have an appellate tribunal. Where are SSCs going to go? Of course, some cases, High Courts are entertaining writ saying that there is no tribunal. What will happen? Today, I'll tell you a genuine problem. What is happening today? Especially in refund cases, there is a provision under section 54 of the CGST Act, I think 5411. One appellate authority, first appellate authority, rejects a refund on an interpretational issue. Say, big issue is arising in the case of intimidation.
Sir, we have to move to the next topic.
Suresh, just 1 minute. This is very important.
Sure.
We'll go to just in 1 minute. Just give me 1 minute. This is very important for, I think, for our participants to understand this. In refund cases, what is happening is one appellate authority rejects a refund, and under 5411, there is a power to withhold refunds for all subsequent periods if there is an order which is against you, and if the matter is in appeal, further appeal. Now, there is no appellate tribunal. Even if they were to constitute an appellate tribunal, these kind of cases will not see the light of day in the next 2 years. There will be so much pendency. So what happens to the poor SSC who is filing refunds periodically? In a case of exporter, he has to file refunds for input taxes, etc. His business will be ruined. And today, when we are in the pandemic era, where people don't have cash, they depend on this cash flow. What is the government going to do about these kind of arbitrary decisions which are being taken even without a second appeal, without a tribunal which has been constituted. It's 3.5 years, and you don't have a you haven't applied your mind as to who will man the tribunal. First, you will apply your mind. You will go to the GST Council, then you will amend the act, then you will appoint the tribunal, then you will create the infrastructure, and then appeals will be filed and heard. So I don't know where we are going to see, relief for the SSE in such a situation. Sorry for exceeding my time limit, but these are very emotive issues, and one tends to get carried away on the manner in which this is proceeding.
Thank you, Tarunji, for this wonderful session. Now I request Chairman Shri P.C. Joshi ji to give the closing remarks before we move on to the question and answer section. Sir, P.C. Joshi ji, sir, unmute the mics.
Don't worry, I am vigilant.
Yeah.
I am vigilant about my right at least.
Sorry, thank you.
See, Mr. Gulati has rightly pointed out what deficiencies the GST has. But let me point out, I supplement to what Mr. Gulati has said, and few of the points which I would like to supplement, and that is one thing. Now, when you submit the return, under section 16(1), you can adjust the input tax against the output tax. And therefore, according to me, section 17(5) should not have been there at all. If the true principle of the regime, or what you call the GST in proper sphere, is to be attained, then I think this 17(5) should have been dropped. Now, see, in the case of the, can you read this audit? As he rightly pointed out in the audit, the explanation, if you read explanation, it gives you long rope to the department, because the requisition will continue, and then one doesn't know when it will end. And that's how the power has been given, which normally should not have come. Now, another aspect which I would like to say is about summons. Now, summons and issuing, giving statement in search and seizure, etc. And he says that the presence of tax professional is only a safeguard. According to me, we should not remain present. Why? Because if any statement is extracted, then later on, immediately, we can advise the SSC, if we are not present, that the such and such statement was extracted because of threat of arrest or because threat of prosecution, etc. And we can retract the statement at the earliest moment. The very next day we can retract if we are not present. And therefore, as a cautionary measure, I would say that we should avoid remaining present in such type of cases. That takes me to one more point, and that is compare provisions of section 73 and 74. Now 73, 74, if you see, kindly read 74:11. 74:11 gives you very perplexing position. Kindly see 74:11. Just see, where any person served with an order issued under so and so, along with interest payable so and so, equivalent to 50% of such, when within 30 days of the communication of the order, all proceeding in respect of the said notice shall be deemed to be concluded. Now, similar provision is not found in 73. If you see 73:11, nothing of conclusion of the proceeding. So this is again a hanging sword. Again, see 73:11. 73:11 doesn't say anything about it, that the matter will be concluded. So the hanging sword will go on. Now next is what I want to supplement is regarding the appeal proceedings. Now appeal proceedings kindly see 107.11. 107.11 the appellate authority, how he is to pass an order after inquiry, etc. It's okay. But he has to pass an order confirming, modifying, or annulling the decision. What is this? Confirming, modifying, or annulling the decision. It doesn't give power of enhancing the tax. Enhancing the tax is not a power in appeal, and therefore they can't levy tax in appeal as a power of enhancement. Because if you see the power of proviso, provided that an order enhancing any fee or pay penalty or fine, etc., in lieu of confiscation, etc. It doesn't speak of an order enhancing the tax. This is an aspect which we all should bear in mind while considering the provisions. Friends, I must compliment Mr. Gulati. He has labored a lot. He has given us enough material for facing the cases of the SSCs. Thank you very much, Mr. Gulati, and thank you very much for all organizers for giving me an opportunity to read the sections and compare the sections and apply my mind. Thank you.
Thank you, Chairman, sir. Now I'll proceed with some of the questions, Tarunji. Sir, is there a provision under the GST law to pay tax under protest if the SSC is of the belief that the transaction in dispute is not exigible to tax? If no such provision is there in law, how does one pay tax under protest?
There is no such provision. There is no specific provision for paying tax to the best of my knowledge. And I think the whole issue of protest.
Sir, you are not audible, sir.
I'm saying that there is no specific provision for paying tax under protest. Under these 1944 excise rules, there used to be a specific provision. After that, that provision was not. Customs also there was a provision for paying tax under protest. And one of the implications of paying tax under protest used to be that in the refund provision, the limitation for filing refunds did not apply in such a situation. 1 year was given for filing refund applications. That did not apply. There is no other implication of paying tax under protest. Here, as far as I know, as far as I have seen, there is no such provision. If tax has to be paid under protest as a matter of giving a message to the authority that this should not be treated as an admission of liability, if that be the reason for paying under protest, then I think by writing a letter to the department, your protest can be recorded. Even under the erstwhile law, in fact, I'd argued one case, I think in the Madras High Court, I think it was Madras High Court, where the court had said that correspondence can be taken into account to record the protest. So even in the absence of a statutory provision, that can be done.
Okay. Sir, the circular 122/41 2019 issued by CBIC mandates quoting of DIN and any communication issued by the tax department by the CBIC officer. Is quoting of DIN mandatory in case of any documentation issued by the state government, since not many states have issued such circulars by the state departments?
I think for me, for my part, I think it's a very important safeguard. Why is all this being done? We have seen that in many cases, documents which are issued by the department are
can also be, I'm not saying that it's done oftentimes, but can also be backdated, or documents can be interpolated or extrapolated also. By putting in a safeguard of quoting a DIN, I think you are there is some level of transparency to say that the documents are being issued and uploaded contemporaneously, and that is the reason why you have uploading of documents also. If state governments have not done it, and if circulars have not been issued, in an appropriate case where there is doubt about the existence of a document or a backdating or an antedating of a document, I think the matters should be taken to court.
Sir, under section 73(11), it provides that notwithstanding anything contained in subsection 6 or subsection 8, penalty under subsection 9 shall be payable where any amount of self-assessed tax or any amount collected as tax has not been paid within 30 days from the due date of payment of such tax. So whether penalty would be payable on the tax payable determined without offset of ITC or after offsetting ITC.
The ITC again, offset of ITC means what? That you have available ITC,
yes,
and you are paying the tax by debiting your credit ledger. That's what you mean, right? According to me, no. Until you debit your credit ledger, that tax remains still outstanding. If you read this provision, it seems as if it is suggesting that it is the gross outstanding. So even if you have a credit balance in your credit ledger, unless you debit it, I don't think it amounts to a payment of tax.
Okay. Sir, next question. Sir, it is observed that many state enforcement departments are issuing notices under section 122 of the CGST Act and SGST Act demanding tax, interest and penalty, and also concluding orders under section 122. Sir. Are such notices and orders valid under the Act?
One will have to see. It's a very sweeping question, and I think we cannot really say what kind of notices are being issued. One thing is very clear, that something which is very different from the income tax provisions, that here penalty proceedings are not separate proceedings in the CGST and the assessment proceedings. I don't know what the question was about jurisdiction of whether the state officers can issue it or not, or whether it is the fact that there is no assessment proceedings but penalty proceedings are being taken. So I don't know what the question is, but here penalty proceedings are not separate. First of all, they can arise as a consequence of assessment, or they can arise separately depending on the circumstance, because 122 contains 21 circumstances in which penalty is levied. So depending on what it is, like if it's just a failure to issue an invoice or whatever, but I would think that that adjudication itself has to happen.
But they are issuing orders under 122, sir. Concluding an order under 122.
You can't do it.
That's what many state.
You can't do it because, see, if penalty is dependent on assessment.
Yes.
One thing to say that penalty proceedings are not separate from assessment proceedings, but if it is dependent on assessment, then you can't have a penalty order preceding the assessment. In fact, I think Kerala, in Kerala VAT, there are at least 5 or 6 judgments of the division bench of the Kerala High Court and single judges of the Kerala High Court, where under the relevant provision of the Kerala Act, I think it was 54(2) or something like that, they were issuing penalty orders even by estimating the tax without taking the assessment.
It can't be done.
High Court has struck down those orders as being without jurisdiction, saying that in the absence of a determination of tax in the assessment proceedings, by estimating tax, you can't levy penalty. At least
in one of the matter, the provisional attachment was made, and the court has to crash down that.
In fact, Joshiji, in CGST, now that you mentioned provisional attachment,
yeah,
very dangerous provision of provisional attachment has been incorporated here, which includes provisional attachment of bank accounts.
Yeah.
Provisional attachment of bank accounts without affording any opportunity of hearing, and that can continue for 1 year. So I think, amongst all the provisions that we are seeing in CGST Act, some provisions are really draconian. And
Absolutely.
One has to be very careful. One has to be very careful, because if you attach the bank account and you have not been given a hearing, there is no finality to a proceeding. Summary assessment, provisional attachment, all of these are all, taking away the rights of the SSCs.
That's it. And only way you have to go to High Court, that's all.
Good for us, but not good for the SSCs.
There's a question from CA Neeraj Agarwal. Sir, in case of summary assessment, only demand is uploaded on the portal and no speaking order is issued or served on the SSC. Can still that order be held as valid? Do we have any other option other than to go for appeal? There are situations where even the date of appeal along with delay has expired. How do we deal with such a situation?
Now, two parts, I think, to this question. Joshiji, please add to whatever I'm saying. Two parts, I think, then which one, if it is a non-speaking, just a demand, clearly, I think the writ option is available. Because I don't think our law and our jurisprudence contemplates demands without speaking, without reasons. Reasons are the lifeblood of our jurisprudence. Time and again, the Supreme Court has said that without reasons, now, in fact, the Supreme Court, after Mukherjee's case, has said that even in administrative decisions, some reasons are important. So to contemplate a quasi-judicial authority passing a demand without any reasons is completely, I think it's unthinkable. So
I think it is AK Kripak case, if I correctly remember, it was AK Kripak case, Supreme Court.
I think that is rate option is absolutely available and should be exercised, even if the period. Second part of the question is that what happens if an order is uploaded? It amounts to a deemed service, by the way. If it amounts to a deemed service, sometimes we will be in big trouble on limitation, because power of condemnation is also limited under the Act. Appellate authorities don't have unlimited powers of condemnation. And under the principles of laid down by the Supreme Court in Congo, India, and several other judgments, that you can't apply the principles of Section 5 of the limitation. Whatever is and even a writ court actually cannot extend that limit. So one will have to be very careful, but about these orders will get uploaded on the portal, because it amounts to a deemed service. Can be challenged, but the way this will evolve is uncertain today.
Thank you, sir.
Certainly can be challenged.
Okay. There's a question from Shri Mukul Gupta ji. Please let us know the jurisdiction issue for investigation teams within CGST or STST in an investigation of chain of transactions for claim of input tax credit.
I think jurisdiction is, I understand it. I don't operate.
Should be proper officer.
Proper officer, and the way the jurisdiction has been bifurcated is SSC wise.
Yeah.
Not as if subject matter wise the jurisdiction has been changed. Although in the appellate provisions, if you see, there is subject matter jurisdiction for the national/regional benches. And if one of the questions is place of supply, then it goes to the national regional benches. If there is no place of supply issue concerned, then it goes to the area of the state benches.
State tribunal.
Yes, state tribunal. Now, for original jurisdiction for investigation, I think it's SSC based jurisdiction which is notified, and it will go according to that. And also for input tax credit is my understanding of this. And what I think one needs to see is there used to be a circular to say that if jurisdiction has been invested with one authority, say central authority, I've used that circular in a petition in Hyderabad, where then the state authorities will have no jurisdiction. It's a mutually exclusive jurisdiction. And jurisdiction is invested by issuing notifications SSC wise.
Sir, there's a question from Shri Rajiv Ranjan Mittal. Can show cause be issued without giving proper notice to the SSC/non-SSC, any ruling of the High Court or Supreme Court?
Yes, there are several rulings. Not, of course, I don't have them handy here separately. I don't remember them offhand, but even in pre-consultation, Delhi High Court has said that it is mandatory and a show cause notice issued without pre-consultation. But there has to be a provision for pre-consultation. Second line of judgments, of course, is that if a judgment is vague and specific allegations are not made or evidence is not considered, the show cause notice itself can be challenged and quashed. I think one, of course, that was a judgment for larger period of limitation, but it's a good judgment for this proposition was HMM Limited. I think it's reported in 76 ELT, 237 or something like that. Page number, wherever it's 76 ELT, HMM Limited, the case. That's specific allegations. Mere repetition of the language of the statute is not enough. You have to have specific allegations square in the show cause notice. And of course, Siemens case of the Supreme Court, Siemens Limited. I don't have the citation again here right now, but Siemens Limited, Supreme Court has said that if a show cause notice has been issued with premeditation, then it can be challenged and it will be quashed.
I'll take one last question, sir. Is there any provision to rectify the monthly GST returns? Please guide. Monthly.
Well, this is what happened in Bharti Airtel. So there are provisions which were created by issuing circulars to say that you can rectify, but you will rectify only in the month in which you notice the error. That created a problem because in that case the SSC had loads of excess credit, and he had already paid cash in the earlier months by using the cash ledger because he hadn't recorded the credit properly. So he wanted to record the credit in those earlier months properly, and which the circular did not allow. The Delhi High Court has quashed that circular. Of course, SLP has been filed by the department in the Supreme Court, which has still not come up for hearing. But provisions are there for rectification. But how you will carry out that rectification is subject to these circulars and what the courts are holding.
With this detailed deliberation and insights provided by Tarun sir and also inputs given by Chairman Shri PC Joshi sir, I will now hand over the proceedings to Shri Varinder Sharma, Advocate G, to give a vote of thanks. Over to you, sir.
I am audible.
Sir,
yes, Varinder ji, go ahead.
Please go ahead.
Good evening. So,
Varinder sir, voice is breaking.
Breaking.
We are having Louisiana problem. Internet problem in Louisiana.
Good evening, ladies and gentlemen. Internet today, first of all, I remember honor, Bharat Ratna. It gives me an immense pleasure to reconnect all you through this web seminar hosted by the AIFTP North-Zone. I, on behalf of the AIFTP North-Zone and the entire team, even a special guest in the audience, and on my own behalf, extend a very hearty vote of thanks to all speakers for gracing your important work and sharing with us your findings and opinion today all about SCR, adjudication, assessment, appeal under GST. Friends, goods and service tax, GST, India's biggest indirect reform, which was implemented from 1st July 2017. It was founded on the notion of one nation, one tax. We are about to enter the 4th year of successful implementation of the GST after braving some serious challenges. Once a great man whispered, feeling thankfulness and not expressing it, it's like wrapping a present and not giving it. Today, I take this opportunity to put all my gratitude into the words, respected our Bhisham Pidama, our chairman, Mr. P.C. Joshi, father figure to me and our association, chairman of this session, our most valued invited guests, ladies and gentlemen. It's my privilege to have been asked to propose a vote of thanks. We are really enlightened with your knowledge and presence. Further, our speaker, we also would like to acknowledge our gratitude to Mr. Tarun Gulati, Senior Advocate, Delhi High Court, for expressing his views and experience before all of us. We all are inspired by your vast knowledge, sir, about goods and service tax. और जो आपने बोला कि जब सम्मन्स आते हैं तो जैसे अथॉरिटीज पकड़ती हैं, जो अथॉरिटीज डरावा देती हैं, उसे हमें कैसे पेश करना चाहिए, क्योंकि ये जो सम्मन्स में हम लोग स्टेटमेंट देते हैं या हम साथ जाते हैं एसएससी के बिहाफ पे, तो वो जो थ्रेट देते हैं उसके बारे में आपने बहुत इनलाइटन किया. और स्पेशली थैंक्स टू मॉडरेटर ऑफ दिस सेशन, आवर यंगर ब्रदर सदेश्वर जी. Finally, again, I want to thank respected chairman sahab, Shri P.C. Joshi ji, for participating in this seminar. Ladies and gentlemen, an event like this cannot happen overnight. The wheels start rolling weeks ago. It requires planning and a bird's eye for details. We have been fortunate enough to be backed by a team of very motivated and dedicated people of the AIFTP, Norjon, who know their jobs very well and are very result-oriented. Thank you very much, friends. Thank you very much. Over to Preet ji. Thank you.
Thank you, Varinder ji. Friends, a fulfilling second technical session, as well as the first day of VNTC 2020 comes to an end. It is said that knowledge is the treasure of wise men. Hope that the first day of this conference has enriched each one of us and made us wiser. Please join us tomorrow at 10:30 a.m. for the second day of VNTC 2020, which starts with a technical session on income tax, where Mr. Ajay Vora, Senior Advocate, will be the keynote speaker. Thank you.
Thank you, Puneet.
Thank you.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, Preet. Great day.
Thank you.
Same to you, sir. Same to you, sir.